Good morning. Thank you all for being here. My name is Erica Jansen. I am Editor-in-Chief of the Southwestern Law Review, and we welcome you to today's event, our spring symposium event, Widening the Lens of Justice, Unmasking the Layers of Racial and Social Inequality. This event truly began as a collaboration in the summer between the Black Law Students Association and the Law Review. And for this event, we worked alongside co-presidents Josie Deese and Sydney Woods, and we sought to use this law review platform, this event, and the issue that is to come in the fall in order to engage those that are in or adjacent to the legal community, scholars, activists, practitioners, public servants who are grappling with these issues of racial and social injustice in their respective fields that, of course, include criminal law and policing, but extend beyond that to environmental law, economics, voting rights, or the rights that underline our democracy. Along with Josie Deese and Sydney Woods, who did not hesitate to jump on board and help us craft the symposium, we have quite a few people that we have to extend our gratitude towards who helped make this event possible. First and foremost, we must give our thanks to Professor Danielle Hart, who brought us this idea, advised us every step of the way, and helped us put together the building blocks that made up today's event. Additionally, Professor Hart helped us wrangle a team, a dream team, if you will, of faculty members. And with their help, we were able to curate these panels, obtain speakers, and also solicit authors for the upcoming issue of the review. And these professors are Professors Ronald Aronofsky, Rachel Van Landingham, Isabel Gunning, Gowri Ramachandran, and John Heilman. As well, we are so grateful for all the speakers who are joining us today. We have an incredible slate of speakers, and I am thrilled to be in this space with them. I know that we wish we could have hosted you in person, but we're excited to hear from you and to learn from you. Of course, we want to thank Dean Susan Prager and Vice Deans Anahit Garakanian and Dove Weissman for their continuing support of the Law Review. I also have to give thanks, last but certainly not least, to what I like to call the Wizards of Oz, the individuals behind the curtain who have made the magic happen. And that is Institutional Advancement, COMARC, Dean Robert Mena, and of course, our very own Special Projects Editor, Abraham Brand. I'm about to pass this off to our Managing Editor, Alejandro Rosa. But before I do, I have one last pitch. As you will notice, today's event is a free virtual event. And so with whatever you could afford, or perhaps what you were going to use to put towards a ticket, we ask that you consider donating it to our Black Lawyers Matter Scholarship. I believe that we're going to put the link to that in the chat. There we go. This scholarship provides funding to Black law students who, despite the many adversities, are integral parts of our legal profession and the Southwestern community. Without further ado, let's begin this program. I'm going to pass this over to Alejandro Rosa. Thank you.
Thank you, Erica. Good morning. My name is Alejandro Rosa, and I am the Managing Editor of the Southwestern Law Review. I have the distinct honor and privilege of introducing our opening speaker, Congressman Adam Schiff. Congressman Schiff represents California's 28th Congressional District, and he is the chairman of the House Permanent Select Committee of Intelligence. Congressman Schiff is a graduate of Stanford University and Harvard Law School. After law school, he clerked for Judge William Matthew Byrne Jr. of the United States District Court for the Central District of California. He subsequently served as an assistant U.S. attorney in Los Angeles, where he gained recognition for his successful prosecution of Richard Miller, the first FBI agent indicted and convicted of espionage for providing classified information to the Soviet Union. In 1996, Congressman Schiff was elected to the California State Senate, and in 2000, he was elected to the United States House of Representatives. Over the course of his tenure in Congress, Representative Schiff has championed progressive causes like expanding access to healthcare, protecting the environment, and protecting our democracy and the rule of law. He has been a strong advocate of H.R. 1, the For the People Act, which would expand the right to vote, re-enfranchise millions of voters who have prior convictions, strengthen our election system, increase government transparency, and fortify ethics rules and enforcement. He is the author of the Protect Our Democracy Act to prevent future presidential abuse, restore our systems of checks and balances, strengthen accountability and transparency, and protect our elections. Congressman Schiff has also led the effort to preserve and protect the Rim of the Valley corridor by adding almost 200,000 acres to the Santa Monica Mountains National Recreation Area to protect natural resources and habitats around Los Angeles. Of particular importance to the Southwestern community, Congressman Schiff has been a staunch supporter of the Armenian diaspora. In 2019, he successfully led the effort in Congress to officially recognize the Armenian genocide. Today, he is going to address the need to eliminate systemic racism and inequality in our healthcare system by treating equitable care as a civil rights issue. I am particularly honored to introduce Congressman Schiff because I used to work for him. He took a chance on me after I graduated college and gave me an opportunity. And when I was considering law school, he encouraged me to apply. Congressman Schiff has been a role model and a mentor, and I could not be more excited for him to be with us today. Congressman Schiff, thank you so much for joining us.
Well, thank you so much. Good morning, everyone. I'm so grateful for the invitation to speak today. And thank you so much, Alejandro, for that wonderful introduction. It was a privilege to work with you in our office. You were a fabulous member of the staff, and I'm very excited to see your legal practice begin. As I was joking with Alejandro before we got started, we have long had a Hotel California policy in my office. You can check out, but you can never leave. Glad that you continue to be a member of our family. Thanks so much again for inviting me. There's a lot that we could talk about today. We're in the first 100 days of a Biden administration. The president is already charting a new course on issues like economic justice, climate change. You may have listened to his foreign policy address the other day, and much more. And in just a few days, the second impeachment trial of Donald Trump will commence in the Senate. We're in the midst of the worst pandemic in a century, which is hitting California and Los Angeles particularly hard. But as I thought about the subject of today's symposium, Widening the Lens of Justice, I knew that I wanted to focus on an issue that I've been working on over the past year, and that is improving equality in healthcare. It's been a year since the first days of COVID-19 in the United States. The virus has proved to be a merciless and a devastating foe. We've lost more than 450,000 Americans. Well over 25 million have been infected, and of those, millions have been severely sickened. We can see some light at the end of the tunnel as over 1 million Americans are vaccinated now each day, but it will be many more weeks of death and suffering before we come out of this on the other side. This virus has struck every community in our nation, but the reality is that it has not struck us all equally. Communities of color, particularly Black and Latino communities, are experiencing mortality rates between 2 and 3 times higher than white Americans infected with the virus. Hospitalization rates are even higher, between 3 and 4 times higher. And even now, as we undertake the mass vaccination campaign that can finally end this pandemic, vaccination rates for people of color are often a fraction of those for white Americans. All of this is horrifying, but none of it is surprising, because while the virus itself does not discriminate, our system certainly does. The virus has exposed and exacerbated the shortcomings in our healthcare system in a dramatic and deadly fashion. Dr. Martin Luther King Jr. once said that of all the forms of inequality, injustice in healthcare is the most shocking and inhuman because it often results in physical death. More than 50 years after he spoke those words, discrimination remains a deadly reality for millions of Americans. Inequality in healthcare outcomes across racial, ethnic, and other lines has persisted long before this virus. It is driven by a lack of access to affordable and quality care, higher rates of chronic diseases like diabetes or heart disease, and differences in nutrition. It rears its ugly head in many ways. when hospitals in some areas get higher funding, when newer equipment is used in some communities but not in others, when physicians and other healthcare providers are willing to work in certain hospitals but not in others and not in certain neighborhoods. The result is that vulnerable groups, and particularly communities of color, like Black Americans and Latinos, experience higher rates of chronic disease, higher rates of transmissible diseases like HIV or AIDS, and a lower life expectancy. These structural inequities are tragic and unacceptable on their own, but it is far worse than just that. Study after study has shown that health outcomes for certain populations are linked to unconscious biases held by healthcare providers who care for them. To give you just a few examples, a recent study found that Black newborns died at nearly 3 times higher rate when cared for by a white doctor compared to when cared by a Black doctor. The maternal mortality rate for Black mothers is up to 5 times higher than for white mothers. And this is a trend that persists even after adjusting for income and education. Black patients are less likely to receive pain treatment in a hospital. A survey of medical students conducted in 2016 found that fully half of first or second year students harbored false or racist beliefs, such as the idea that Black patients had thicker skin or higher pain tolerance. And sometimes the bias presents itself even in medical devices. One of the most important and basic tools in the fight against COVID-19 has been the use of oximeters, small devices that can measure the oxygenation of a patient's blood at home or in a medical setting and determine if that patient needs interventions such as oxygen or even intubation. Yet we now know that patients with darker skin may receive inaccurate oximeter readings, giving the false impression that they don't need additional treatment. As we grapple with racial bias in criminal justice, in our schools, in housing, the healthcare field is equally in need of drastic and systemic change. This summer, the nation experienced the most sustained civil rights protests in decades in the form of the Black Lives Matter protests. As I spoke to community leaders and health experts, it became clear to me that the area of health equity was one that had not received the attention that it deserved. It's an idea whose time has come, healthcare as a civil right. As we explored policy options, we found that current civil rights law lacks teeth when it comes to inequitable healthcare and health outcomes. Discrimination in healthcare is difficult to prove because doctors and nurses and other professionals make complicated medical judgments based on many factors, and teasing out whether unlawful bias played into any single decision is difficult, even in the best of circumstances. Over the course of several months, my staff and I worked with healthcare experts, civil rights advocates, and other stakeholders to draft legislation to fill the gap. The Equal Healthcare for All Act was the result. We introduced this bill in September and are working on further improvements as we prepare to reintroduce it this session. This bill takes an ambitious civil rights approach to equity in healthcare, placing a new and explicit duty on providers to eliminate bias throughout the healthcare system. The legislation would, for the first time, create a clear and enforceable standard for equality in healthcare. It would enhance and expand the mission of the Office of Civil Rights at the Department of Health and Human Services and give it the tools and resources it needs to root out bias. It would establish a new regulatory process to receive and investigate complaints about inequitable care on the basis of race, ethnicity, gender identity, sexual orientation, and create a private right of action for someone who has suffered an injury to seek redress in the courts. It would also explicitly authorize the Department of Justice to investigate healthcare providers with a pattern of discrimination in the healthcare provided to patients and to force corrective action. And it would put serious federal dollars behind these systemic changes by providing new assistance and incentives for healthcare providers to meet the duty of equal care for all. The bill creates a new grant program with a preference for hospitals that serve disadvantaged populations to pay for training and reforms to promote equal care. And it would include equal healthcare as a metric that can result in increased incentive payments to hospitals. With the new Biden administration, I think we have a real chance to make progress. Already, President Biden has signaled he will form a COVID-19 health equity task force focused on allocating resources fairly, collecting data to ensure equitable treatment, and helping communities of color get through the pandemic. In drafting this legislation, one particular story has stayed with me. It was relayed by an emergency room physician about treating a Black patient who had been terribly injured in a car accident. As she came to the waiting room to update his terrified family, the physician found his loved ones telling her not about this man's medical history, but that he was well educated, that never mind his bloody and torn clothes, he had a good job, that he had a family. In other words, this man's family felt they needed to communicate to this doctor that his life was a life worth saving. Every life is worth saving. Doctors and nurses work valiantly every hour of the day to save lives, as we have seen throughout the coronavirus pandemic. But we must take pains to ensure that the care provided to patients is never influenced by bias, whether intentional or subconscious. America is still falling short of that standard, and until we meet it, we must work every day to make equal healthcare a reality. I thank you for your time this morning and look forward to our discussion.
Thank you, Congressman Schiff. Folks, Congressman Schiff has agreed to take questions. So if you would like to ask Congressman Schiff a question, please use the participant function and raise your hand. Congressman Schiff, I was wondering, it seems like there are a lot of priorities that we have right now in terms of things that we need to address. We have COVID relief, we have healthcare, legislation on our democracy and our elections. And we have quite of a slight minority in the Senate. And I was wondering how you thought, just your thoughts on how we move forward with, kind of a slight minority in the Senate.
Well, I thank you for the question. And you're absolutely right. We have the thinnest margins that we have seen in a very long time, maybe the thinnest margins ever, with an equally divided Senate where the vice president will cast the deciding vote when that's necessary. And in the House, a mere handful of seats that divide the parties. Right now, as you may be following, the president and the Congress are very much focused on a relief package to get help out to millions of families whose unemployment compensation may run out, who may get evicted otherwise, who need help keeping a roof over their heads and food on the table. And there's a real desire in the new administration and many of us in Congress to see, is there a way we can come together to meet this crisis? Frankly, I'm skeptical that my GOP colleagues will be prepared to devote the kind of resources to providing help to families that they really need right now. We will find out soon enough, and we are proceeding along two tracks. One, where if bipartisan agreement is possible, we can use that route, and another using a process called reconciliation, where we can get bills passed in the Senate with only a 50% vote or 50+1, rather than the 60% required to overcome a filibuster. And so that is a real venue that we may have to use, a vehicle that we may have to use. I suspect it will be necessary because what I've seen so far from the GOP is far too small and inadequate. And the big risk here is that we do too little, not that we do too much. Now, that process of reconciliation is a very complicated one that can only be used infrequently and for certain things with a budgetary impact. So for other major issues, it won't be available. And it will be enormously important to make the case publicly why we need to do big things on the economy to make sure it works for everyone, on the environment to save the planet, in healthcare to make sure that there's equal access to healthcare. And by making the public case, put pressure on the Senate not to be the legislative graveyard that it has been for the last several years under Mitch McConnell.
Thank you very much, Congressman. We have a question from Andy De La Cruz.
Yes, thank you for coming and speaking with us, Congressman. My question was I was kind of wondering, what do you say to people who believe we must address societal racism, societal bias before addressing issues in healthcare equity?
Well, I think that we're going to have to do both. And you're absolutely right. The societal issue is paramount. It's going to be hard to make progress on racism in criminal justice or healthcare, in environmental justice, if we don't confront the pervasive racism within the country. And if we needed any more graphic example, and we shouldn't have, the image of people marauding through the Capitol with Confederate flags, with Auschwitz T-shirts and the like, once again underscored this persistent strain of racism and bigotry that has sadly run through the country since its founding, and of course well before its founding. And we're going to have to come to grips with it. I realize that, though, that is a very long-term project. It is really the project of this country. When we think about making America a more perfect union, so much of that means addressing these persistent issues around race. And at the same time, though, we need to press forward with individual remedies, like the George Floyd Justice and Policing Act, like bringing about equity in healthcare, and in so many other ways. So I think we have to really try to do both. And I recognize that, like so much in this country, it's going to be one step forward and two steps back from time to time. But I do try to bear in mind the long trend, which I hope and pray and believe is positive. I continue to cling to the vision of Martin Luther King that the moral arc of the universe may be long, but it bends towards justice. But I am very mindful that it doesn't bend of its own will. It bends because millions and millions of good people are pulling and straining and pushing to make sure that it bends towards justice.
Thank you, Congressman. We have a question from Professor Daniel Hart.
Thank you so much, Congressman Schiff, for speaking and coming and talking to us. I had a question specifically about the legislation that you're planning to reintroduce into this session, and specifically about the private cause of action. And I guess my question is essentially, have you thought about, and the people that you're working with, have you thought about how that private right of action is actually going to play out, assuming that the law gets enacted, which I'm hoping it will, in light of all of the mandatory arbitration and class action waiver clauses and all of the contracts that people enter into with their doctors, right? You have to sign all that stuff before you get in there, with insurance companies. They're everywhere. And we've already seen, given the Supreme Court's jurisprudence on arbitration, that all kinds of our statutory rights are already being shunted off into private arbitration, no class actions, et cetera. And so I guess I'm wondering, have you thought about what you can do or what might be possible so that the private right of action you're considering with the legislation that you're going to be proposing isn't going to have the same problems? So I guess the question is, have you thought about anything that you can do about arbitration and the class action waivers that the Supreme Court just seems to uphold constantly?
No, it's a very good and important question because, as you point out, there are those aspects of contracts of adhesion all throughout our society now, and that's a very big and separate problem, which we have been trying to address, and I've been supporting legislation to do away with a lot of that, a lot of those mandatory arbitration clauses, which heavily prejudice the system of justice and restitution against victims, whether they're victims of product problems or consumer safety issues, or problems in healthcare or in housing. We have modeled this approach after the civil rights legislation on housing to provide a similar process and cause of action. But I will take that feedback with me, because we are looking at what changes we want to make this session from the bill as we introduced it last session. And frankly, what we'll have to weigh in that is it is already going to be a very heavy lift to get this bill passed. You can imagine the reaction that we're likely to get from a lot of healthcare providers and hospitals and the like. And that's a big, difficult industry to move. Are we prepared to take on the additional fight with the precedent we would be setting of attacking those provisions of binding arbitration at the same time? We may need to, or we may decide that we need to attack those problems separately. But I appreciate you raising it. I will be raising this anew with the team that's working on this. We've got a great group of stakeholders that are examining these issues. But you're absolutely right. We want to make sure that this is an effective cause of action. It's my hope, frankly, that in most cases, the private action won't be necessary, that the Department of Health and Human Services and its Office of Civil Rights will undertake these cases, because even in the absence of the provisions you mentioned, for an individual to be able to bring a case like this and make the showing necessary is a very high hurdle.
Thank you, Congressman. We have time for one more question. Ms. Thelma Mbuz Daniel.
Daniel, thank you so much. Hello, Congressman, and thank you so much for being here today. For our DACA students who don't have access to federal loans, my question as we talk about equity is, what is the administration's plan? Is it to submit a new DACA bill or to strengthen the existing one with executive action?
Well, I think it's both. The administration is taking quick action through executive orders to make sure that DACA recipients are protected. But the administration and the Congress recognize that that's not a perfect solution by any means, because as we have seen from this administration, well, from the last administration to the one before it, you could turn night and day when it's a protection only afforded by the executive decision of the president, and that could change with the next administration. So I think what dreamers need is certainty in their lives, and that will only really be accomplished by legislation. So I'm confident the administration will continue to do everything it can right now to protect DACA recipients, but Congress is going to need to address this also. And you know, given where we are now with a majority in both houses, I'm more optimistic than I have been in a long time that we'll be able to do so.
Thank you, Congressman Schiff. Thank you so much for taking the time to join us today. I know that we have all really enjoyed your talk, and thank you as well for taking time to answer some of our questions. We wish you all the best in Washington, D.C.
Thanks so much. Take care, everyone, and stay healthy.
Take care.
Alrighty. Good morning, everyone. My name is Abraham Brand, and I'm the Special Projects Editor for the Southwestern Law Review. I will be helping with facilitating some of these transitions between panels, but I will not be speaking much because I definitely want to get into the reason why you're here, the panelists. To start things off, we're getting started with our environmental justice panel, viewing public policy reform through the lens of environmental justice. And for this, I welcome our moderator, Professor Ronald Aronofsky.
Well, thank you, Ave, and welcome everybody to the first panel of the day, the Environmental Justice Panel. The issue of systemic inequality in our society manifests itself in a variety of ways, and our first panel examines systemic inequality through the lens of environmental justice. The field of environmental justice addresses the consequence of distributional inequities by which historically underrepresented communities bear a disproportionate share of the air, water, and soil pollution generated by our society. And we're learning that these communities are also disproportionately bearing the impact of pollution on the global climate as well. The consequences of these distributional inequities are felt at every level of society, whether local, regional, national, or international. And we have an outstanding panel of speakers today who will be addressing a variety of environmental justice issues with us. Our first scheduled speaker, Yana Garcia from CALEPA, unfortunately is unable to join us today because of a last-minute work emergency that arose, and she expresses her regrets and apologies for not being able to join us today. But we're fortunate, however, that Dr. Vanessa Galaviz from the Cal EPA, has agreed to step in at the last minute and take her place. Dr. Galaviz will be followed by Professor Carmen Gonzalez of Loyola University Chicago School of Law, Natalia Ospina from the Natural Resources Defense Council, and Professor Steph Tai of the University of Wisconsin School of Law. I'll be sharing more information about each of our speakers when it's their turn to speak. After we hear from our speakers, we'll have time for questions. Dr. Galaviz may not be able to stay with us for the question period, but she's graciously agreed to answer questions sent to her by email. We encourage you to ask to think of questions and ask them during the question period, as we did with Congressman Schiff. We'll be fielding questions through the raise hand feature. We won't be using the chat to field questions, but we'll be using the raise hand feature for our panelists. So our first speaker is Dr. Vanessa Galaviz. She's an environmental justice public health doctor with the Environmental Justice Program of the Office of the Secretary for Environmental Justice, Tribal Affairs, and Border Relations of the California Environmental Protection Agency. Dr. Galaviz's work focuses on addressing environmental injustices faced by underserved communities. She works to reduce exposures in predominantly low-income and minority populations with multiple sources of pollution who also face occupational, socioeconomic, and biological stressors. She's interested in exploring how these stressors can increase vulnerability to adverse health effects on exposure to, to pollution to create disproportionate health impacts. Dr. Galaviz has experience in multiple aspects of environmental health fields, including industrial hygiene and exposure assessment, air pollution, biomarkers of exposure and susceptibility, cumulative impacts, community-based participatory research, citizen science, and science policy work. She works in partnership with communities, government, and academics to achieve environmental justice for underserved communities. With that, Dr. Galaviz.
Hi, can you hear me? Can you hear me okay?
Yes.
Okay, awesome. Yes, sorry, you're stuck with the scientist. Yana had an emergency at the governor's office, so I'm glad to be able to speak with you all, and hopefully I can answer any questions, like I said, via email. Sorry, I have to jump off after this, but yeah, I don't know, do I have to show my slides, or do you have them, Abe? Did I send them?
I do have them. Would you like for us to share them for you?
Yes, that'd be great.
Okay.
Okay, awesome. Thank you, Abe. Okay. So on slide number 2, just kind of some questions just kind of think about during the presentation. Yeah. So just, big 3 broad questions to think about that I'm kind of going to cover in the presentation. So what is cumulative impacts, and how do we tie environmental justice with cumulative impacts, and how do we address cumulative impacts in environmental justice communities? So there's 4 main things I'm going to go over, and the first is just why cumulative impacts and risk, and then talking about exposure just to single chemicals, and then exposure to mixtures, and then what does kind of these mixtures mean for community scale assessments, and then what does cumulative impacts tell us about a racial divide? Okay, so first, next slide, please. Awesome. Okay. So why cumulative impacts? So when we think about chemical pollutants, there's different ways they could accumulate. So they could accumulate over time. For example, DDT, which was an insecticide that was used, it's very persistent in the environment. So it still exists in the environment today. And so you have this accumulation of over time of one chemical. And not only that, but it accumulates in the fatty tissues of our body. So it's also very persistent in our body. But also, chemicals can accumulate across different places. So you have lead, which is a great example. You have lead where you have accumulation in the paint from lead-based paint that was used, from gasoline when we had lead in gasoline, from drinking water, medicines, cosmetics, and jewelry. But then also it could accumulate via different routes. So a good example is particulate matter. And so with particulate matter, you have different sources. You have sources from automobiles, you have sources from industry, and you also have area sources like from agriculture. But then also you have pollutants that could accumulate in multiplicity and unevenly. So multiplicity just means that, you have kind of these interactions of chemicals that the magnitude of its effect can multiply. And then also unevenly. So a great example is particulate matter. You have two different motor vehicles, and they're both going to, spew out particulate matter in uneven concentrations. So having these kind of different ways that pollutants could accumulate creates a concern for cumulative impacts and risk. Next slide, please. So there's different meanings for cumulative. There's 3 different ways you could think about it. One is that chemicals could accumulate in our body or over time, like I had given that example about DDT. But then also chemicals could come from multiple sources, such as lead that I talked about. But then also you have this accumulation of community scale impacts where you have multiple effects arising from multiple sources. So the effects being both effects to people and to the environment. Next slide, please. So now exposure to single chemicals and mixtures. So here, yes, okay. So we have kind of this cumulative impact of a single chemical that you could think about versus mixtures. So with a single chemical, like I spoken about, you have this chemistry that happens in your body, and it kind of could lead to certain chemicals to stay in your body for a really long time, like lead. You have also other chemicals, like I said, that are very persistent in the environment, that are very toxic, even though they've been removed and haven't been used for a very long time, they're still in our environment. And so they still cause this public health concern. But then also you have this accumulation over time from chemicals that could cause cancer and also damage to the brain, such as pesticides. Next slide, please. And then now you have kind of, these chemical mixture types that go away from single chemicals. And there's 3 different ways you could think about it. So defined, where you have combinations that are created under specific conditions. So diesel exhaust is a perfect example. You have chemical mixtures that are similar. So these are chemicals that have similar properties. So they have basically similar mechanisms of action for health impact. So pesticides is a good example for that. And then you have mixtures that are coincidental. So these are things that happen by chance, and urban air pollution is something that happens by chance in a time or a place. And so, you have a mixture of coincidental where they're not comparable with properties. Sometimes they are, sometimes they're not. And they're not created under specific circumstances. So they're just by chance. Next slide, please. So we kind of spoken about ways to think about chemicals by themselves or in a mixture, but then you have this like combined way of thinking of like, well, you have effects that are long-term, that are short-term, that are from different sources, that have different mixture types. And so then you have to think about how can you really assess that, this cumulative impact of all those different factors. Next slide, please. So in 2003, the US EPA released this document for cumulative risk assessment. And so it's kind of going away from thinking of things as the singular chemical, the singular agent, or the single stressor, but thinking about how can we combine these things to look at holistically the impact of communities and of people. Next slide, please. So, it gives us this thought of like, okay, we need a tool that can go combine all this information, something that also, most importantly, has community stakeholder emphasis. So you want a tool where you have communities that could ground truth the information, because they're the ones living these experiences. They're the ones with the pollution in their backyard. So you can have all these, the state scientists putting together this data, but really working with community to figure out, well, what are we missing? What are some data gaps? But also needs to, incorporate non-chemical stressors. So what are the environmental conditions? What are the vulnerable populations? Are there pre-existing conditions that we need to account for? What about poverty? And so thinking about a tool that we could use led us to the next slide. So here in California, environmental justice, as I'm sure you guys are all aware of, is defined in statute. So what that means is each agency in California could kind of, takes that environmental justice definition and modifies it based off of what their purpose of that agency is. So for CALEPA, how we define it is identify and address any gaps in existing environmental programs, policies, or activities that may impede the achievement of environmental justice. So this led to a couple committees and working groups to define cumulative impacts in environmental justice. Next slide, please. And so what they found is there's the basis of what is the basis of environmental justice? So one is that there's multiple pollution sources that are disproportionately concentrated in low-income communities. Next slide, please. 5 minutes, okay. In that folks are, you have these socioeconomic stressors that are associated with increased sensitivity to pollution. Next slide, please. And then combining these two things, you have what's known as cumulative impacts. Next slide. So now we have 4 different terms that we're incorporating with cumulative impacts. We have exposures, environmental effects, sensitive populations, and socioeconomic factors. Next slide, please. Next. So exposures means, so these are defining the different terms. So exposures, you have direct contact, environmental effects, these are adverse conditions. Sensitive populations are people with biological traits or health status that may magnify the effect of exposure. Next, please. And then socioeconomic are things that result in vulnerability. Next slide, please. So that led to the development of CalEnviro Screen, which is a tool that's being used in to invest billions of dollars in communities, environmental justice communities. And what the tool brings together is 20 indicators. So we have 7 exposure indicators, 5 environmental effects, 3 sensitive populations, and 5 socioeconomic factors. And we're actually, this year, we're working on releasing version 4.0. Next slide, please. So these are the 20 different indicators that you guys can look at on your own. I know I only have a couple minutes, but it just shows you, like, for exposures, we have, for example, drinking water, pesticides, toxic releases from facilities, and so forth for the other factors. Next slide, please. So those all are combined into one score. So every census tract in California, there's about 8,000 census tracts. So every single census tract has a CalEnviro Screen score based off of those 20 indicators. So next slide, please. And so the census tracts with the highest score, which is indicated by red, those are census tracts with high pollution and high vulnerability. And as you can see, going down, the greener you are, the less pollution and less vulnerability you have. Next slide, please. So here is just a zoom in on one of the census tracts. So you could click on one of the census tracts and you can, it'll break down the score for you. So it tells you, this census tract is in the top 10 percentile. And then it tells you the pollution burden is 94 percentile, which is really high. And population characteristics is 81. And then every single indicator has its own percentile that you can look at. So there's a map for every single indicator. If you're only interested in looking at, say, PM 2.5 or pesticides, there's a map that you could go and just look at what those, the community's score is when it comes to pesticides. Next slide, please. So this is how CalEnviro Screen is being used. So like I mentioned, there's like billions of dollars that are being invested into these communities using CalEnviro Screen. So right now it's in statute where the top 25 or the top 25 census tracts, or the census tracts in the top 25 percentile, get investments as a result of SB 535 and AB 1515. And so that's where you have, where a ton of money goes into these communities. We also base a lot of regulatory and enforcement decisions on using CalEnviro Screen as well. Where do we prioritize our actions? It's also being used for other things like research initiatives. So right now, actually, Yana wanted me to bring this up. This is actually coming from the Department of Justice. We're working with them on this effort right now. And I don't know if you guys ever heard of SEPs, Supplemental Environmental Projects. So, you know, these are things, or this is money where you have, you know, there's been a fine, say, by an industry. And so they have an option to invest money in a community that's similar to the fine. And so right now we have about, you know, $3 million from one of these fines and they're planning on using this money in communities to put up air monitors and, you know, collect other environmental data that is of concern to the community. So this is basically free money to the community as a result of industry, you know, having a penalty. And so, you know, this is going to happen pretty soon, and it's pretty exciting. And I don't know if anyone's interested in working with us on this project, but it might be an opportunity if anyone is. Where we want to hire local folks in the area, you know, local students, local researchers, local even like law students that want to be part of this project. We're going to put this money into 3 different communities. And so hopefully, you know, while working with communities, while working with academics and government, we could help address these environmental issues in the community. Okay, that's all I have. But like I said, I apologize that I have to jump off, but I'm happy to answer any questions that you have via email. I'm actually working on this $3 million project right now. That's kind of an urgency. And then also we have a tribal emergency as well. We have a tribal nation we're working with that has a landfill nearby, and they're having a lot of health outcomes. And so we're doing a huge investigation of that right now. And so that's kind of the 2 things that are on my plate today, that reason why I can't stay on, so I apologize. But it was really nice to speak with you.
Well, thank you, Dr. Galaviz, and thank you so much for taking the time, especially with the short notice, to be able to join us today and provide us with so much useful and interesting information.
Of course.
Our next speaker is Professor Carmen Gonzalez from Loyola University Chicago School of Law. Professor Gonzalez is the Morris Liebman Professor of Law at Loyola Chicago. She writes in the areas of international environmental law, environmental justice, human rights in the environment, and food security. After graduating from Yale University and Harvard Law School, Professor Gonzalez clerked for Judge Thelton Henderson of the U.S. District Court for the Northern District of California and practiced law for Pillsbury, Madison, and Sutro, where she specialized in environmental litigation. She later served as an attorney with the Pacific Gas and Electric Company and as assistant regional counsel in the San Francisco office of the U.S. Environmental Protection Agency. Professor Gonzalez was a Fulbright Scholar in Argentina, a visiting scholar at the University of Cambridge in the United Kingdom, a visiting professor at the Hopkins Nanjing Center in Nanjing, China, and a U.S. Supreme Court Fellow. She's taught and or worked in environmental law projects in Europe, in Latin America, and in Asia. Professor Gonzalez is active in a variety of professional organizations. For example, she served as a member and vice chair of the International Subcommittee of the National Environmental Justice Advisory Council, which is an advisory board for US EPA on environmental justice issues. And she's represented non-governmental organizations in multilateral environmental treaty negotiations. With that, Professor Gonzalez.
There we go. Thank you so much for inviting me. I'm really delighted to be here with you today. As you can gather from that introduction, my presentation is going to focus on international environmental justice issues, specifically climate change, race, and migration. How are these 3 related? Let me try to share my screen, and hopefully this will work. So I want to begin with some numbers. Climate-fueled disasters are displacing record numbers of people all over the world. The International Organization for Migration predicts that climate change will displace between 25 million and 1 billion people by 2050. The precise number is impossible to quantify because climate change is simply one factor that influences the complex and multifaceted decision to migrate. We do not currently have a binding legal framework at the international level to address cross-border displacement caused by climate change. Persons who migrate across international borders to escape climate-related harms are essentially treated as undocumented immigrants. They face detention, deportation, and criminal prosecution. The climate crisis, though, is unfolding in the midst of a raging pandemic at a moment of growing economic inequality and rising racial tensions. Since 1980, income inequality has soared in all areas of the world, squeezing the middle class and enriching the top 1%. As the gap between the rich and the poor has increased, authoritarian leaders and nationalist social movements are increasingly directing public anger at immigrants and at racial, ethnic, and religious minorities. This is happening not just in the US, but also in the European Union, in Australia, in China, in India, in Brazil. The regulation of migration is among the most consistently racialized practices of states. For those of you who have studied immigration law, you know that there is a very long history of encouraging European migration into the Americas, South Africa, New Zealand, Australia, and an equally long history of restricting and controlling the movement of persons deemed non-white. From the Chinese Exclusion Act to immigration policies designed to favor Northern Europeans, US immigration policy, like that of many other states, is deeply racialized. Despite the significance of race in deciding who is allowed to cross national borders, much of the scholarship on climate displacement does not explicitly address the way race is embedded in the emerging legal frameworks for climate change induced migration. So I want to begin the discussion by making clear what many of you already know, that when we talk about climate change, we're not talking about a misfortune, we're talking about injustice. Climate change is caused by the greenhouse gas emissions of the world's most affluent populations. As you can see on this chart, the richest 10% of the world's population is responsible for approximately half of all greenhouse gas emissions. But that's not all. Because carbon emissions remain in the atmosphere for hundreds of years, it is important to consider not just current emissions, but also historic emissions from the Industrial Revolution to the present in order to apportion responsibility for climate change. When you look at the picture from a historical perspective, the world's most affluent countries, the United States, the European Union, Japan, Australia, New Zealand, are responsible for the vast majority of historic greenhouse gas emissions. Even though current emissions, China is now the primary emitter. Those most affected by climate change, i.e. the people at the bottom of this funnel, including the small island states in the Pacific, indigenous peoples in the Arctic, millions of poor and marginalized communities living in areas vulnerable to climate change. These are the people who contributed least to the problem, but are the ones who experience the greatest potential harm. These are the people who are likely to be forced to migrate. This is why climate change needs to be talked about through the framework of climate justice. I'm going to define racism broadly for purposes of my presentation, because I'm not only talking about how racism operates in the US, but how it operates globally. I define it as the dehumanization and objectification of human beings based on a variety of factors, commonly physical characteristics such as skin color, but also ethnicity, indigeneity, language, religion, culture, immigration status, and geographic origin. Who is racialized and how they are racialized is historically contingent. It's not phenotypically predetermined. Groups that we consider white today, the Irish and Jews, for example, were once racialized. Conversely, light-skinned Arabs and Muslims who were once considered white are now racialized. But race is not only about people, it's also about places. Race, it's a classification imposed on human bodies, but also it's mapped onto space in the form of areas that are considered expendable and disposable, including ghettos, reservations, prisons, war zones, refugee camps, and, as I will discuss in a minute, the sacrifice zones of the fossil fuel economy. Race is embedded in the history of fossil fuels. First, the colonization of the Americas and the transatlantic slave trade established the material and ideological foundations for the contemporary global economy. Economic historians have concluded that the Industrial Revolution, which inaugurated the age of fossil fuels, was made possible by the slave plantations of the Americas located on lands stolen from indigenous peoples. This means that colonization, slavery, genocide, and the racist ideologies that supported these projects are central rather than peripheral to the Industrial Revolution that launched the age of fossil fuels. Second, the slow violence of the fossil fuel industry, the pollution emitted by industry, has a disproportionate impact on racialized and poor communities all over the world. From the Niger Delta, where the oil is pumped out of the ground, to Cancer Alley, which is filled with petroleum refineries and chemical plants, fossil fuels take an enormous toll on the health and well-being of Black and Brown communities living in the shadows of oil drilling, chemical plants, fracking, petroleum refineries, power plants, and oil and gas pipelines. Third, fossil fuels are concentrated in certain areas of the world, such as the Middle East, that have been targeted over and over again for invasion, occupation, and exploitation. And when Arab and Muslim populations displaced by war try to enter Europe or the United States, they are classified as potential terrorists and excluded. Finally, the persons most susceptible to climate-related disasters and slow onset events, such as rising sea levels, are overwhelmingly persons classified as non-white. They live in areas that are exposed to hurricanes, floods, drought, rising sea levels, and desertification, but they have been rendered vulnerable through colonialism and its aftermath. Walter Rodney wrote a book called How Europe Underdeveloped Africa. Eduardo Galeano has a book called Open Veins of Latin America. These are some of the classic studies that illustrate how economic, political, and military interventions have increased poverty, reduced access to healthcare and education, and deprived countries of the resources that they need right now for climate adaptation and disaster response. Central America is an excellent case study, and I'm happy to entertain questions later about how this narrative applies in Central America. What unites this history is racial subordination. It's part of the history of fossil fuels from cradle to grave, and unfortunately, it's also embedded in some of the approaches that are developing to try to address the problem of climate displacement. Again, we don't have any hard law at the moment. We don't have any treaties that address it specifically. There's a placeholder in the Paris Agreement that has yet to be developed, but we have a number of non-binding frameworks that are starting to develop. What this narrative that I've just given you illustrates is that racism is not just bias and prejudice. It's actually something much more pernicious. It's state-sanctioned or extra-legal production of group-differentiated vulnerability to premature death. In the time I have left, I want to talk about the emerging approaches to climate displacement and to critique these approaches. And then I'll conclude with, what are people who are facing imminent displacement asking for? What are the solutions that they're putting on the table? So the first approach, which we see very clearly, is the national security approach. Environmentalists in affluent countries have often used the specter of mass immigration by Black and Brown people to prod states into adopting aggressive measures to mitigate climate change. The result has been a militarized and xenophobic response, the hardening of borders and the construction of walls. Instead of invoking empathy for the plight of migrants or responsibility for causing climate change, the national security approach reinforces racialized distinctions between us and them, citizen and foreigner, and promotes nationalism and the exclusion of migrants as threats to the public order. We see this in the United States, we see this in Europe, we see this in Australia. The criminalization of migration and the erecting of greater barriers to entry, often resulting in death along the US-Mexican border, death in the Mediterranean, death in the open seas as migrants try to reach Australia. The second approach to climate displacement is a non-binding framework that has been emerging based on the humanitarian approach. In contrast to the national security approach, the humanitarian approach portrays climate displaced persons as victims of misfortune who need to be assisted by the international community as a matter of charity rather than corrective justice. The paradigmatic example is the picture that's painted of states in the Pacific as vulnerable, isolated, and endangered by rising sea levels. The humanitarian approach, in a much more subtle way, reinforces racial hierarchies by casting affluent countries as essentially the saviors of the downtrodden, instead of recognizing the history that these are the countries whose greenhouse gases have created the problem and whose economic, political, and military interventions have increased vulnerability to climate change by exacerbating poverty. The Nansen Initiative is an example of a non-binding legal framework based on the humanitarian approach. It is the only legal framework that sets forth a series of principles to better protect displaced persons across national borders who are affected by disasters. So it's a disaster framework, and that disaster would encompass climate-related disasters. So the problem with this approach is that climate change is not like an earthquake. It's an injustice, not just a misfortune. The humanitarian approach absolves affluent countries of historic responsibility for climate change and makes any assistance of displaced persons essentially voluntary, something countries do out of the goodness of their hearts and as opposed to a rectification, a reparation of the harm that has been caused. The fact that it's voluntary will likely fail in the current political climate. We have seen what the response of the US has been to Central American migrants who are fleeing not only poverty and violence, but also massive droughts caused by climate change that have made it impossible to grow food. A third approach that is emerging through the International Organization for Migration is what's known as the migration management approach. This approach, unlike the others, recognizes migrants as active agents who take responsibility for their own social and economic well-being instead of relying on the protection of the state. Under this approach, temporary migration, as long as it is closely undertaken by states and international institutions, is something to be encouraged. So that temporary migrants from climate vulnerable states can work in affluent states and then provide remittances with which to finance climate change adaptation for family members that are left behind. In other words, the migration management approach treats climate change as an unavoidable misfortune and places the burden of climate change adaptation on the world's most climate vulnerable populations. Pull yourself up by your own bootstraps, even though this was caused by, you are not the cause of the problem. This approach is problematic. First, once again, it's not an obligatory approach. It's based on what northern labor markets require. It's not framed in the context of corrective justice. It doesn't obligate countries to open their borders. It only suggests that they do so. So which migrants are likely to be welcomed with open arms? Probably those who are young, able-bodied, light-skinned, skilled, and educated. Which migrants are likely to be excluded and incorporated into the workforce as undocumented immigrants or detained and deported? Those who are darker skinned, older, poorer, disabled, children. Most disturbingly, this approach doesn't contemplate affluent countries giving migrants labor rights, social safety nets, and the rights to protest abusive working conditions. There is a human rights treaty that protects the rights of migrant workers, the 1990 International Convention on the Protection of the Rights of All Migrant Workers and Members of Their Families. Not a single affluent labor importing country has ratified this treaty, not one. Finally, migration can produce a brain drain, labor shortages, and dependence on erratic remittance flows, thereby increasing the vulnerability of those people who are essentially trapped because they don't have the resources to leave, primarily women, children, the elderly, the poor, and the disabled. So in subtle and not so subtle ways, all of these approaches reinforce racial hierarchies. The national security approach constructs climate displaced persons as security threats to be neutralized through militarized borders, a clash between the civilized nations of the world and the barbarians. The humanitarian approach portrays climate displaced persons as passive victims in need of rescue by affluent saviors, a form of charity rather than corrective justice. And then the migration management approach creates exploitable workers to whom affluent countries owe no responsibility, even though these are the affluent countries that have contributed to rendering their homes, the homes of these migrants, uninhabitable. So what are climate vulnerable states and peoples calling for? Climate vulnerable states and peoples are calling for a different approach based on the collective right to self-determination. These states and peoples reject the narratives that portray them as savages, victims, or exploitable workers, and instead they define themselves as political subjects who collectively have a right to determine their own fate. Their goal is to preserve cultural integrity, community cohesion, and self-government so as to migrate with dignity. Their strong preference is for in situ adaptation, financed by the countries that caused climate change. They want affluent countries to honor their commitments under the Paris Agreement to provide financing for adaptation. If this is not enough, if migration is inevitable, then what they demand is the right to migrate either individually or collectively, and to reconstitute themselves as a self-governing people rather than having to assimilate to another culture. I want to point out that many of the communities that are advocating the right to collective migration grounded in self-determination are Pacific Islanders, many of whom are indigenous peoples. For indigenous peoples, being displaced from one's ancestral lands and forced to assimilate to a foreign culture is a form of ethnocide or genocide. Therefore, the protection of history, language, culture, and self-governing traditions is paramount. And one of the things that's happening very concretely is that there are bilateral and regional negotiations currently taking place in the South Pacific, which is spearheading this approach, to address the imminent loss of territory. The small island states are participating in the broader climate negotiations, but they're concerned that these multilateral resolutions take too long and are one size fits all, and may push them to the sidelines and not address their local circumstances. So they remain active in the climate negotiations, but they're also negotiating with neighboring countries that share common histories and traditions and understand and respect their desire to continue to exist as holistic self-governing communities. Finally, it's important to ask who benefits from the status quo? Who benefits from the militarization of borders? There are a couple of beneficiaries. The primary beneficiaries are the corporations that operate private immigration prisons, construct border walls, and provide security and surveillance. The second beneficiary is the state bureaucracy, ICE, whose staff and budget increase in order to administer the policing, detention, and expulsion of migrants. The third group is those who exploit migrant workers. The human traffickers also benefit because they can charge higher fees when the border controls increase. And then finally, authoritarian populist elites who scapegoat migrants and other racialized communities benefit because this is the tool that they use to mobilize support from the rest of the community, especially less affluent white people, for policies that actually intensify economic inequality and hasten catastrophic climate change. Racism is a form of social control. Communities of color are controlled very directly by violence, by incarceration, by policies that exclude. White communities are controlled into voting against their self-interest through racist ideologies. There are two books that are very good that talk about this that I want to recommend. The first is Dying of Whiteness by Jonathan Metzl, which was published in 2019. That book explains how racism persuades poor whites to support policies that are literally killing them and to oppose policies that would improve their quality of life, including gun control, healthcare reform, social safety nets, and better environmental protection. A second book by the sociologist Arlie Russell Hochschild, called Strangers in Their Own Lands, examines why white workers in Cancer Alley distrust government regulation, even though they know that the petrochemical industry is killing them. The answer again was race. These white communities have been persuaded that the federal government has abandoned them, it does not care about them, and that it is allowing immigrants and people of color to get ahead at their expense. These books show the way that race and racism are used as a wedge to divide people who should be allies in a common struggle against economic policies and industries that are wreaking havoc immediately and more broadly on the planet. In fact, one of the most insightful observations by the author of the second book on Cancer Alley is that the people she interviewed said that they felt almost like a minority group, forgotten, set aside, and displaced. In a very interesting way, which gets back to my capacious definition of racism, unbeknownst to them, they have been racialized as white trash, and they have been made surplus, like the very immigrants and the people of color that they despise. Racism is an obstacle to the solidarity required to address climate change and climate displacement, because it blames persons categorized as other for the misery that has been inflicted on them. Racism makes injustice acceptable by portraying large segments of humanity as surplus, disposable, and a threat to civilization. Racism is a technique of control that distracts people from the real scandal, the impunity with which the petrochemical industry and their allies wield their wealth and power, and the urgent need for a just transition away from fossil fuels. Thank you for your attention. I look forward to your questions.
Thank you. Our next speaker is Natalia Ospina. She is a project attorney with for environmental justice at the Natural Resources Defense Council. Ms. Ospina supports communities of color and low-income communities through advocacy and litigation as they fight disproportionate environmental burdens and build healthy and vibrant communities. Before joining NRDC, Ms. Ospina advocated on behalf of farmers in the Central Coast area as a staff attorney for the California Rural Legal Assistance. She's a graduate of Wellesley College and the Northwestern School of Law of Lewis and Clark College. She's based in the NRDC's Santa Monica office. And with that, Ms. Ospina.
Thank you. And I'll just say it's such an honor to follow that presentation. Definitely a lot of overlapping themes and points I think that all of us on this panel are making. I do have a presentation. Abe, if you can help me by sharing that, that would be great. Thank you. So I'll start off just quickly introducing myself. Thank you, Professor, for that introduction. So as you said, my name is Natalia Ospina. I'm an attorney with NRDC on our environmental justice team. And my team works with community partners across the country on a variety of different campaigns, coalitions, and issues. And I will be highlighting a little bit of my work, but really I've designed this presentation to cover two primary points. One, I'd like to convey the definitions and the values that guide what my team works on and also how we work, and also to illustrate these values and these tools through some project examples. Slide 2. So just want to start things off by sharing a definition of the environmental justice movement and also recognizing that the EJ movement really has grown out of the powerful work of civil rights activists in particular. EJ as a movement seeks to address the fact that people who live, work, play, and pray in America's most polluted environments are disproportionately people of color and the poor. And these communities not only are burdened by the bad stuff, but they also lack access to many benefits such as open space, access to healthy foods, and transportation. And in this work, it's important that justice be defined by the affected communities and that the long-term goals of any EJ campaign are to achieve justice and build power on the ground. Next slide. And before I get too far into the presentation, I do want to name some of the community members and organizations I work alongside of on coalitions and campaigns, and recognize that their knowledge and their organizing is the foundation of the support that I provide as an attorney or an advocate. I'll share a little bit more about some of these partners in my short presentation, but I want to highlight some of them here by name and by picture. So the first picture, some community members from the Communities for a Better Environment who came out to a rally about the I-710 expansion project. The second picture features Mr. Walter Bird, who's an active member of the Centerville Citizens for Change based out of Centerville, Illinois. And last but not least, the last picture features Shakima Thomas, Yvette Jordan, and Saber B, 3 activists from Newark, New Jersey, who stepped up during the lead and the drinking water crisis and are a huge reason for causing the city to take aggressive steps to change how it treated its water and also to replace its lead service lines. Next slide. So this slide lists the Jemez principles, which were developed in Jemez, New Mexico in 1996 and guide how EJ groups engage with each other, but also expect to be engaged by others. I share these values because in EJ advocacy, the substantive outcome is as important as how our work is done. So these 6 principles are challenging to implement, especially given the pace of our advocacy, the size of some of our institutions, and traditional views of what environmental or legal advocacy looks like. However, holding myself to these principles, I hope to grow and foster long-term trusting relationships with our partners and really help support movement building. And I won't go through all of these principles now, but I really encourage you all, if you're not familiar with the Jemez principles, to look them up and think through how you can incorporate them into your own work currently and moving forward. But I think overall, incorporating these principles requires a lot of self-reflection, acknowledging when we've made mistakes, and also often slowing down. Especially I think with legal advocacy, this is probably true of many fields. There's a pressure to move quickly and respond right away. And sometimes this works is in conflict with some of the principles that we try to hold ourselves to. So I think it's important to balance and sometimes trade off speed or some of these other things that are pushing us in order to try to really work along with our values. Next slide, please. So what I will briefly do here in this presentation is share some examples of my work that demonstrate the definitions and the values I've just described and exemplify these three principles: rootedness, building power, and accountability. I also want to preface these examples with a recognition of the limitations of the law, as well as the need for lawyers to reconsider and sometimes unlearn ways that we were taught to value the law and our role as attorneys. I included some materials to accompany the panel that speak to some of these points, and I noticed there's some materials from my co-panelists that raise similar points. I think particularly as a former legal aid attorney, but also in my current role, I recognize that it can be hard to shift how you view your role as an attorney, but I've definitely come to realize that it's crucial for approaching the issues that face us with transformative solutions and values. I think the last presentation spoke to that point very vividly, that sometimes if we're not approaching, even if we recognize the problems and we want to work to support EJ communities, if we're not working in a principled manner, sometimes the solutions that we put forward can actually have unintended consequences and lift up the same systems that we're trying to knock down. Next slide. So the first principle will be being rooted in community. So to illustrate that principle, I'll describe my team's advocacy with the Coalition for Environmental Health and Justice on the I-710 South Corridor project. Next slide, please. So over 2 decades, the last 2 decades, EJ communities in the LA region have prioritized reducing air pollution from ports, rail yards, warehouses, and truck corridors, because emissions from these operations have resulted in more asthma, cancer, and premature death in their neighborhoods. Communities of color and low wealth people along freight corridors across the country bear disproportionate impacts, but some statistics on California specific impacts are that on average, Black, Latinx, and Asian American Californians are exposed to more pollution from cars, trucks, buses than white Californians. Also, the lowest income households in the state live where particulate matter pollution is 10% higher than the state average, while those with the highest income live where particulate matter pollution is 13% lower than the state average. As a result of these disparate impacts, which freight corridor communities are the most aware of, when a huge highway expansion project was proposed for the I-710, CHAJ, the coalition, was activated. For those who aren't aware, the I-710 freeway connects the ports of Long Beach and Los Angeles in South LA to the region, to the larger LA County region, as well as surrounding counties, especially distribution centers and warehouses in the Inland Empire. But it's also part of a national network, connecting lots of different freight corridors. While the proposed project has changed somewhat in the last 15 years since it was first proposed, it's still viewed as a lane widening project. And this is one of the largest highway projects in the country. So its impact is immense. And it also has a potential of being an example for other highway and road transportation projects moving forward. So as a result, the coalition has coalesced around 3 primary demands, which are listed here. One, that the project improve surrounding air quality, not just make it worse, but actually make it better, particularly through implementing zero emission technologies and encouraging them, particularly with trucks. 2, that the project include no displacement of homes, businesses, or community spaces. And 3, that the corridor communities also receive benefits from one of the largest freeway projects in the country through targeted and local hiring projects that are enforceable through labor agreements. So CHAJ is currently led by community-based organizations, including East Yard Communities for Environmental Justice, Communities for a Better Environment, the Long Beach Alliance for Children with Asthma, and Long Beach Residents Empowered. I'm a part of the coalition in a technical advisory role as a lawyer, but my advocacy requires attending coalition calls regularly and meetings to understand the coalition's priorities and needs, and also be creative and flexible in how I can support. And so sometimes this does mean doing legal research or drafting legal documents, but other times it really means listening and taking the time to understand the issues and the solutions being proposed by our community partners, and figuring out what are some tactics that we can use, especially some legal tactics, since that's my area of expertise, somewhat expertise, and how can we leverage some of that in order to reach the actual goals of the coalition. So I also make sure I come at the work in a thoughtful way, and I think about how to provide and share feedback with coalition members as necessary to make sure that any legal work I am doing is grounded by the experiences and the priorities of community members. And so, as I mentioned before, that takes time. It takes time to build trust and solidarity with members of the coalition. It also takes time to sometimes break things down or to try and engage in some community education. And I think slowing down and taking time ultimately allows me to be a better advocate on this coalition. Next slide, please. Next principle is building power and capacity. And to talk about that, I'll provide a little bit of information on an example initiative at NRDC. Next slide. So this initiative is called the Movement Support Fund. According to a 2012 study from 2007 to 2009, only 11% of all philanthropic giving in the environmental sector was focused on social justice advocacy, and only 15% of environmental grant dollars went to marginalized groups. So while this has begun to shift, the fact remains that large national nonprofits like NRDC continue to out-fundraise grassroots groups. This disparity comes in large part from a legacy of institutional racism, as well as a lack of appreciation for community organizing. So NRDC recognizes the need, 5 minutes, thank you. The need to distribute resources more equitably. So the MSF is a program we initiated to shift resources to the grassroots sector. Essentially, staff are invited to apply on behalf of a community-based organization. And in their application, they must identify how the contribution aligns with the HMS principles, how the grantee is grounded in the community, and also confirm that it has a relatively small operating budget. To date, the MSF has approved 50 applications to grantees across the country, as well as a few international partners, including a grant to the Black Farmer Fund, which is an emerging effort that supports Black farmers and food system entrepreneurs, as well as a grant to support the Columbia River Intertribal Fish Commission on behalf of the Columbia River Treaty Tribes for basic food and healthcare needs for tribal members and elders. Next slide, please. One critical question that arises when working with EJ communities is accountability. To whom are we accountable? While EJ organizations are accountable to the community members they represent, as national membership-based advocates, NRDC typically litigates and advocates on behalf of itself and its members. But in the EJ context, we must be accountable to the community first and foremost. But accountability can be difficult to achieve, particularly where there's a shifting political landscape, or facts are still coming out, or the problem is so big that the solutions require us to be accountable to an entire community, and communities are not monolithic. So determining how accountability, how we actually remain accountable, it can be difficult and a challenging process. Next slide. I was going to play a little bit of a video of some residents from Centerville talking a little bit about the sewage and flooding issues that they've faced for decades, but I'm a little bit short on time, so I really encourage you all to just check out the PowerPoint and watch the video and listen to these residents speak from their own experiences about how much of a burden it's been to live in a community that's been underinvested and ignored, not just by local municipalities, but also by regulators and state and federal enforcement agencies. But turning specifically to my point of accountability, in Centerville, Illinois, I work with several academic, nonprofit, and legal organizations where we all work in partnership a lot with the resident committee, which has come together as a Centerville Citizens for Change. And we work to carry out our advocacy in a way that is accountable to the residents that are directly impacted by the sewage and flooding crisis. I've put some brief facts, including a typo, about the issues in Centerville on the slide, but I don't want to dig in too deeply on the facts because I think that could take up just on its own a whole hour. But at a high level, I'd just like to highlight that so I've been working on this project for about 2 years. And in that time, all the partners have really been not only looking for solutions and trying to understand the causes of the sewage and flooding problems, but we've also been working to figure out how to support residents in building leadership and power. So now after 2 years, they're their own formal nonprofit that can fundraise and receive grants. And they also have a leadership structure that allows them to make decisions about how to directly engage with agencies and with media. And so part of my work is not just doing legal or policy research, but also taking time to consider how that research will be shared with residents in a way that they can take the information and make informed decisions about priorities and next steps based on the information that I'm providing. Ultimately, accountability requires an acknowledgement that those who are directly impacted and closest to the problems are also closest to the solutions, which was also raised in the last presentation. So therefore, while I'm providing some knowledge and some technical expertise to a partnership or a coalition or a campaign, ultimately decisions and solutions need to be developed by the community and community members. Next slide, please. And so in sum, my team works to carry out our work in a way that is rooted, builds power, and is accountable to community. These values are very challenging to implement, but even while we make mistakes, I really believe that as long as we're working towards these values and principles, we can leverage our skills and knowledge as lawyers towards strengthening the movement. And really, it's together that we all need to show up and try to build power to tackle some of these huge issues that are impacting all of us ultimately, but definitely disproportionately EJ and frontline communities. So thank you for the time, and I look forward to answering any questions. Thank you.
Terrific. Thank you so much. Our next speaker is Professor Steph Tai from the University of Wisconsin School of Law. Professor Tai earned her bachelor's degree at Massachusetts Institute of Technology, MIT, her JD at Georgetown, and a PhD at Tufts University. Professor Tai's scholarly research examines the intersection between environmental and health sciences and administrative law. These include considerations of scientific expertise, environmental justice concerns by administrative and judicial systems, as well as the role of scientific dialogue in food system regulation and the ways in which private governance can be incorporated in scientific research. Professor Tai's teaching interests include administrative law, environmental law and systems law, food systems law, environmental justice, risk regulation, contracts, and comparative Asian environmental law. After graduating from Georgetown, Professor Tai served as a judicial law clerk to the Honorable Ronald Lee Gilman on the U.S. Court of Appeals for the Sixth Circuit. Professor Tai then worked as an appellate attorney in the Environmental and Natural Resources Division of the U.S. Department of Justice. And from 2013 to 2014, Professor Tai served as a U.S. Supreme Court Fellow as a researcher in the Federal Judicial Center. Professor Tai actively represents Amici in Federal Circuit Court, Supreme Court cases, most recently or recently, among the amicus briefs that she filed, included a brief in the County of Maui versus Hawaii Wildlife Fund case, a Clean Water Act case that was very favorably referenced by the Supreme Court in its majority opinion. And with that, Professor Tai.
Thanks so much for the introduction. One of the things that I think that we as law professors can do is use our positions to amplify the works of those of us who are working on the ground in environmental justice. And so my talk today centers around an essay, I don't have PowerPoint slides, that I worked on with my friend Jayesh Patel of Street Democracy, a community justice organization in Detroit, Michigan. The essay was published in Detroit Mercy Law Review earlier this year, and it's called A Scaffolding Approach to Environmental Justice. And it's actually great because I happen to come after Natalia, who is talking about many of the things that I'll be talking about as well. But mostly centering around how lawyering can be specifically structured to empower communities. So the entire focus of it is around that. So in 2014, the Detroit Water and Sewage Department terminated water service to over 20,000 Detroit residents for lack of payment, without any regard for the residents' health needs or ability to pay. This was the largest residential water shutoff in US history, and part of an effort to address Detroit's insolvency issues. But the agency's aggressive approach created a powerful example of environmental injustice. It meant that tens of thousands of Detroit residents lacked access to clean water and, in connection, a clean environment and clean foods. My co-author Jayesh worked on this alongside a number of other community justice lawyers and advocates. So we sought to write a paper showing his own experience and applying what's called a scaffolding approach, a three-prong approach drawn from educational theory and designed to move students progressively towards stronger understanding and ultimately greater independence in the learning process, exactly what Natalia was expressing, sort of empowering communities. In community justice lawyering, this approach focuses on using litigation as a scaffold for local mobilization and empowerment, rather than as a direct method to achieve change. The idea is to empower communities and community members to move towards independence in activism rather than upon continued reliance upon lawyers. So the three prongs involve creation of opportunities for storytelling and engagement in the political process, focusing on visible rallying and polarizing points for movements, and using structures and deadlines for galvanizing nascent campaigns post-litigation. So how did the advocates in Detroit apply this process to helping the community get access to drinking water? Well, first, the advocates in the Detroit water shutoff crisis, and Jayesh and our essay provided some of his own experiences with this, focused on expanding access to the political process. Detroit's water crisis began well before 2014, precipitated by white flight and decades of steady economic decline, beginning in the 1970s, which led to a crashed local real estate market. Back in 2005, Michigan Welfare Rights Organization, a union of public assistance recipients and low-income workers, and Michigan Legal Services, a poverty law nonprofit, began noticing that members and clients were increasingly experiencing water shutoffs. Together, they developed a policy goal of an income indexed water rate to take into account affordability. They presented this to the Detroit City Council. Here, the lawyers were engaged, not as direct advocate, but as political enablers and scaffolding and providing scaffolding, using their legal skills and knowledge of law and policy making to help its community partner draft policy goals, i.e. the Water Affordability Plan. By selecting a strategy of public presentation to governmental bodies, they elevated the Water Affordability Plan status from a policy white paper to a matter of public discourse. And again, that plan was developed by the community members. This provided the community with multiple opportunities for storytelling and the means by which to hold public officials accountable. Although the adoption of the Water Affordability Plan was tabled by the city on the basis of legal concerns, the plan still continues, even now, to serve as both the policy lodestar for the movement, as well as an instrument raised to resurrect the issue's political profile. Next, the advocates in the Detroit water shutoff crisis focused on rallying and providing points for coalition building. When the movement first started, it initially approached access to water from the perspective of the public trust doctrine, right? Something that we're all familiar with in the environmental law world. As public outrage mounted, and here is where Carmen's tie-ins with all these different disciplines come up, it added a rights-based approach, namely that access to water is a human right. On June 18, 2014, the Blue Planet Project, Food and Water Watch, the Michigan Welfare Rights Organization, and the Detroit People's Water Board, a broad coalition of environmentalists, poverty advocates, and union members, filed a petition with the United Nations Special Rapporteur on the human right to safe drinking water and sanitation, alleging that Detroit's water shutoff crisis constituted a violation of the human right to water. That petition included raw data about the shutoffs, information about the administrative burdens for reestablishing water access that were alleged to be inappropriate to impoverished persons, and stories of and from affected people. Within 7 days, 3 UN experts concluded that disconnection of water services because of failure to pay due to lack of means constitutes a violation to the human right of water and other international rights. This brought the moral weight of international law into the framing of the Detroit water shutoff crisis. Water marches after the UN declaration were now punctuated by chants of fight, fight, water is a human right. Several months later, the UN Special Rapporteur, upon invitation of these water advocates, visited Detroit to conduct listening sessions with affected persons and discuss the situation with the city's congressional leaders and attorneys. The visit and the resultant statement both confirmed the movement's claims about the hardships experienced by Detroit's poor residents and championed its policy demands. So motivated by these principles of civil disobedience, further empowered within their rights-based legal arguments, and buoyed by offers of legal representation by attorneys from the National Lawyers Guild, water activists planned actions to block the agency contractor, Homeridge, from executing additional water shutoffs. And so here you start to see the sort of wide range of ways in which lawyers, not necessarily using environmental law, can still empower communities to try to achieve environmental justice. So there, the planned protests coincided with the Netroots Nation conference to maximize its effect and media exposure. In July, 9 protesters were arrested for misdemeanor disorderly conduct at a second action. The defense's strategy was to test the necessity of defense theory, with the greater harm here being the imminent harm posed by water shutoffs. Reverend Bill Wiley Kellerman summed up the defense strategy, saying, "We believe what we did was right and necessary and an act of conscience that a jury can understand and vote on, and they've been denied that." The cases lasted 3 years with multiple motions and an appeal just before jury deliberations. Each docketed event served as another opportunity for community rallying and coalition building via packing the courthouse and media exposure. The cases were ultimately dismissed as a violation of the defendant's right to a speedy trial. These actions succeeded in doing 2 things. First, it raised the profile of the Detroit water shutoff crisis from a local issue to an international one. Second, it elevated the public's perception on water access as not only a matter of human dignity, but also as a human right. The last thing is that advocates in the Detroit water shutoff crisis attempted to create structures and deadlines for galvanizing nascent campaigns post-litigation. So again, we're talking about the use of litigation as a scaffold for the community to engage in its own kind of political advocacy. Advocates in the Detroit water shutoff crisis worked to create structures and deadlines looking forward to post-litigation community organizing efforts in order to further galvanize the community. So advocates worked with community members and others to involve them deeply into the Detroit bankruptcy proceedings. Though the initial court proceedings ruled that human rights concerns were outside of the jurisdiction of the bankruptcy court, the political pressure fostered by the UN report, the protests, the civil disobedience, still created legal pressure prompting the bankruptcy court to at least inquire about the city's plan to address the shutoff crisis. And moreover, even though the appeals have not yet been addressed, this still created political pressure to implement some water shutoff relief by the impending legal deadline. This work is still ongoing, but I have to say that there are some bright sides in this struggle. During the pandemic, Progressive Outreach Organization Engage Michigan used some of this foundational work, all of the work that I discussed before, the scaffolding work, to petition Governor Gretchen Whitmer to issue a moratorium on water shutoffs in Detroit, citing the environmental, public health, and human rights crisis. Governor Whitmer did issue a moratorium, and as of January, the city is continuing that moratorium on residential water shutoffs through 2022 and working on a plan that would end them permanently. What does this all mean for thinking structurally about environmental justice advocacy? The successes and hurdles faced by advocates in the Detroit water shutoff crisis suggest the following. When entering the environmental justice space from a community-based lawyering perspectives, attorneys should first remind themselves that the community's accumulation of power is the paramount objective, much like Natalia said, and that all lawyering should be undertaken in a way that furthers that objective. Secondly, the messiness of movements will be manifest in the work. You heard the examples I gave. It brings into mind international law, criminal law, bankruptcy proceedings, all of this. But this messiness means that strategy and lawyering modalities will shift as often as opportunity windows open and close. And the important point is to find those opportunities and make them as useful to the communities as possible. Third, although there may be issues with the speed and efficacy of environmental impact litigation, there remains tremendous opportunity underneath the scaffold of litigation to galvanize public support for a movement and amass enough political power to effectuate change, which is what has happened here with Detroit. By acting within a carefully designed community-based lawyering strategy, movements can win power regardless of whether or not attorneys lose an argument in court. Thanks for your time. I think I tried to end a little bit early so that we could have time.
Well, thank you, and thank you to all of our speakers for their wonderful presentations. We do have time for questions and answers, and we're going to be using again the raise the hand feature. So if you have questions, please please go ahead and raise your hand through the raise the hand feature, and we look forward to hearing your questions. Let's see. Let me pull up. So we have, let's see. We have a question from Natalia.
Yes, I have a question to Professor Gonzalez. Do you think that there would be realistically a multilateral treaty reached addressing the issues of climate displaced persons on international level? Thank you.
There's a placeholder for it in the Paris Agreement. So the Paris Agreement, for the very first time in the history of the climate negotiations, recognizes what is known as loss and damage. And that refers to harms that cannot be avoided through adaptation, such as the sea levels are rising, but that includes damages from hurricanes. It also includes displacement of people. Under the auspices of the Paris Agreement, a committee of the Paris Agreement's loss mechanism, a committee has been created to study the issue of climate displacement. So that work has begun. So there is a place for it in the climate treaties. The benefit of the climate treaty is that the climate treaties recognize a principle known as common but differentiated responsibility, meaning that those who contributed most to a particular environmental problem have the obligation to take the lead. And so the Paris Agreement, because it's part of the climate regime that recognizes this principle, is primed to consider justice. So in theory, right, this would be a fantastic placeholder for it, and things are moving along. In practice, when the Paris Agreement was adopted, the United States pushed to have language in the decision adopting the agreement to specify that this does not create the basis for compensation or liability, right? This is the exit strategy to try to not deal with this in a manner that would require the countries that caused the problem to recognize the scope of the problem. This is just in the decision. It's not in the agreement itself. The political barriers are enormous. Migration is one of the most politicized areas imaginable. So I think the possibility of anything coming through as at the international level that is more than just a voluntary framework at this point is very unlikely. My own sense is that the solutions that are likely to come forward are going to be regional. Because every region of the world has connections with particular groups that are going to be displaced and has historic responsibility not only for greenhouse gas emissions, but also for its intervention in other places of the world that are also among the triggers. The real challenge is that displacement is not only because of climate change, unless you're talking about the small island states that have 10 years. When you're looking at Central America, it's one of many factors. People are fleeing because of poverty. They're fleeing because of conflict. They're fleeing because of drought. It would be impossible to actually say you are a climate refugee and you are not, because there's so many complicating factors. That's what leads me to think that the most plausible and likely solution is going to be a regional one and not an international one that tries to grapple with this issue.
Can I add something to that? I haven't read this yet, but just yesterday, the Biden administration issued an executive order on rebuilding and enhancing programs to resettle refugees and plan for the impact of climate change on mitigation. I haven't read it yet, but it just got up there. So if you're interested in seeing what kind of approach the administration has taken to that, then you can look it up. I was going to read that after the conference.
Thank you. You know, I'm in the same boat. I heard about it, but I haven't read it yet. And so one of the things I want to plant in your brains when you all go out and read it, which I hope you do and I will, is it simply addressing the symptom of the problem, or is it addressing the underlying roots? Without a plan to address poverty, conflict, and adaptation for climate change, it's simply not enough to take individuals one by one, because this is a systemic problem. So look at it through that lens when you read it.
I did read the executive order on refugees from Central America, and they actually did say that agencies, including Department of State, Department of Treasury, et cetera, are supposed to review their policies to see the extent that they're contributing to the migration issues. So it does seem like at least that executive order is addressing it on a regional basis.
And that's a fantastic beginning. That really is a fantastic beginning.
Let me exercise the moderator's prerogative and if I, oh, I'm sorry, before I do that, let me turn to Alicia.
First off, thank you all for coming today. My question is more for Professor Tai. So I noticed you mentioned how lawyers are going in, they're going through the legal process to make sure that environmental injustices don't happen. And so one way they did that was to argue that water was a basic human right. And then in that way, it's more of like, now something has to be done. Is this something the Supreme Court has like grappled with, or is there like certain issues that they will have to grapple with in the future?
So,
now that we are taking this route.
Our federal Supreme Court is unlikely to grapple with it in the future, just given the composition of the Supreme Court. State courts, a lot of times can apply what's called the public trust doctrine. And I mentioned that briefly. Different states apply it in different ways. And some states, the public trust doctrine looks more like a sort of human right to water than others. So it's going to be a state by state kind of approach. But that's one thing. But the other thing I wanted to emphasize is that this approach does not rely upon a legal win, right? The idea is to sort of emphasize to the public that this is a moral human right as well. And that too can sort of change political outcomes, right? Part of the framing of water as a human right is the reason why Governor Whitmer ultimately granted this moratorium on water shutoffs, because they'd spent so many years framing it from that angle. So I wanted to emphasize that it takes both of those efforts.
If I could add something briefly there, is that in addition to through courts, the right can also be articulated legislatively, and usually that does come as a result of community activism and community organizing to get that legislation passed. So for example, in California, we have the Coastal Act, which articulates a right to the coast for all Californians, which is part of why, unlike where I'm from in New Jersey, where you have to pay $10 to go to the beach, California, in a lot of places you can just drive up and go. But it also recognizes the act, and the Coastal Commission that enforces the act recognizes that in practice there can be barriers that come up. So there needs to be a comprehensive articulation of what that right looks like, and also how the state is going to take steps to make sure that right is actually accessible to everyone.
So a question following up on some of the observations about existing doctrinal tools that can allow for the use of litigation to address environmental justice issues. Are there particular ideas that you have, any of you have on sort of the top of your doctrinal wish list with regard to whether it's statutory change, evolution in common law, a uniform law that could be adopted by the several states that would provide a particularly useful vehicle to advance environmental justice interests?
So I guess I'll start since you're being quiet. One of the things that I see as a positive thing in the Biden administration executive order, which would be great to see enacted in law, is that it urges agencies to do a review of all the ways in which their activities lead to environmental injustices versus, just sort of little micro level kind of things. And I think that sort of overall big accounting by different agencies is important. I don't know whether or not this will actually come and play. The problem with executive orders is they can be wishy-washy. I mean, this gives like timelines, so that's great, but it depends on, the details of how the report is put out. That said, if this was an actual sort of congressional reporting requirement or something like that, that would put more teeth into it, and it would allow the public to more forcefully hold agencies accountable for these kinds of things. The other thing too, it contains, I think, a requirement for OMB, White House Office of Management and Budget, which kind of oversees all agency actions, to put out an environmental justice report every 2 years. Again, in an executive order, it's fairly weak, right? Because if another administration comes in, it could just get wiped out. But if that kind of thing becomes a sort of long-term statutorily enacted kind of goal, that could come a long way. Again, these are ways, I'm thinking of this in terms of sort of big framework ways to have public accountability for agencies and their actions.
I can jump in. I think, well, one thing I would just preface by saying, I think it's so, EJ issues are so local that solutions are also very local. So it's hard to, I think it could look different depending on the community. But something that was a very significant victory last year was that New Jersey passed an EJ bill that required, going back to the very first presentation of Dr. Galaviz, it required a consideration in permitting for large facilities of the cumulative impacts that are already existing for the communities surrounding any proposed facilities. So that is something, again, like EJ communities were advocating and have been organizing and educating around that for many, many years in New Jersey. And so they finally were able to come to push for it to be passed legislatively. And there are other states like California, like Illinois, that are where EJ communities are similarly considering, okay, what would this look like in California? What would this look like in other states? And what would we want in it? What are the factors that we want considered in this case in permitting processes? And that can be, I think for me, that was a great victory after so many years of trying to get similar laws passed. So I think hopefully we'll see more of that in the future. And I know there's some federal bills as well that require a look at cumulative impacts, although the federal landscape looks a little bit different than state legislatures. So there's different opportunities on state and federal levels.
I'm seeing some really interesting changes relating all of this to the topic of migration that have some potential. In January of 2020, the Human Rights Committee, which implements the International Treaties on Civil and Political Rights, to which the US incidentally is a party. The US is notorious for not signing treaties, but it is a party to this treaty, issued a very interesting decision that said that deporting someone to a country where they will be harmed by climate change constitutes a violation of the right to life under the International Covenant on Civil and Political Rights. The petitioner in that case was a man from the Pacific island of Kiribati who was suing New Zealand, which had deported him. So on the one hand, this is really important. It's relief from deportation because of climate change caused conditions in your home country. The disappointment was that in this particular case, the committee said, well, this individual, there were 10 years before conditions in Kiribati became truly desperate. And therefore, in this situation, it was not a violation of the treaty for New Zealand to deport this person. There were two absolutely stinging dissents that described in detail what the conditions were right now in terms of lack of access to land, lack of access to water, conflict, which leads me to believe how dire does the situation have to be before this right is triggered. So we're seeing some gradual movement in terms of interpreting existing treaties to grant rights to climate displaced persons. But so much more is needed. This is simply a right not to be deported once you're actually in. But the problem is getting in, that it's a life-threatening endeavor to actually leave your country and migrate to a place of safety.
Well, thank you. Well, we're at the appointed hour. So thank you so much to all four of our speakers for enlightening, inspiring, thought-provoking presentations. Also wanted to not let the moment go by without thanking the Law Review in general and its editorial staff, and in particular Abe Brand for all the wonderful work he's been doing in general on this symposium and the terrific work he did in helping to pull together this panel. So with that, let me pass the baton through the Zoomosphere to Abe, and thank you.
I'm very excited to introduce our moderator for the Race and Economic Justice panel, my contracts professor, Vice Dean Dove Weissman.
Thanks, Abe. Good morning, everyone. Welcome again to this year's Southwestern Law Review Symposium. As Abe said, my name is Dove Weissman. I'm a Vice Dean and Professor of Law here at Southwestern. I'm very pleased to be moderating this morning's second panel, Race and Economic Injustice, Past, Present, and Future. In a moment, I'll begin by introducing our four panelists. After I've done that, we'll hear from each panelist for about 15 minutes. After the panelists have presented, we'll go ahead and open it up to the audience for Q&A. I'll ask audience members to use Zoom's raise hand function to indicate that you'd like to ask a question, and we'll take as many questions as we have time for. So to introduce our four distinguished panelists, our first panelist today is my colleague, Danielle Kai-Hart, who is Professor of Law here at Southwestern Law School. A Southwestern faculty member since 1999, Professor Hart has published on a wide range of topics, from procedural reform and the strategic uses of procedure to same-sex marriage. Her current research focuses on contract law, its politics, distributive effects, and social consequences. Professor Hart's work has been published in the Hastings Law Journal, the Loyola Law Review, the Nevada Law Journal, among other places. And Professor Hart has served as a member and past chair of the Executive Committee of the Association of American Law Schools section on gay and lesbian legal issues, as well as on the Executive Committee of the AALS section on contracts. She's also a member of the Organizing Committee for Class Crits, a network of scholars and activists interested in critical analysis of law and economic relations. Professor Hart's topic at today's panel is Contract Law and Inequality, a Primer. Why don't we go ahead and have your presentation, Professor Hart, and then I'll introduce each panelist right before their time to present.
Sure. Thanks so much for the introduction, Dove. And I also want to just thank the Law Review. I also want to thank Balsa for making this symposium happen. And I want to thank everybody who has taken time out of their day to join us. One last thank you. I really want to thank all of the other panelists on this particular panel for agreeing to join the panel. And I'm really very much looking forward to hearing what all of you are going to be talking about. So my talk is called Contract Law and Inequality. And actually, let me share my screen right now. Can someone can you see my screen? Can someone, at this point, just going to have to say yes or no?
Yes.
Okay, awesome. Thank you. So my talk is Contract Law and Inequality. It's going to be a primer, which means it's going to be short and to the point. And so let me just start by saying, America, as we already know, right, was founded on institutionally recognized and supported inequality, namely slavery. And so the fact that inequality continues to exist today should surprise absolutely no one. And the COVID-19 pandemic has really exposed some of those fault lines and the inequality in really, really horrifying detail. A few stats just to kind of set the context for this. We already know that people of color are dying at higher rates than white people. We know that people of color are doing worse economically than white people. And the chasm economically, I think, is really captured by these few stats that I have up on the slide right now. So the S&P 500 is hitting record highs. Morgan Stanley, Goldman Sachs are posting record quarterly earnings. We apparently minted 56 new billionaires during the course of the pandemic, which brings our total, I had no idea, up to 659. The billionaires have gained $1 trillion since the start of the pandemic. If you contrast that with the poverty rate, poverty in a 3-month period last year rose by 6 million people. And African Americans were the group most affected by that increase in poverty. And so I think the punchline to some of this is that the haves come out ahead. The haves come out ahead, and there's really nothing new about this. We've all heard that before, but I think there's two important details that are obscured and therefore overlooked in this widely accepted observation that the haves come out ahead. And those two details are the role that contracts and contract law play in facilitating the reality where haves come out ahead, and the often devastating social consequences that contracts and contract law help to produce in this process. And so in this particular talk, I want to focus on the racialized basis of this inequality. And obviously there are other explanations and contributing factors to for the extent and intransigence of inequality in the US. But an argument I've made for a long time is that we ignore contracts and contract law at our peril, because on a day in and day out basis, they play an integral role in helping to create and perpetuate inequality in American society. So this particular talk is one where I want to kind of pull back the curtain and expose some of this really, really briefly, and focusing specifically on first, the way that contracts and contract law in action reinstantiates existing hierarchies. So for example, rich over poor, which ensures that the people who start with more end up with more. So in other words, contracts and contract law in action help to create and perpetuate inequality in American society on a day in and day out basis. The second part of the talk is going to discuss some of the devastating social consequences that contracts and contract law produce in this process. And I'm going to revisit the housing market crash that precipitated the Great Recession as an illustration. The final part of the talk, assuming I have time to get to it, is I want to talk about ideology, basically, because notwithstanding the fact that contracts and contract law help produce these kind of profound social and systemic social consequences, the role that they play is actually going to get ignored, and it gets ignored because of how we think about contracts and contract laws being strictly private. And so the third part of the talk is essentially an origin story where I want to focus on emancipation. Okay, so let's talk about reinstantiation of hierarchy. So this is contract law in action. Contract law in action, sorry, forgot I had this one. Contract law in action starts with property, because inequality starts with property, and specifically how much property you own. The state determines what constitutes property, how it can be acquired, by whom, and what can be done with it. The stark example that I want to use here is a slave, because on December 31st, 1862, which is the day before the Emancipation Proclamation was issued, slaves were property under the laws of the Southern states. On January 1st, 1863, which is the day that the Emancipation Proclamation was issued, slaves were legally no longer considered property, but were instead freed persons. Okay. The state has never distributed property equally, meaning the original distribution of property was limited to white men. So this necessarily means that some people own more property than others. Let me give you another quick example. December 31st, 1862, before emancipation, a white plantation owner in the South owned the land on which his plantation was situated, plus any buildings, equipment, and farm animals located or living on that property, probably some money, right, from the crops and stuff. And he owned slaves. A slave on that date owed absolutely nothing. On January 1st, 1863, that white plantation owner still owned everything that he owned the day before, minus his slaves. The slave on the day of the Emancipation Proclamation, newly freed, owned himself. And that's not an insignificant thing. I'm not trying to minimize it, but the comparison is what I'm making here. So property and contract have a symbiotic relationship, because contract is the legal device that we use to transfer property from one party to another. In the context of contract law, property is the basis of bargaining power. It's the original basis of bargaining power. The legal realists told us almost 95 years ago now that what somebody owns, meaning their property rights, is going to determine what that party's bargaining power is and what that party will ultimately be able to acquire in the market. The contract law acknowledges that unequal bargaining power exists, but it treats the existence of unequal bargaining power as unproblematic, and it treats it as unproblematic because it ignores its own structural inequality, meaning that contract law will ignore the fact that unequal bargaining power exists, and it does this by applying the same rules to everybody, regardless of what they bring to the mythical negotiating table. So everything from formation to interpretation, performance, breach, and remedy, everything, all the rules are the same, gets applied to everyone. Now I'm going to skip a lot of steps in this particular analysis because I want to just get to the practical effect, and I want to be able to get to the other parts of the talk. So practically speaking, right? Practically speaking, recall that what a party owns, right? The property rights determines that party's bargaining power. Bargaining power, the party with more bargaining power, not surprisingly, is going to be able to dictate the terms of the contract, right? Which means that the party with more bargaining power will get to reap more gains than they might otherwise have been able to if they had less bargaining power. So for example, I might be able to charge a higher price in this particular contract because I have more bargaining power than you. The reality is, and these are steps that I skipped in the talk, the reality is that the vast majority of contracts are going to be binding. They're just going to be binding. It's really, really, really hard to get out of a contract. Fair, unfair, unequal bargaining power, no one, it doesn't matter. It's really, really hard to get out of a contract. And so if the contracts are going to be binding, this also means that the state is going to enforce those contracts. State will enforce the contracts. And so making contracts binding and enforceable is going to ensure then that the party with more bargaining power gets to keep the gains from each of its contracts. And then over time, sorry, pressing the wrong button. Over time, the party with more bargaining power is going to end up owning more, right? More land, more money, more labor, etc. And so the more one party owns, the more bargaining power that party has, and so on and on ad infinitum, okay? This is just how contracts work. And let me give you an example. I want to give you a really quick example of a case. It's a case called McCook versus Cousins. It was decided by a Georgia court in 1869. This is 8 years after the Emancipation Proclamation was issued, 4 years after the Civil War ended. This, in McCook, it involved a contract to share proceeds in cotton, the cotton that was produced on some land. McCook provided the land. Edmund, whose last name was never provided, was a recently emancipated slave, and he provided the labor. McCook sold the cotton for $841.21. Edmund, however, had a profit-sharing agreement with Cousins. And so Edmund ended up only being entitled to recover $210 approximately of the cotton produced on that property through his labor. McCook, however, was able to prove that Edmund owed him $571 for provisions that McCook provided to Edmund and his family over the course of this contract. And so the result is that after the contract was fully performed, Edmund owed McCook $361. And then McCook ended up, this is what he ended up with. He remained the owner of his land. He ended up with his and Edmund's share of the cotton, and he now owned the amount of Edmund's remaining debt. So right, wrong, fair, unfair, efficient, inefficient, it doesn't really matter, because at the end of the day, contracts and contract law really does help create and perpetuate inequality, because again, the contract is going to be enforced. It's enforceable and it's going to be enforced. So that said, contracts and contract law also help to create devastating social consequences, because contracts and contract law are at the center of a lot of systemic problems present in American society. So here's where I want to revisit the housing market crash that precipitated the Great Recession. So the story that I'm going to tell, it's going to start with a story involving Mary Smith. She is a 32-year-old single African-American woman who was sold a subprime mortgage loan to purchase a single-family residence in a predominantly minority neighborhood. And all of these facts are pretty significant because the research and studies show that subprime loans are predominantly made to younger single or divorced women of color living in minority neighborhoods, and that African-American women were disproportionately represented among this demographic. Now, Mary Smith didn't actually qualify for the loan that she was sold, but the bank never told her this. The terms of the loan that she was sold included all kinds of high prepayment penalty provisions, high origination and post-origination fees that actually totaled about 20% of the total loan amount, and of course, a really quick adjustable rate mortgage. The bank sold a lot more of these predatory subprime mortgages to a whole bunch of other people. The subprime mortgages were then bundled and sold as risky mortgage-backed securities. The Federal Reserve eventually raised interest rates, which made the price, the monthly payments on the mortgages too costly. Borrowers started to default. So demand fell, as did the housing prices. The mortgage-backed securities became worthless, essentially worthless. The housing market crashed, which precipitated the Great Recession. At the end of the day, the banks got bailed out. And Mary Smith did not. She lost her house. And yes, absolutely, a lot of things contributed to the housing market crash: deregulation, banks, the hedge funds, right? Everybody doing all kinds of stuff, and just out and out greed. But at the center of it all, right, I think the thing that we tend to overlook, because it's such a massive problem, the center of it all was a contract. The center of the problem was a contract. Because Mary Smith's mortgage on the house was a contract. And that subprime loan that she was sold was a valid contract. And it would have been, and probably was, enforced, assuming it ever made its way into court. So while the Mary Smith story is different from Edmund's story from the McCook versus Cousins case, they're eerily similar, right? They're eerily similar because the results seem similar for Mary Smith, meaning in 2010, when she would have lost her house, she lost her house, and then she still owed the bank the balance of the mortgage loan. The bank, on the other hand, owned the house that Mary just lost, and also owned the remaining debt, which constituted the balance of the mortgage loan. The systemic effects of all of these individual contracts being bundled together are still being felt. So just a really, really quick thing, the haves come out ahead again, right? Because the banks have actually more than recovered since the Great Recession. So there's some stats up there, right? JP Morgan Chase is doing like $1 trillion better now than it did before the Great Recession. African Americans, not so much, right? African Americans, not so much. Medium household income, $62 more in 2017 than they had in 2007. And like I said, the stats speak for themselves. In the last couple of minutes that I have, what I want to do is just talk really briefly about the fact that contracts and contract law help produce profound social consequences and systemic social consequences. That said, the role is going to go largely unnoticed, and it's going to go unnoticed because contracts and contract law are always and only understood as private transactions between private parties. And so the fact that they actually produce profound social, meaning public consequences, is something that can be and is ignored. So the question really becomes, right, why do so many of us believe that only private transactions between, that contracts and contract law are only private transactions between private parties with no public impact? To understand the answer to this question really means that we have to understand ideology and how it's reproduced in the field of contract law. So I don't have time to get into all of the ins and outs of this. In a nutshell, right? In a nutshell. And I don't think I'm going to be able to get to this, but let me just set some stuff up. For the social world to work, we have to have a common understanding of how we think it works and what the rules are about how our interactions are going to take place, et cetera, et cetera. So how we end up talking about something, how we actually end up talking about something, how it gets discussed, literally shapes and defines our reality, right? This is what happens. Emancipation, actually, it's not the beginning or the end of the discussion about private contracts being private and so on and so forth, but it is a critical moment in this particular discussion. I am actually, I see I am out of time and I don't want to go into this more. I wish I did have some time to get into it more, but I think I will stop there and in a way just leave you hanging. So thank you.
Thanks so much, Professor Hart. That was terrific. Our second panelist today is Kenya Covington, who is lecturer SOE of Public Policy at the UCLA Luskin School of Public Affairs. Dr. Covington teaches courses on housing policy, introduction to public policy, research methods, forces of urbanization, social inequality, and urban poverty. She joined the public policy faculty at the UCLA Luskin School in 2017. Dr. Covington conducts empirical research that examines social and economic inequality associated with the structural makeup of metropolitan areas. Her work suggests ways to better utilize social and urban policies that likely mitigate disparities in economic opportunity and well-being overall. Over her career, Dr. Covington's articles have appeared in the Journal of Urban Studies, Brookings Institution Policy Briefs, the Journal of Urban Affairs, the International Journal on Economic Development, the Harvard Journal on Legislation, the National Urban League's 2003 and 2004 publication titled The State of Black America, and the Review of Black Political Economy, among other publications. Professor Covington's topic today is a critique of urban renewal and the neighborhood stabilization program in its contribution to spatial inequality. Professor Covington.
Thank you. Hi, everyone. Good morning. Let me just thank the Southwestern Law School for inviting me. This is a good opportunity to share with you what I've been thinking as of late and some of my research. The title actually was updated. And so let me just share with you the title, Growing Concerns About Spatial Inequality in the COVID-19 Economy, Reflections on Place-Based Policies. And so I will be talking about inequality, but spatial inequality in particular, okay? My slides, I should share. Okay. Okay, so I'll talk about the COVID-19 economy, just provide some background, the compounded economic shocks, spatial inequality, and how it dovetails with the COVID-19 economy and how it will grow if we don't get a handle on things. And I'll talk about place-based policy solutions that we might want to incorporate into the COVID-19 responses. And so, as you well know, we're under siege right now. COVID-19 has impacted the US in a particular way that it hasn't impacted the world. And so, in part because of the leadership, behind our response to COVID, we've seen much greater cases and greater deaths. And so there are over 25 million cases of COVID in the US currently, with over 427,000 deaths at the end of January this year. So with cases and death counts certainly growing every minute. And so in the US, we have more than 25% of the world's COVID cases and more than 20% of the world's deaths. And so this puts us in a particular pernicious situation. And so as the COVID economy has hit us, given the pandemic that we're experiencing, we're also seeing, you know, in comparison to the previous Great Recession, more than twice as many jobs were lost at the beginning of COVID-19. And between March and April 2020, as were shed during the entire Great Recession period, there is no clear understanding of when these jobs will fully return. Unfortunately, the evidence from the previous recession suggests that if we don't do things immediately and in big measure to alleviate the problems that we're seeing in the economy, we'll see this take more than 5 years to recover. And so we also see the major job loss that we're experiencing as well. And so what's even more troubling really is that the job loss that we're seeing is already long-term, right? More than 27 weeks or more jobless, that's about 37% of the total employed. And these effects are especially pernicious on vulnerable households. And so the economic shocks, job losses that is, have hit vulnerable families the hardest. And so in 2020, COVID-19 related job losses wiped out about 113 straight months of job growth in the US economy, with total non-farm employment falling by about 20 plus million jobs in April, and that's April of last year. And so the forced economic shutdown is employed by states to stem COVID spread hurt all workers, but the impact was greatest for women, non-white workers, lower wage earners, and those with less education. And so wage loss can cause large welfare cost of income fluctuations. And so what that means is generally Black households after an economic shock cut consumption by about 50%. And so that's consumption. Those kinds of cuts include cutting food, cutting the not being able to pay bills, so not being able to pay bills, so they fall behind. So they're cutting essential goods and services from their household. As well, Latinx households experience a welfare shock of about 20%. They're cutting about 20% of their consumption. And so this has real consequence to households. And so generally, families hurting now were already severely burdened by housing costs as well. So rent moratoriums and foreclosure forbearance policies for federally insured loans have stemmed the massive waves of evictions, but only for the moment. Many families are currently at risk, and without real action, we're likely to see something even beyond what we saw for the Great Recession with people losing their homes, eviction and foreclosures. And let me just say, the distribution of rent burden is is pretty clear by this map here. Mapping the scale and distribution of rental risk across the United States gives us some indication of how widespread, the rent burden is and risk for eviction. Here we see highly rent burdened households, those spending greater than 50% of income on rent, compounded by COVID-19 related job losses. And so the COVID-19 economy presents an imminent risk to housing stability in the US. If more is not done to stem the economic and health hardships, today over 19 million households are at risk for eviction and homelessness, setting the stage once again for long-lasting financial harm to our most fragile households. For the second time in less than 2 decades, American families face Great Depression-like economic contractions between 2007 and 2010. The Great Recession caused approximately 3.8 million households into foreclosure, causing deep wealth losses coupled with long spells of unprecedented employment. And so the last period of economic recession created housing instability that many vulnerable communities are only recently recovering from, or if at all. And so the bar chart here provides some indication of who actually has not recovered, right? Which families, which groups have had difficult time recovering from the last recession. And so the bar charts represent the 2017 median net worth. So how much equity, how much assets do households hold in 2017? So that's the striped bar. And we'll see, there's some great variation in median net worth for households. And so the question, looking at this figure, is who was able to achieve median wealth back to the level that they were in 2005, pre-Great Recession. And so here we see for these groups of people who I'm concerned with, whom the COVID-19 economy have hit hard, who was at a weak position, a weak economic position to start with. And so what we see mostly is that single family, single female households, Black alone, people with lower education, these fragile families generally had not achieved the median net worth that they held in 2005. By 2017, over 10 years, they had not gotten back to the median net worth that they held prior to the previous Great Recession. And now here we are embarking on another recession. So these households are in an economic unfavorable position to start with. Layer that with how COVID has been impacting families. And the pandemic is certainly twofold, both widespread, offering everyone in society in mundane ways through social distancing, including stay-at-home orders and online school, only to concentrate more pernicious effects in especially vulnerable communities. Inequities in the social determinants of health, income, and wealth, healthcare access and utilization, education, occupation, discrimination, and housing are interrelated and put some racial and ethnic minority groups at increased risk of contracting and dying from COVID. The figure shows that vulnerable communities are being devastated. Their health and well-being are being challenged like never before. So on average, communities socially vulnerable are more likely to experience higher death rates. So high vulnerable rates. High vulnerability counties are places where there is a concentration of individuals facing elevated poverty, unemployment, lower income, and less educated. They're seniors and households with greater number of minors or minors with disabilities. Parented by single parent households, racial or ethnic minorities, or those with English speaking barriers, and those in high density housing or mobile homes, experiencing crowding and no access to a vehicle. On average, the cumulative death rate for members of high socially vulnerable counties experience at least 45 more deaths per 100,000 people than the least socially vulnerable counties. And so death rate disparities for most socially vulnerable are surpassed by high poverty counties and high Black counties, as well as high Hispanic Latinx counties, populated counties, highlighting the dire need for relief for these neighborhoods. Overall, communities of color, both Black and Hispanic, experience higher death rates relative to their share of the US population. And so this is the compounded effect of the COVID, the previous recession, and the COVID economy on socially vulnerable communities. And so now I want to just move into exposing you to this concept called spatial inequality. Let me give you a little background. Spatial inequality in America is largely invisible. Those not experiencing this form of inequality can easily escape it. Think what Robert Moses did. We put highways around it to escape the reality of intense, concentrated racial and economic inequality. Spatial inequality is evidence of extreme neglect of spaces and the people that exist in those spaces. The COVID-19 pandemic has laid bare spatial inequality in the US. The people who have been hit the hardest by the COVID-19 economy reside in these places. Society can't solve the COVID problem without considering the spatial dimensions of the pandemic. And so spatial inequality incorporates multiple inequalities. Economic, social, and racial inequalities intersect across geography to generate spatial inequality. Mathematically, one can think about spatial inequality as a cube of inequality. Generally, spatial inequality is intense and concentrated. It permeates every aspect of a place. And geographically, spatial inequality is concerned with the spatial dimensions of uneven distribution of key resources, opportunities such as income, accessibility to healthcare, food, housing, or other goods and services by race, gender, and class. And so this is a depiction of what racial inequality, of what spatial inequality is. And so these stark differences between spaces equate to real differences in material well-being and with regards to access to opportunity. The pernicious effect of COVID-19 on racial and ethnic minorities is related to exploitative business practices and a decade of government policies that have systematically disadvantaged Black and Brown communities. Historically, housing discrimination effectively limited residential neighborhoods, and workplace discrimination created income and wealth disparities that rendered African Americans and Latinx households more at risk. As a result, racially restrictive covenants and redlining practices, among other policies, help to determine the location, quality, and residential density for people of color. Black and Hispanic people are more concentrated in the same high density urban locations that were most affected in the first months of the pandemic. Moreover, the isolation of Native populations on reservations without access or the means to grow nutritional cultural food, staples core to the indigenous diet, compromised immunity and set the stage for poor health outcomes. Social distancing is a critically important response to the pandemic, but it also assumes that residents have adequate space, ventilation, services, and social safety nets to survive such an order. This is simply not the reality for many households in the US. The welfare costs of social distancing were higher for these households. They gave up consumption of essential goods, food, education, resources, physical activity, and other core essentials, such as residential air quality, that will extend the inequalities that they'll experience. And I think I'm getting short on time here. And so just to wrap up, addressing the legacy of spatial inequality is important. And we have to do this through the kinds of policies that we're going to consider in this period, right? Severe loss of businesses in communities, loss of social and human capital for local communities, massive rental eviction, likely foreclosures to follow. And all of this leads to forced displacement because of the effects that this spatial inequality will have on individuals. And I'll stop there. And certainly I have more to say, but maybe we'll get to some of it at Q&A. Thank you.
Thank you, Dr. Covington. Our third panelist today is Veena Dubal, who is Professor of Law at UC Hastings School of Law. Professor Dubal's research focuses on the intersection of law, technology, and precarious work. Within this broad frame, she uses empirical methodologies and critical theory to understand the impact of digital technologies and emerging legal frameworks on the lives of workers, the co-constitutive influences of law and work on identity, and the role of law and lawyers in solidarity movements. Professor Dubal has been cited by the California Supreme Court, and her scholarship has been published in top-tier law reviews and peer-reviewed journals, including the California Law Review, Wisconsin Law Review, Berkeley Journal of Empirical and Labor Law, and Perspectives on Politics. Based on over a decade of ethnographic and historical study, Professor Dubal is currently writing a manuscript, Driving Freedom, Navigating Neoliberalism, on how 5 decades of shifting technologies and emergent regulatory regimes changed the everyday lives and work experiences of ride-hail drivers in San Francisco. Professor Dubal's topic today is gig work and racial capitalism. Professor Dubal.
Thank you so much for having me. My talk really dovetails well with Dr. Covington's talk in so much as I'm going to be talking about COVID and the experiences of a particular group of people. Majority workers are in this economy are immigrants and people of color, but I'm going to be really honing in from a legal and anthropological perspective on what worker experiences and organizing look like on the ground for this particularly vulnerable workforce who are disproportionately economically impacted and exposed at work to the virus, and extrapolate on the future implications of their experiences during this time. So Esperanza texted me as I had just laid down in bed to sleep. It was Sunday night, March 28th. The 8th day of the coronavirus lockdown, and I had been doing nothing but childcare. She had seen a tweet suggesting that one of our mutual friends, Janie, was in trouble. Esperanza, an Instacart worker and organizer, and I had both gotten to know Janie in 2019 through alliances that had formed between and among gig workers during the fight to get AB 5 passed in California. Janie, who's a Lyft driver and organizer, was in physical danger. She had been housed for 4 months prior to the COVID-19 pandemic. because the building of her long-time apartment in economically booming Sacramento had been sold to a commercial developer, and because her only income was from Lyft driving, which is well known as an unstable form of income. Landlords consistently rejected her application. After the shelter-in-place orders went into effect, Janie had landed in her father's home, a place she described as, quote, her absolute last resort. He had been emotionally and physically abusive throughout her life, and that night, things had gotten bad. Janie's father, who suffers from mental illness, had stopped seeing his psychiatrist due in large part to the shelter-in-place orders and had stopped taking his medication. In an unprovoked violent rage, he kicked Janie out. Janie called the police, who helped her get back in, but not before her dad removed the lock from her door and took the keys in the house off of her keychain. In desperation and alone, she had tweeted into the void, "There is no safe space for me here, only turmoil." Esperanza saw the tweet, became concerned, and that's when she texted me. I, in turn, texted Janie, "Are you okay? Can I help?" She wrote back, "I'm safe now. He drunk himself to sleep. I'll be safe tonight." "You got to get out of there," I said. "I'm sending you money. Go to a motel." "No, please don't," she answered. "If I don't get my unemployment insurance check by Friday, I'll let you know." I and a few of my friends sent Janie money that night because I knew something that she hadn't quite grasped yet. She was not going to get her unemployment insurance check that Friday. In fact, because she had been misclassified by her employer for 3 years, she wasn't going to get it for 7 weeks. Janie spent the next week in an Airbnb and soon thereafter reunited with an old boyfriend. No one, she told me, should be alone in a pandemic. And for the past 9 months, Janie and Mark, both unhoused gig workers, have been camping and couch surfing. And until the evening of Tuesday, November 3rd, they had been passionately organizing to prevent the passage of Proposition 22 from passing in California. Both Janie and Mark are ride-hail drivers, but neither of them worked this summer. Janie has a heart condition and worried that if she had contracted the coronavirus, like so many of her coworkers had, she would die, as some of them also had. Her boyfriend, Mark, like many other ride-hail drivers, said that the demand was so low that even if he risked exposing himself and tried to work, he would end up losing money. Despite all of their struggles to find housing, to obtain food, this reality is what inspired both of them to organize and fight against Prop 22 and for employment status. I offer you this vignette to highlight the intense precarity and difficult choices that so-called gig workers have been facing amidst the pandemic, and the explicit and active role that not just gig companies, but also the state has played in their insecurity. So in California, as in many other places in the nation, ride-hail drivers and food shoppers and delivery workers, all disproportionately a majority people of color and immigrant workforce, fall under the category of essential critical infrastructure workers, workers that are allowed to continue to work during the state lockdowns. On the other hand, as misclassified workers, they've also faced insurmountable barriers in making legal claims of security and safety. Though AB 5 made clear that workers were owed basic state labor protections, government enforcers for many months waffled in systematically enforcing the laws on their behalf. So as this pandemic unfolded, I had been continuing an ethnographic engaged research study of self-organizing ride-hail drivers in California, the Rideshare Drivers United, or RDU, but had been winding down the research in hopes of completing a long-term book project. What followed for me instead was months of research on and advocacy with Rideshare Drivers United and worker organizers, including Mark and Janie. These drivers' life stories and experiences all reflected the same kind of immediate, dire insecurities that Mark and Janie faced. And indeed, many of them, immigrants and people of color, supported multiple generations of family. Some undocumented drivers had zero access to work or to emergency economic protections under the CARES Act. Janie and Mark, together with thousands of other gig workers, turned their attention to two primary issues from the end of March 2020 through early November. Through Rideshare Drivers United, they fought to get their colleagues unemployment insurance as opposed to pandemic unemployment assistance, and they organized against Proposition 22. Today, I really only have time to talk about the unemployment insurance piece of their organizing, but I want to talk about Prop 22 in the Q&A if we get to it. So I'm going to share very quickly just a graph so that you understand the differences between unemployment insurance and pandemic unemployment assistance. So pandemic unemployment assistance was created as a temporary measure by the CARE Act for independent contractors. State unemployment insurance, which was a byproduct of the Social Security Act of the New Deal, is what California workers get if they've been laid off through no fault of their own. State unemployment insurance is calculated based on gross income. So Uber, this is the income of a Lyft driver who I helped file for unemployment insurance. His gross income was $45,750. But if he extracted all of the expenses that were associated with driving, those expenses, including the Uber service fee, the booking fee, the airport fee, and the IRS mileage expense that accounts for gas and wear and tear on his vehicle, together his expenses were $24,000. So his net income was $21,000. So if he applied for pandemic unemployment assistance, which was based on net income, he would get $207 a week. If he applied for state unemployment insurance based on his gross income, he would get $440 a week. But if he applied for state unemployment insurance, because he was misclassified, he had to go through a whole different, extremely unorganized and very difficult process at the EDD to convince the EDD that he was a misclassified worker, despite the fact that California had just passed AB5 and despite the fact that Lyft and Uber had been, drivers had been getting state unemployment insurance for many, many, many years. And so many people just filed for PUA, despite the fact that they were owed more than twice as much under the law, because PUA gave them immediate benefits. They could get them just like this from the state. The companies blasted these drivers with emails encouraging them to file for PUA, did not tell them that they were owed state unemployment insurance. And the government didn't, at the highest levels, did not want to have to deal with this issue because of all the tech lobbying and political connections that these companies have. There was a lack of money, hundreds of millions of dollars in California coffers as a result of the fact that unemployment insurance taxes had not been paid by companies like Lyft and Uber. California was the state apply for a federal loan to pay for unemployment insurance. And it became very technically difficult to give these workers who the state didn't have records of their income, again, because the gig companies were not reporting their income, to get these workers what they were owed under state unemployment insurance. And so for all of these reasons, combined with the fact that there were hundreds of new workers at the EDD who were untrained in misclassification, there was just a crisis already built on a crisis of gig workers who are food insecure, housing insecure, disproportionately, again, people of color. Forgive me one second. Guys, I'm giving a talk. Just, Brian, if you could just, hi. Sorry, very tiny house, lots of people currently in our house. Okay, so how did workers respond? So interestingly, together with a sympathetic inside source in the EDD, they scripted a way for workers who called in to file for state unemployment insurance, those who could wait out the long period of time to get their unemployment insurance. They scripted something that they should say. This is drivers themselves doing this, and they advertised on social media via hashtags the extraordinary stories that the extraordinary stories of their precarious lives. They also created a mutual aid video showing people how to do this, how to apply for SNAP, how to think about their renters' rights in the course of the pandemic, how to find food banks. And they recognized that this situation was really, this UI situation was really a conundrum for many, many workers. So on the one hand, workers needed their money now. On the other hand, PUA did the cultural, if not legal work of cementing the idea that ride-hail drivers were independent contractors and not employees. And this was a really cruel choice that the state placed upon these workers. One of the drivers, Nicole, said, "We want to hold these companies accountable, and state UI will hold them accountable. But now PUA is dangling in front of us. And let's not joke. A lot of people are wondering how they're going to make May rent. Kids are hungry, and having a little bit of financial relief will be really good. So we have to think about the differences between UI and PUA, which is supposed to be for people who don't qualify for UI. So these gig workers are becoming experts on UI law and the way that law professors don't understand unemployment insurance law in the context of this pandemic. In slow and sporadic ways, workers who held out for UI began getting their checks in late May. That's, March, April, May. And this, according to my interviews with government officials, was a direct result of this driver-led campaign. The first driver that we know of who got his UI check, a single father of 5 who had been delivering pizza to make ends meet, except during the 2-week quarantine after his elderly father contracted the coronavirus, sent us all a video from his car in between pizza deliveries after he got his first check. Today is a good day. Today is Friday and we are in Ramadan. We are fasting. Anyway, when AB5 starts, everyone was laughing at me. What happened? You're going to fight Uber? Yes, I am doing it. Are you the one who's going to change Uber? Yes, I am doing it. And they laughed and said, good luck to you. But some people, they hold their dreams with me and we were walking together. Some people were just laughing at me, even my family members. But now guess what? And when the UI claim opened and we got $0 and they pushed us to PUA, which is less money and goes with the net, I did the appeal and I followed the Rideshare Drivers United guidelines and I did the appeal. I was telling my friends, hold on, you are going to get your rights, just apply for UI. And they said, no, we cannot wait. But I said, no, it is my right. I am an employee. It starts January 1st, 2020 by AB5. And today I get my benefits. And you can see here, and he shows his check, it's $450, the full amount as an employee, a full amount that I deserve as an employee. That's what they consider me, an employee. That's the date and that's my benefits. And I get $450 because I believe in our dreams and I'm using our tools, Rideshare Drivers United, to do that dream. So this UI campaign had some very important pro-worker effects, not just in the lives of workers, but also at the state level. As a result of this campaign and a similar wage campaign that began a month prior to the pandemic, Attorney General Becerra, alongside the city attorneys of California, sued Uber and Lyft to enforce the law. But analytically, what I want to highlight with this case study is what the bureaucratization of social benefits looked like and looks like for essential gig workers. The inconsistency of the application of laws to vulnerable people, primarily people of color, in the middle of a public health and economic crisis did very little to give workers faith in either the law or in public institutions. Worker organizing and informal connections with insiders became a substitute for the rule of law and reliable government. This experience combined with the passage of Proposition 22 has had what I want to call a pre-Wagner Act effect on gig worker organizing in California. Organized gig workers have come to believe that the state will only play a minimal role in addressing their precarity in the coming decades, and their strategies are no longer triangulated between government and corporate actors. Rather, they are organizing to make demands directly to the companies themselves. Many of them are immigrants with tenuous relationships and faith in US government institutions, and their fears and beliefs have only been cemented. This country, as Alvaro told me, is the same as the one that I left. These experiences, I hypothesize, will have ripple devastating effects, not just for the will of these workers to enforce and mobilize around state and federal rights in the coming years, but it may also have broader ideological effects in shaping faith in the rule of law and state initiatives, like I am devastated to say, vaccine distribution. Thank you.
Thank you so much, Professor Duval. Our fourth and final panelist today is Robert St. Martin Westley, who is the Louisiana Outside Counsel Health and Ethic Foundation Professor of Legal Ethics and Professional Responsibility at Tulane University Law School in New Orleans. His research and teaching interests are in the fields of critical race theory, constitutional law, philosophy of law, law and literature, and the legal profession. He's the author of Restitution Claims for Wrongful Enslavement and the Doctrine of the Master's Good Faith, which appeared in The Social and Legal Construction of Whiteness, an Interdisciplinary Analysis, published by University of Mississippi Press in 2016. He's also the author of First Time Encounters, Passing Revisited, and Demystification as a Cultural Practice, which appeared in the Yale Journal of Law and Social Policy in 2000. He's currently working on a book on reparations for historical injustice. He will present and discuss his work in a workshop, Critical Race Theory for the New Millennium, at the CAS, and will be giving a lecture at the LMU Munich on the topic of, can there be racial reconciliation without reparations? Professor Westley's topic at today's panel is discussing reparations. Professor Westley.
Thank you so much for that introduction. And I'd like to start by thanking the organizers of this symposium, the Law Review. I also would like to thank the BALSA students and to give a special shout out to Professor Danielle Hart for inviting me to be part of this panel, and a special thank you to Abraham for all of the help he gave in making this happen. As part of my presentation, I was asked if I would submit a sample of my work on reparations, and what I offered was an essay that I recently completed, which is entitled What Every Law Student Needs to Know About Reparations, that I was asked to write as part of a volume that will be published by Oxford University Press. What I'd like to do today is first talk about a few of the themes that I've had to deal with in writing and researching the topic of reparations. The first being the importance of being alert to temporal frameworks when engaged in discussions about social and racial justice. I also have a few comments I wanted to make about the starting point for reparations before then turning to the issue of why reparations for historical injustice. So, as for the importance of being alert to temporal frameworks when engaged in discussions about social and racial justice, I think attentiveness to time encourages both a comparative and historical analysis, countering the tunnel vision of exclusive focus on current conditions and present claims. I think it also helps to name and identify particular forms of inequality or injustice. For example, structural or institutional racism that might otherwise go unaddressed because it has been normalized. Beneficiaries of structural inequality tend to normalize unequal social relations through attribution of their social advantages to things like merit, intelligence, or even luck, rather than more insidious practices of exclusion and domination. Policies that may seem neutral or natural, like the system of inheritance, can mask the accrual of unearned and unequal privilege. So correcting injustice, moreover, should never be equated with the commission of unjust acts, and here gain consciousness of how current social conditions developed over time as a result of past inequalities is helpful in distinguishing injury from compensation for injury. So the starting point for reparations, in my view, is any uncompensated mass deviation from respect for human dignity under the color of law, which is in fact a violation of the rule of law. So reparations, therefore, in my view, is not a species of ordinary justice. Its extraordinariness means that it will be extremely difficult to achieve or implement under ordinary conditions. Moreover, what I refer to as grand bargain reparations are not the only worthwhile steps towards repair of mass injustice. It is just the hardest step to mount in a process that can take generations to work through. Examples of smaller steps or so-called micro reparations might include symbolic gestures that acknowledge the wrong done, such as the Stolpersteine that you see in Berlin, Germany, that are memorialize the Holocaust and Holocaust victims, or material measures that fall short of full rehabilitation of those who have been injured. So in judging the adequacy of reparations, the scope of the remedy should be commensurate with the harm done. Adequacy, therefore, will require the fullest possible reckoning of injury, not to revive trauma or merely to assign blameworthiness, but to establish benchmarks for restitution and repair. And in this process, beneficiaries of mass atrocity, no less than perpetrators, do not get to determine independently from mutual assent of victims the conditions precedent of their own exoneration. Full reparations cannot be achieved separate from a substantial political transition in the society where the mass atrocities occurred, and establishment or reestablishment of the rule of law. So from that standpoint, I want to share some of the insights that I shared with you in writing from my article on what every law student needs to know about reparations, focusing on the theme of why reparations for historical injustice. There are several reasons that a society may decide to offer reparations to victims of historical injustice in the absence of an existing legal obligation to do so. As the moral views of the society evolve, past practices that many may have once considered acceptable can become unacceptable to the majority. In order to demarcate a clear break with a prior regime that promoted or tolerated the newly unacceptable behavior, it may be insufficient simply to prohibit that behavior in the future, especially when the consequences of the behavior have a lasting impact on those who are harmed by it. Reparations provide a means for society to show regret or remorse for unjust harms inflicted in the past. Ideally, reparations should be accompanied by an apology to those who were harmed by the wrongful behavior. However, even apologies may be viewed by victims of state-sponsored injustices as meaningless words unless accompanied by both material and symbolic acts that demonstrate a sincere intention to repair any harm that has been done, as well as a firm resolve not to inflict similar harm in the future. Through the acceptance of accountability for past wrong, reparations can make reconciliation between formerly adverse social groups possible. The importance of the relationship between accountability and what I refer to in the paper as entity liability in cases of reparations for historical injustice is extremely relevant here. Nevertheless, accountability and blameworthiness should not be considered synonymous. The most general sense of accountability is an obligation to give an account of one's own actions. The need to give an account implies that the person held accountable has a story to tell in which access to important aspects of what happened are not transparent to those to whom the account is given. Thus, those held accountable inevitably tend to appeal to mitigating circumstances, such as excuse, justification, or even denial. It is only when certain facts have been established beyond doubt that accountability can lead to a conclusion of blameworthiness. In the case of reparations for historical injustice, a recurrent difficulty for advocates who wish to hold others accountable is the refusal by those sought to be held accountable to offer any meaningful account of their actions. The assertion of accountability is most often met by its denial in the form of silence or refusal to give an account. Because those directly involved in the enforcement of the apartheid regime in South Africa refused to be held accountable, it became necessary through the Truth and Reconciliation Commission process to offer amnesty in exchange for accountability. As a result, the victims of apartheid were required to accept a political process that valorized reconciliation without providing punishment to perpetrators for wrongdoing or meaningful material reparations to victims. Advocates of reparations have occasionally resorted to litigation as a means of compelling accountability. This approach, while leading to mixed results, most often results in failure. Lawsuits seeking reparations for slavery and Jim Crow segregation have established a record of courts denying jurisdiction on the grounds of lack of standing by the litigants, sovereign immunity of state actors, or the statute of limitations on the relevant acts of violence, without ever reaching the merits of the claims brought before them. In the language of the courts, these cases were dismissed, quote unquote, without prejudice. This language seems to have the legal effect of preserving the underlying substantive claims for further adjudication, but thus far, this legal formula has functioned as a final disposition on the merits in the courts. Even when the parties bringing forth claims for reparations are state actors, as is the case with the nations which compose the membership of the Caribbean Community, also known as CARICOM, those claims for reparations have thus far mostly succeeded in prompting denials and silence from the former colonial powers such as Great Britain and other European countries that participated in the African slave trade and the racial enslavement of Africans throughout what was once known as the West Indies. None of the former colonial powers in Europe has appropriated money to compensate descendants of enslaved Africans. However, there has been a modest effort to sponsor further collaborative research between the University of the West Indies and Glasgow University in Scotland on the topic of slavery. Just as everyone who is held accountable is not blameworthy, not everyone who is blameworthy is equally so. From a moral standpoint, there can be degrees of blameworthiness, where some may be considered directly and personally responsible for unacceptable behavior as a result of their intentional acts. There are others who are only indirectly responsible by virtue of their associations or affiliated status. Still others may have an even more attenuated relation to bad acts that other actors commit. These individuals with attenuated relations to bad acts may derive unjust benefits, whether knowingly or unknowingly. However, they would have never given direct assent or approval to the bad acts. These distinctions among those who might be considered blameworthy express the possible range of statuses that the notion of complicity encompasses. Because the range is so broad, some may argue that complicity has no value in moral reasoning. One can imagine a moral universe in which only those in the first category, those who are directly and personally responsible as a result of their intentional acts, are considered blameworthy. However, if we then reflect on the example of racism, it should become clear why a more complex moral universe is desirable, one that includes some allowance for considering those who are merely complicit in the evil acts of others who are directly blameworthy for those acts. One argument that defenders of the European colonial powers who engaged in the African slave trade have made is that the Africans themselves willingly both participated in the trade and benefited from it. Since the Africans practiced enslavement among themselves and voluntarily traded other Africans in exchange for goods that European traders offered, the Africans should be considered complicit with any harm the African slave trade inflicted. Another complicity-based argument to which opponents of reparations for slavery sometimes resort is that during the antebellum period in the United States, there were some free Black people who held other Black people as slaves. Again, the argument implies that since some Black people were complicit in slavery, then there should not be reparations paid to any Black people for slavery. Those who make such arguments against reparations seem to fail to understand how deeply racist these arguments in fact are. The premise that underlies both is that collaboration in, association with, or profit from an enterprise that inflicts harm on some members of a group is somehow negated when it's done by other members of the same group. This form of argument trades on the assumption that the Africans who profited from the sale of other Africans to Europeans would have accepted the common characteristic of race as uniting them with their victims. It trades, in other words, on the false assumption that identity characteristics that might have mattered to European buyers of enslaved Africans also mattered to the African slaves or buyers of other Africans. No evidence has ever been shown that that is true. By contrast, there's overwhelming evidence that when it came to enslavement, race was a matter of great and determinate importance to European enslavers. The default assumption of racist is that once someone's race has been identified, that label tells us everything one needs to know about that person's views and interests. On the other hand, these complicity-based arguments also show that in order to combat racism, it may be necessary to consider blameworthy members of the victimized group who collaborated with or profited from the bad acts of those more directly and personally responsible. Plainly, some Africans were complicit in the slave trade, just as some free Blacks in the antebellum South were complicit in slavery. This does not negate the need to repair the damage of the slave trade and slavery for the vast majority of persons of African descent who suffer continuing harm due to these practices. There are many possible measures. I just want to check on how much time I have. Do I have a time?
Professor Wesley, you have about 2 minutes.
Okay. There are many possible measures of the continuing harm of historical injustices such as slavery. Racism is the most blatant and pervasive indicator of continuing harm. Too often, however, racism is dismissed as a matter of prejudicial beliefs of unnamed others rather than a structural feature of society that limits access to opportunity and advancement for people of color. By contrast to this minimizing view of racism's effect, the racial wealth gap is perhaps the most concrete measure of continuing harm that is directly traceable to the conditions that slavery and Jim Crow segregation imposed. From a purely economic perspective, slavery was a system of theft and plunder of Black labor. It allowed some white Americans to become wealthy, some of them staggeringly so, by legalizing ownership of persons of African descent and sanctioning the forced extraction of their uncompensated labor. Slavery was the origin of the racial wealth gap. Additional acts of plunder and racial exclusion in the generations that followed the constitutional prohibition of involuntary servitude augmented and replenished this gap. The racial wealth gap that exists today, on average, white Americans possess 7 times the wealth of Black Americans, constitutes an ineliminable barrier to genuine equality measures such as equal income for equal work and equal opportunity, even assuming these measures could be consistently enforced. So it appears that I'm out of time. I had more to say about continuing harm, and I also had more to say about the current state of reparations as it is in play right now in the political sphere. So maybe during the Q&A, I'll get a chance to address some of those issues. Thank you very much.
Thank you, Dr. Wesley, and thanks to all 4 of our panelists for those wonderfully rich presentations. So I'm told by Abe that we actually can go another 10 minutes until 12:20 for our Q&A portion. If there are questions, which I imagine there will be, and folks can stay around. So with that, I will open it up now to the audience. Please use Zoom's raise your hand function, and I will take questions in the order that they appear. It looks like our first question will be from Evan Martin.
Hi, thank you, Professor Wiseman. And I wanted to direct this question at Dr. Covington, specifically to ask about specific policies and actions to combat spatial inequality. And also, given the current political makeup of a conservative Supreme Court and conservatives continually barking socialism at any kind of progressive policy, if you see that as a hurdle and how to frame these policies to be able to have them successfully enacted.
Yes, thank you for that question. You know, I had I had more in my presentation that would have covered policy. But what I was hinging at with the title is that place-based policies are a good way to target aid to disadvantaged communities, to vulnerable communities. And so we do have some history with utilization of place-based policies, and it hasn't all been good. So place-based versus people-based policies, there is a distinction. People-based is direct aid to individuals, irrespective of place, irrespective of location, irrespective of how that disadvantage is concentrated. And place-based allows us to target help to communities that are facing a level of intense, concentration of disadvantage. And so we can look in our history at policy that we have used. Certainly urban renewal, a post-World War II program, is not a good example of how to use place-based policy. Urban renewal targeted places that were disadvantaged, but they targeted for the removal of so-called slums and blight. And in rebuilding those places were rebuilt for the affluent, not for the people that they displaced. And so this generated, thousands of families and instability in families as those people were pushed out of those neighborhoods into other precarious residential situations in a period where housing discrimination was pretty robust. And so instability was clear. So, but what we've learned from that, and this is why I wanted to share with you the neighborhood stabilization program, which was a response to the Great Recession and the unprecedented foreclosures that were being experienced around the country. So in pockets, foreclosures were concentrated in particular pockets. And so the neighborhood stabilization program was meant to address that. Now, it was not perfect, right? I think Danielle Professor Hart offered that we should have done a lot more for homeowners. And so the subprime mortgaging definitely hurt and harmed lots of families. And so we should have allowed people to stay in their homes, and we should have created a situation where we allow people to redo their loans and forgave the difference in equity. And so what we have learned now is that place-based does have, can be effective, but we have to do it in a way that is targeted, utilizing criteria, and it has to be administered at the local level with utilizing these tools that are creative on the one hand, but also allow us to go directly to the communities that are being harmed. Now, under the Biden proposal, we see a great number of policies as a part of his overall description. And some of these policies are meant to go to address communities, right? Small business loss. They're meant to address schools. And so take, for example, what he is intending to do with schools. Right now, it's a pretty broad response to addressing COVID and getting kids back into schools. But what he is not doing that I think could benefit from a place-based strategy is that, you have to consider the quality of the school, right? You cannot send students back to school without addressing the ventilation problem in this COVID environment. And so these are the kind of place-based, you need to identify those schools that are systematically in disrepair, systematically have not received the kind of maintenance funding that they should have been receiving over the years. And so this is the kind of effort that should be taken in order to effectively address that portion of the effort. And I'll stop there. Sorry.
Thanks, Professor Covington. So the next question we're going to take is from Dorna Kazeni. Dorna.
Hi, I want to thank Southwestern and UA for bringing us this wonderful symposium. It's been most edifying, such an array of really brilliant speakers. My question is for Professor Duvall, whose work I followed closely over Prop 22. And I wondered if she could speak to the fact that that law now requires a supermajority to be overturned, and what kind of grassroots or other efforts are envisioned to advocate for the rights of gig workers.
Thank you so much, Dorna. It's such a good question. The California Supreme Court declined to take the question of whether or not Prop 22 is unconstitutional based on the 7/8 provision, which basically says that in order for the California legislature to legislate at all in the arena of workers' rights, which would ultimately be seen as an amendment to Prop 22, that they have to have a 7/8 majority. So that means that in an area, in a moment of crisis, if the California legislature or even cities wanted to legislate to provide some kind of stopgap measure, some temporary measure, they couldn't do it. So it is a really sort of problematic, anti-democratic aspect of this proposition that that we were hoping the California Supreme Court would see as unconstitutional, but they declined to take it without prejudice. So where do we go from here? I think it's important to understand Proposition 22 as an attempt to create a different wage code for a primarily people of color workforce. I think we can understand this as differential race codes. So this was a debate that was had by Congress and the Joint Congress and the NAACP and African American leaders during the national before the passage of the National Industrial Recovery Act, and certainly during the debates that followed the Fair Labor Standards Act, or that preceded the Fair Labor Standards Act, whether or not certain workers, particularly workers in African American workers who occupied industries that were fully occupied certain industries, whether it made sense to have different wage codes for those people. And ultimately we decided no, and sort of a history I won't get into, but I think we need to understand Prop 22 as this, as lower wages, less security for a Black and Latinx and immigrant workforce. They want to spread this law all over the country. These companies, they want to spread this formula to other sectors, to gigify healthcare, to gigify education, to gigify the restaurant industry, retail. They've publicly, venture capitalists are publicly saying that that's what Proposition 22 has emboldened them to do. And so we really have to see swift action at the federal level. I'd like to see Congress pass the PRO Act, which was introduced yesterday, and would expand the number of people who have organizing and collective bargaining rights in this country, and also legalize some of the direct action tactics that have long been illegal since the passage of Taft-Hartley. I think there's a lot that can be done at the Department of Labor level. David Whale and I have argued that Prop 22 is in violation of the Fair Labor Standards Act. Congress did not intend for app-based workers to be carved out of minimum wage protections. So it's really, the ball is in the court of the Biden administration, and I truly hope that the administration is able to see this for what it is, which is another page, another ugly, disgusting page, using facially neutral language in the book of racial capitalism.
Thank you, Professor Duvall. Our next question is going to be from Jade Harvey. Jade.
Firstly, thank you for this wonderful symposium. Secondly, I was actually wondering about the possibility for reparations to be done through property and space.
Was that the end of your question, Jade? Reparations through property and space? Professor Wesley, do you want to address that?
I'm not sure if I really followed the question. Could you restate it, please?
I was wondering about the possibility of reparations to be reconstituted in a way that property and space could be given.
The form that's a great question. The form that reparations takes is something that is, of course, something that is contested among even among reparations advocates. Everyone has their own ideas about the best way to do this. So there are those who argue that there should be geographic spatial reparations. And I express no opinion on that. I'm not opposed to it. I haven't really formulated my own thoughts about how exactly that might work. I think that we're still very much at the threshold of this issue. it's only very recently during the last presidential election cycle that House Bill 40, HB 40, started to gain the kind of political momentum and support in Congress that would allow for there to be a commission to study the issue of reparations. And still, even more recently, California became the only state jurisdiction that passed a bill that would impanel a commission to study the issue of reparations. I think we need a lot of study before we begin to take very strong positions about the particular form that reparations should take, because we also have to, as I said in my comments during the talk, we have to be very careful to study the extent of the injury. I don't think that we really understand the entire extent of the injury yet in order to be able to have strong views about the form that reparations should take. Certainly, I think that the racial wealth gap is one significant and important measure, but there are other measures as well.
Thank you, Professor Wesley. Let's go with Alexandra Christensen.
Thank you. I have a question for Professor Hart. In your opinion, what are some ways we can transition from thinking of contracts as purely private arrangements to a broader understanding of their impact on public life?
So that's the million-dollar question, you know. So part of it is literally having to shift the frame, to shift the way it's just understood. So the part of the talk that I wasn't able to get to was really the part of the talk that explores, you know, how is it that we all come to understand the world a particular way, right? And the thing I was going to focus on to show how part of this idea, a big part of the idea that contracts are private and you're responsible for yourself, really the emancipation and the debates around emancipation by members of the Reconstruction Congress set all of this up, and then you could see how it then gets reproduced in contract law. So this is just one of the many ways in which our common understandings of the world get shaped. And so this is another reason why I think, just as a general matter, right? Why does the world work the way that it works? Why do we believe the things that we believe? This is also why I think it's so hard to make this inroads with racial equality or any kind of equality, because you're butting up against not just one institution, not just one little thing. It's everywhere. Everything is kind of set up in a way to just maintain stability, for lack of a better word, and how those meanings get produced, it's an entire field. But so one of the ways to do it is we have to start talking about it differently. We have to start highlighting the fact that when you aggregate all these contracts, it has these profound effect. And then you can disaggregate it and still see the effect. And I think Professor Wesley was talking about this. I think Professor Covington was talking, right? That you can see how the impact on one person, then the impact on community, and then that those impacts are just long lasting and very, very, very hard to recover. But I think the short answer is you've got to change the frame. You've got to change the way people understand the world. And that's a really, really hard thing to do. Which is why I've been saying these things for like 20 years now. No, I mean, I'm not even kidding. You know, I'm actually not even kidding. I have been saying similar kinds of things for like 20 years. And I don't see a lot of movement yet, say, for example, at a contracts conference. You know what I mean? But you just keep doing it. Yeah. Thank you for the question.
Thanks, Professor Hart. I think we have time for one more question, and for that we will go to April 2.
Hello, my question is for Dr. Wesley. I know he mentioned the California Assembly bill that was passed that formed the task force for reparations in the state. I actually had a heated discussion about this with my family last year when it came on the news. And I wanted to ask what your thoughts on about the compensation issue, because that seems to be, at least as the regular people, their first question is, how is that going to work? How is that going to affect us? And what you think will come out of this bill, because I know it has an end date in 2023. And with all of these issues surrounding how reparations will work and the differences in compensation, how is that going to play out? Do you think what will come out of this? I mean, is it just going to be hopefully more dialogue to be had, or can we possibly see something positive come out and actually come into effect in terms of reparations?
Thank you for that question. I hope that something positive comes out of it. This has been a long time coming, right? It's something that you know, it's hard to imagine that these are discussions that have been going on since the time of slavery. What should be done? Even since before slavery ended, these discussions were taking place, and yet precious little actually has been done. So I'm hoping that something positive comes out of it. I think that there are many different facets to the problem. And in my experience in working on this issue of reparations, those who oppose the idea typically do so by thinking about or focusing on just the whole notion of giving people money or giving people a check. And long before we ever get to that point, I think it's important to understand the history, understand how this problem got created, understand what its impacts are, and then we can look at the range of possible remedies that could be applied. You know, some of the ideas that have been put forth under the rubric of reparations discussions has been zero interest loans to the beneficiary class who have been harmed, free college tuition, community development money. There's all kinds of ways of doing this that doesn't necessarily end with just giving people an individual check, which is not to say that I'm opposed to giving people checks if that seems appropriate. But I think that we first have to build consensus around what the history is and how did the problem get created. And I don't believe that we're there yet. You know, I teach at Tulane. I'm originally from New Orleans. I'm a New Orleanian by birth. And, you know, what's happened here in various parts of the South is an attempt to take down the Confederate monuments and statues. I actually think of that as a form of symbolic reparations that we can start on now. We don't have to wait. But I think with other things, we have to do the research, and we have to then, after having done the research, we have to educate the public. And in educating people, we then build consensus among people of goodwill that this is something that we really need to do as a society in order to deal with something that is often referred to as America's original sin, but then nothing is ever done about it.
Well, thank you, Professor Wesley. I think we are out of time, but I want to thank all of our panelists for terrific presentations and really just thank everyone who was present for a very rich discussion. A huge thank you to Abe Brand, Erica Jansen, and the entire staff of the Southwestern Law Review for successfully organizing such a wonderful symposium during a challenging time and under challenging conditions. Thank you. I'm now going to hand the floor back to Abe. Have a great afternoon, everyone.
Hello, everyone. I'm so excited to be able to participate today and to see the amazing combination of the devotion of our law review students, of our faculty, and of the many of you who have so generously agreed to participate in this program. Law reviews are highly unusual institutions because they are, I think, almost unique in the world of higher education because they're edited by students. What I've admired about Southwestern is the collaboration that faculty and students engage into leading up to this annual symposium every year. I won't take the time to thank all of the people that Erica thanked this morning, our wonderful editor-in-chief, Erica Jansen. I do want to note the special contributions, though, of Abe Brand to this effort and so many others. And of course, Danny Hart, who had the original conception for this. To all of our speakers and panel participants, what an extraordinary experience it has been this morning, learning from you. It's been exciting, illuminating with a lot of detail, the detail that you're using to inform the broad public policy questions that are so important. Well, I have the honor of introducing a remarkable, and I will say young woman, although she is very established in the academy and beyond. Our speaker today has been a law professor for about 13 years, and she's currently the Vice Dean for Faculty and Academic Affairs, as well as Professor of Law at USC. That appointment was preceded by her initial full-time tenure track appointment at Florida State, where she was honored with an endowed chair. And that says a great deal for a person only so few years in teaching. Before she started her teaching career, she had two valuable clerkships, one with Judge Claire Williams of the United States Court of Appeals for the 7th Circuit, and prior to that with Federal District Court Judge Ruben Castillo of the Northern District of Illinois. Vice Dean Tolson is a graduate of the University of Chicago Law School and soon will be a visiting professor there. I don't have the words to describe what a big deal that is, to be asked to come to the faculty at the law school where you went to law school. I'd like to ask the students to think about that. Your law school knows more about you than any other possible law school, any other law school could possibly know. So congratulations to you on that accomplishment, along with your many others. Professor Tolson's scholarship often uses history to illuminate public policy problems of today. She focuses on a wide range of topics that include partisan gerrymandering, political parties, the Elections Clause, the Voting Rights Act of 1965, and of course, the 14th and 15th Amendments. Her research has appeared in the most prestigious law reviews. But beyond this achievement of the quality of this scholarship, she's a person who really makes a difference. She's a nationally recognized expert in these fields who's been called upon in the media by, asked to writing for places like the New York Times, appearing as a commentator for others. These entities include Reuters, Bloomberg Law, and during this most recent election cycle, she was regularly called upon by CNN. She contributes to the more direct development of the law as well. For example, she's testified before the House Judiciary Committee regarding the reauthorization of the Voting Rights Act. And I want to emphasize that you don't just volunteer to do that. You have to be asked to do that. That too is a big deal. She's authored a legal analysis that undergirds an amendment to the United States Constitution that's been introduced by Senator Elizabeth Warren and Senator Richard Durbin that would explicitly protect the right to vote. Last night, I decided to listen to her most recent podcast, her most recent offering in her election-themed podcast, which is called Free and Fair with Franita and Foley. The Foley is Ned Foley of Ohio State law faculty. It was fun and fascinating. So I am honored and excited to welcome Vice Dean and Professor Franita Tolson and to say to you all that you're going to have fun.
Thank you so much, Dean Prager. That is probably the most gracious introduction I've ever received. I mean, that was awesome. Thank you so much.
you provided the material.
I am so happy to be here. I have to say, I know that these events are the collaborations of many people, the law review, faculty members, students. But I have to shout out Abe. Abe was just on it, and I'm a person who tends to double book, and Abe made sure that I had all the information I needed to prevent myself from doing that. So thank you, Abe, and thank you guys so much for the DoorDash gift card and just all the thoughtful things that you did to really make this invitation just amazing. So I thank you. So I'm really happy that I get an opportunity to talk about some things that have been on my mind as of late. Even if the message is somewhat sobering, it is something that I've been thinking about in particular with respect to the things we saw in the last days of the Trump administration, although it wasn't new to me then, right? So this issue of democratic expectations and what our democracy needs to survive has been something that's been pretty much top of mind for the last pretty much my entire career. But really the last 4 years have really revealed that we have significant challenges ahead of us. And in fact, the waning days of the Trump administration, which was punctuated by lies and spurious legal challenges and ultimately violence, for me, it raised significant questions about the legitimacy of our political system. And in particular, the system in which lies could take hold and fuel the possibility that because of the Electoral College, there can be an outcome in the presidential election that is so at odds with the will of the people. The fact that this undemocratic outcome was possible highlights the crisis of legitimacy that has always haunted the American democratic experiment. And I think this is why over the course of my career, this issue has been top of mind, but the events of late really drove home the urgency of our current situation. And in fact, it's not only the Electoral College, which, as we all know, enables the loser of the popular vote to go on and win the presidential election anyway. The Supreme Court has also told us in a case called Rucho versus Common Cause that some level of partisan gerrymandering in drawing congressional districts is okay. And this is okay even if it distorts the will of the people. And in either case, they're not going to police it anyway, right? So the victor goes the spoils, which, if you think about it, in a system that holds itself out as a democracy, that is a pretty profound pronouncement. And of course, there are other anti-democratic elements of our system. Each state gets 2 senators. It doesn't matter if the state's population is 4 million or if it's 40 million, like here in California. Some would say that that is also illegitimate. And while on some level, we accept that the Electoral College could lead to an outcome different than a popular vote, which has happened 5 times in our history. The recent attempted coup, I think, revealed an additional flaw that we haven't fully grappled with. That our system is so dysfunctional that had both houses of Congress been in one party hands, then we could have ended up with a different president today. This is a much more ominous proposition than a candidate losing the electoral college vote because he or she did not get enough votes in key states. Now, we can speculate on all of the reasons why such an outcome would be illegitimate or inconsistent with our democratic expectations, but I think we will find that expectations are all that has been keeping our democracy afloat. As the recent presidential election reveals, there are far too many flashpoints where something can go wrong, right? So you have Article 2's delegation to state legislatures to choose the electors. You have the meeting of the electors in December to cast their votes. And then Congress has its obligations under Article 1 to oversee the count. And then the vice president also has a role in overseeing the count, right? So you have too many actors with key roles and arguably partisan intent for one to be able to say that the Constitution dictates a particular process outside of the basic framework laid out in its text. There are simply too many outcome determinative questions that crop up during this process that we don't conclusively know the answer to. So, for example, can state legislatures allocate their electors differently following an election? And in doing so, essentially make the vote of the people advisory rather than binding. Another question, does Congress's role in overseeing the count allow it to determine competing slates of electors in contravention of the wishes of the state legislature that prefers a different slate? Again, can the vice president refuse to open a certificate from a slate of electors that he deems to be illegitimate? Right? These are all questions that came up over the most recent presidential election. And undoubtedly, these questions, depending on how we answer them, raise a prospect of some pretty illegitimate outcomes. But I wonder if it is because some of the answers to these questions do not align with our expectations as opposed to being prohibited by the Constitution outright. In fact, the fact that people are rightly surprised by just how I saw a little face. Excuse me 1 second. Sorry. Sorry, my kids are homeschooling. My son got an A on his test, so we celebrate. But to awesome, right? So the fact that people are rightly surprised by just how undemocratic our system is, I think, tells a bigger story about the state of our democracy. It's not just that we have all of these questions and issues that come up that we don't know the answer to, right? That the Constitution doesn't definitively provide a solution. It's just that it doesn't align with how we expect the system to work. And I think this is because the story is that we, the American people, have failed to properly constitutionalize how we see ourselves as a participatory democracy. Even if it's the standard by which we judge the legitimacy of our government, there is a gap between our expectations and the constitutional text. Now, to some extent, democratic legitimacy requires that we constitutionalize our expectations. And these expectations deal with our sense of how government should operate, because norms and practices are not always going to be enough. Now, this is not to say that our norms are never enough to guide us. After all, we have been guided by democratic principles for over 2 centuries, and the norms are often important for supplementing the constitutional text. There has been both constitutional and extra-constitutional progress in expanding the electorate, even if the progress doesn't perfectly align with our expectations. We often want more than our politics can give us at any particular time. So it's not unusual that there's a gap between expectations and text. Nonetheless, it turns out that memorializing our democratic expectations in the constitutional text is still really important, particularly when the Constitution uses words like Republican government. And the Constitution also enshrines protections for the right to vote that we, as a society, have often failed to live up to at various points in our history. And I want to point to another more serious risk of failing to constitutionalize our democratic expectations. As the baseline for what counts as legitimate government shifts away from the bare minimum that the Constitution requires, then political norms play an increasingly important role the further we depart from this baseline. If we get too far away from the baseline of the constitutional text, then it is actually norms rather than law that forces political actors to respect our democracy. Over the past 200 years, we have had a mixed record in navigating the gap between our constitutional text and our democratic norms. But we have usually averted disaster through a mix of constitutional amendment, the democratization of our political culture over time, and also electing political leaders willing to adhere to our norms. But the prospect of disaster, of things going completely left, is always present when democracy operates in this manner. To make this point, let me start with what should be an obvious example to show you how these factors have operated in our democracies, this sort of give and take between texts and norms. So I think we can all agree that if the representatives who were elected to the most recent Congress in 2020, if they were elected from states that had electorates identical to those in the 13 states in 1789, I think everyone would agree that it would hardly be a recipe for legitimate government of any sort by today's standards, right? The disenfranchisement of African Americans, the fact that women and propertyless white men could not vote in these states would deprive these states and their representatives of any legitimacy on the national stage. And this is because there are events that have transpired since that era to update our understanding of what legitimate government is. So, for example, you had the expansion of electorates in the states as early as the 1790s beyond property white men, right? So this was done through state law in many cases. You had shifting norms around voting and participation that coincided with the rise of mass political parties over the course of the 19th century. You also had new constitutional amendments that were enacted to enfranchise various groups over the course of 2 centuries. So there have been changes both in our law and our norms about what legitimate government, or to use constitutional nomenclature, Republican government requires. While these governments might have been legitimate by 1789 standards, we the people have redefined the majoritarianism, underlined the Republican guarantee to embrace democratic ideals. And in the process, we have reset the baseline for what constitutes legitimate government. Having an electorate that consists almost entirely of white men would not only violate the constitutional text, i.e. the guarantee clause, which guarantees to each state a Republican form of government, as well as the 14th, 15th, and 19th Amendments. It is also not within our collective understanding of what a legitimate electorate is, independent of that text. So it's not just about the text, it's also about our expectations, right? Most people, including political elites, would say that this is so outside of our norms so as to not be a legitimate state of affairs by any measure. We don't necessarily need further constitutional amendment to make this expectation more concrete. Although, to be fair, recent events are starting to make me question that assumption, and I'll come back to that. But let me give you another example. And I think this other example is just as extreme as having a completely male and white electorate. But it's one where I don't think that we have fully thought about it as a consequence of this gap between our expectations and the constitutional text. So I think that the failure to constitutionalize our democratic norms helps to explain why African Americans were disenfranchised in the South for decades following Reconstruction. Right? The constitutional text fell far short of what was needed to make African American enfranchisement permanent. And Congress tried to make up some of this gap by statute, but it didn't work. Between 1868 and 1870, Congress passed the Reconstruction Acts, which readmitted the former Confederate states back into the Union. But notably, these acts imposed certain conditions on that readmission. So these conditions, which, as I mentioned, were imposed by statute and not by constitutional text, specifically had to do with voting rights. So to give you an example of this, the 1868 Reconstruction Act, which readmitted North Carolina, South Carolina, Louisiana, Georgia, Alabama, and Florida, provided in relevant part, quote, "The constitutions of neither of said states shall ever be so amended or changed as to deprive any citizen or class of citizens of the United States of the right to vote in said state, who are entitled to vote by the Constitution thereof herein recognized." Right? So the Constitution, at the time that the state is readmitted, the people who can vote under that Constitution cannot be disenfranchised, except as a punishment for such crimes as are now felonies at common law, whereof they shall have been duly convicted under laws equally applicable to all the inhabitants of said states. So clear implications for felon disenfranchisement. So these Reconstruction Acts, so this is the one from 1868, but there were others passed, readmitting the rest of the former Confederate states. What they did was they clarified the requirements of Republican government, as well as the scope of the 14th and 15th Amendments, right? The 14th Amendment was ratified in 1868. The 15th Amendment was ratified in 1870. So the Reconstruction Acts were actually passed at the same time that the Reconstruction Amendments were being ratified. So importantly, it also shed light on the Guarantee Clause, which predated the Reconstruction Amendments, right? So the Guarantee Clause, for its part, it legitimized much of the Reconstruction program, especially as Congress brought the Southern states under federal control to facilitate the creation of new post-war governments. The Military Reconstruction Act of 1867, put the former Confederacy under federal receivership. And so what this did was it necessitated the creation of new governments and new state constitutions that would, in the process, update the standard of Republican government. Understand that these governments were unlike any that this country had ever seen. First of all, they were racially diverse, right? And you had a broader swath of we the people who could participate in these elections and these state constitutional conventions than at any other time in American history. So the Reconstruction Acts, by readmitting these new racially diverse state governments, not only set a new standard for republicanism, but it also provided guidelines for what was required in order for these governments to remain Republican, right? So the obligation was actually ongoing, as you could see from the Reconstruction Acts. So to give you an example, the act prohibited the any amendment of the state constitution that would disenfranchise people who were permitted to vote at the time of admission. And so in the process, it reinforced the Republican guarantee and also the 15th Amendment's prohibition on racial discrimination in voting. So African Americans couldn't be disenfranchised after readmission. But the acts went even further than that. So it wasn't just about that particular point of admission. It also clarified Section 2 of the 14th Amendment. So Section 2 of the 14th Amendment allowed Congress to reduce a state's delegation in the House if the state abridged or denied the right to vote of its citizens. And it contained language in the context of Section 2 that exempted those who committed a felony from the penalty of reduced representation. So most people haven't heard of Section 2. And this is because Section 2 has never been enforced, even though Section 2 is the only provision in the 14th Amendment that actually mentions voting. Right? We talk a lot about voting. We talk about a lot about the right to vote under Section 1 of the 14th Amendment. But it's actually Section 2 that provides an express penalty for those states that abridge or deny the right to vote of citizens within their borders. They lose congressional representation. And Section 2 goes on to say that states can, however, disenfranchise those who commit a felony. So the Reconstruction Acts are really important because it clarifies what kind of felony. So it stated that individuals could only be disenfranchised for felonies at common law. A felony at common law is not like any other felony. It was a serious crime, most of which were punishable by death. The non-common law felonies were murder, robbery, manslaughter, rape, sodomy, larceny, arson, mayhem, and burglary. So it's pretty clear from the Reconstruction Acts that the world of felonies that the framers of the 14th Amendment believed would exempt states from the penalty was very, very small. And so in sort of setting these boundaries, the Reconstruction Acts directly raise the question of how we can have a constitutional text and then statutory guidance shedding light on the meaning of that text, all of which point in the direction of broad enfranchisement. Yet we currently live in a society in which there are both artificial barriers to voting that have a racially disproportionate impact, as well as extensive felon disenfranchisement, right? Many states disenfranchise for hundreds of crimes, rather than the common law felonies that the acts identify as appropriate for disenfranchisement. And the answer for why this is the case is because political actors have been able to exploit this gap between the constitutional text and the more lofty democratic expectations of those who frame the text, but try to capture their expectations not through that text, but through the statutory Reconstruction Acts. In fact, I would argue that it is this exploitation that led to the dark period in our history known as redemption. So in 1890, Mississippi was the first state to call a convention to amend its constitution and alter its voter qualifications in the wake of Reconstruction. And the point of this was to disenfranchise African Americans, despite the 14th and 15th Amendments. And they accomplished this in a number of ways. So first, the state introduced a very onerous residency requirement. They required that voters live in the state for 2 years prior to the election and be registered 4 months before the next election, right? So 2 years and then 4 months prior to the election occurring. Keep in mind that most states today, the outer limit is 30 days. So it's really hard to imagine the requirement that you stay in one place for 2 years, even in 1890. But the Constitution also imposed a literacy test. So the literacy test required potential voters to read a provision of the state constitution. And this was at a time where there were high rates of illiteracy pretty much across the South. And so the state constitution, in order to get around this, because it was there were a significant number of Blacks and whites who could not read, they grandfathered in those whose grandfathers had been registered to vote. which effectively exempted whites but not blacks from the literacy test. The state also instituted a poll tax of $2, and so this was incredibly effective. Historically, a poll tax was a tax paid as a precondition to voting, and it's a really effective barrier to voting. And Mississippi, in passing the $2 tax, as well as the residency requirement and the literacy test, they also engaged in gerrymandering, right? Gerrymandering is not a new phenomenon. And in doing all of these things to disenfranchise African Americans, they really served as a model for the rest of the South who sought to emulate them. They were incredibly effective, right? The changes in the state constitution had the impact of cutting African American turnout from 30% in 1888's presidential election to virtually nothing thereafter. So close to zero. But the point of all this is not that Mississippi was a very effective discriminator. I don't think that's surprising to anybody. My folks are from Mississippi, so I feel like I can say bad things about it. But the point is that many of these changes were legal. And I think that gets lost in the narrative, right? So it wasn't that Mississippi's constitution was facially discriminatory. Like most of the southern states that were going to adopt similar restrictions, Mississippi relied on the discretion of election registrars to apply the rules strictly to African Americans while making exceptions for white people. This is the same type of enforcement discretion that would pervade the criminal justice system, where African Americans were disproportionately arrested and convicted for crimes that triggered disenfranchisement. So many states, including Mississippi, expanded their universe of crimes to include crimes that legislators believed African Americans were more likely to commit, including crimes like vagrancy, crimes of moral turpitude, notably crimes that are not the crimes, the felonies at common law that the Reconstruction Acts reference. So the US Supreme Court actually took a look at the changes to the Mississippi Constitution in a case called Williams versus Mississippi. And the court reasoned that there's no judicial remedy for the discrimination because it's not because the Constitution doesn't reach discriminatory enforcement. Instead, because it's facially race neutral, then the changes to the Mississippi Constitution did not violate the federal Constitution. So understand what this means, right? Despite the racial purpose behind the 1890 changes to the Mississippi State Constitution and also its discriminatory effect, the court held that there was no 15th Amendment violation because the text itself was race neutral. And this is not an aberration. The Supreme Court of Mississippi in 1896 upheld the state's felon disenfranchisement law, despite that law also having a racially discriminatory purpose, because it was not a violation of the 15th Amendment for the state to target, quote, certain peculiarities of habit, of temperament, and of character that tended to define African Americans rather than whites, end quote. Of course, we know that these changes would now violate the 15th Amendment because they were enacted with discriminatory purpose. Under current case law, that is sufficient for a constitutional violation. But in the 1890s, the courts did not conceptualize intent and or effect as raising significant constitutional issues. And so this effectively allowed states to bypass the expectations of those who ratified the Reconstruction Amendments, who honestly thought that they were creating more egalitarian and inclusive political regimes across the South. The states found a way to get around that by exploiting the limitations in the text. Let's turn to the poll tax, because this is another good example. As I mentioned, it was incredibly effective, but notably, it was also legal in the 1890s. The tax would not be barred for federal elections until 1964 constitutionally, or struck down as applied to state elections as a violation of the 14th Amendment until 1966 in a case called Harper versus Virginia State Board of Elections. Prior to these changes, though, states like Georgia took advantage of this gap between text and expectations in using the poll tax to disenfranchise African Americans. In the 1890s, Georgia adopted one of the most restrictive poll taxes in the country, even more restrictive than Mississippi's. It was restrictive because it was cumulative indefinitely. So if you fail to pay at year one, then you owe double the amount in year two, and so on until you paid it off. And of course, it was really difficult for individuals to pay it in the first instance, much less pay it in subsequent years. So keep in mind, even if the tax is $1 or $2, the per capita income for individuals living in the former Confederacy was $86 in 1880 and $100 in 1900, right? So one doesn't want to spend $1 of that paying a poll tax, and you certainly can't afford to pay a tax that has accumulated over a number of years. But the goal of the tax was to disenfranchise. There's no record of anyone ever being prosecuted for failing to pay a poll tax. In fact, most states went out of their way to avoid collecting it from individuals deemed politically or racially undesirable. So the tax, just because it's called a tax, it really wasn't about raising revenue. It was about keeping people from voting. So I'm gonna share my screen because I have a slide that shows how effective the Georgia poll tax really was in disenfranchising African Americans in that state. So if you take a look at this slide, on the left-hand side, you see a chart that compares Georgia to the rest of the South in terms of voter turnout. It's not broken down by race, but even then, Georgia lagged behind the rest of the South in terms of voter turnout. So 1880, their turnout was about 48%. It dropped down to 37% over the next two presidential election cycles, whereas the rest of the South held steady. But if you look at the breakdown by race over the course of those two presidential election cycles, it tells you that the drop in overall turnout is because Black people were disenfranchised because of the poll tax. So whites voted at 56% in 1880 and 56% in 1888. Really no change, right? But African Americans, first of all, their turnout was already lagging behind that of whites in 1880 at 39%. But it dropped to 19% over two presidential election cycles. If you compare this to neighboring Florida, the turnout is significantly higher, even though you do see a bit of a drop between 1880 and 1888 in Florida because Florida is starting to adopt more restrictive measures. But the fact that the poll tax was cumulative really made a difference in African American turnout. And as these numbers show Georgia was able to use discriminatory enforcement to keep the poll tax from impacting whites in the same way. Okay, so it's pretty clear that the laws of Georgia, just like those in Mississippi, really operated contrary to the expectations of those who wrote the Reconstruction Acts and the Reconstruction Amendments. But it turns out that a statute, particularly statutes widely considered unenforceable today, were insufficient to memorialize the understanding of those who enacted the 14th and 15th Amendments regarding the requirements of Republican government. So Southern states were able to just bypass it, right? They adopted facially neutral laws with respect to voting, with respect to the criminal justice system, which nominally complied with the Reconstruction Amendments, but then they enforced those laws in a racially discriminatory manner, which even though it comported with the Constitution on its face, was definitely not within the spirit of the text. Now, to our credit, we have been able to address this gap between text and expectations in subsequent decades. In the 1960s, we achieved this through the Voting Rights Act, through Supreme Court precedents protecting the right to vote, as well as constitutional amendments that, as mentioned, barred the poll tax, but also enfranchised those who lived in Washington, D.C., and also those over the age of 18. So what you see is this marriage between constitutional and statutory fixes to create the electorate first envisioned by the framers of the Reconstruction Amendments and the Reconstruction Acts. But there's still a gap, right? There's always going to be this gap that can be exploited despite this progress. There will always come a time when we have to reckon with the fact that our progress has not gone far enough in making our expectations permanent. And to make this point, let's circle back to felon disenfranchisement for a moment. In Richardson versus Ramirez, which is a case that was decided in 1974, so after the Civil Rights era, after all of this, progress on the voting rights front, in that case, the Supreme Court held that states that disenfranchise those who commit felonies do not violate the Equal Protection Clause. There, the court concluded that because Section 2 of the 14th Amendment expressly exempts disenfranchisement grounded on a prior conviction, states do not violate Section 1 of the 14th Amendment by excluding these individuals from the franchise. So recall that Section 2 has never been enforced, which I mentioned before. So here what you have the court doing is using Section 2 in order to inform the scope of the Equal Protection Clause under Section 1, right? Because Section 2 has this exemption for felony or other crime, in the court's view, that means that Section 1 cannot be violated. Now, Richardson is still good law, right? The lower court still enforces terms, but it's nonetheless inconsistent with the principle of broad enfranchisement embodied in Section 2's text. And in fact, Section 2's textual exemption from the penalty of reduced representation only tells part of the story, right? So if you read that, you can sort of see how the Richardson court might come to this conclusion. But again, this is another situation where you have a gap between the text and the expectations of those who frame the text. So the story behind the exemption is that representatives from Missouri, which was a border state during the Civil War, lobbied for this exclusion because ex-Confederates constituted a significant portion of their population. So if they were subject to the penalty of reduced representation, the state would have lost congressional representation, even though they were loyal to the Union during the Civil War. So in essence, you have this exemption for felony so that Missouri can disenfranchise former Confederates without suffering the penalty of reduced representation. So, I mean, it goes without saying that one can be disenfranchised for treason, which is the only crime actually defined in the Constitution. The Reconstruction Act, for their part, tried to further memorialize this understanding that disenfranchisement should only be for a narrow category of serious crimes. Yet Richardson doesn't talk about this, right? This plays no role in the opinion or the court's position. And lower courts continue to cite Richardson for the proposition that Section 2 is an express grant of authority for states to disenfranchise those with felony convictions for pretty much any crime. And of course, this gap between this text and this case law, and then the expectations of those who actually frame the text, has significant implications for our political system today. So if you take a look at this slide, this is the ugly legacy of not only Ramirez, but a century of using the criminal justice system to subjugate and later disenfranchise African Americans. I tried to highlight some of the most egregious examples, but if you notice, a lot of them are in southern states and states in the West. So Alabama, 15% of African Americans are disenfranchised. Arizona, 11%. Florida, 21%. Right? Louisiana, 26%. Mississippi, 15%. Nevada, 11%. Tennessee, 21%. Right? So I think I suspect there's not a lot of surprise that a significant portion of African Americans are disenfranchised in the South, although there may be some surprise about the West because we don't talk a lot about the ugly history of discrimination in the Western states, although there is some great recent scholarship on this. But generally speaking, this is a very real political and social and cultural reality of this gap between text and expectations. I think this history shows that the failure to constitutionalize or really update our democratic expectations and have them more accurately be reflected in the constitutional text, particularly when it is apparent that there is a disconnect between we the people's view of how government should work and the minimum that the Constitution requires. If we don't have that update, then it subjects us to backsliding, right? For example, the Constitution might prohibit discrimination on the basis of race, right? It is clear about that. But does it prohibit race-neutral practices that have the effect of discriminating on the basis of race? 50 years ago, we had updated our jurisprudence, our statutes, and our texts to answer this question in the affirmative, right? I would point to the 15th Amendment and the Voting Rights Act as proof of this. I would also look at Supreme Court case law, right? Cases like Harper, which I mentioned before, which found an affirmative right to vote in the Equal Protection Clause of the 14th Amendment, also the one person, one vote jurisprudence, right? I will look at these cases to corroborate that we are a society in which, even if it's facially race neutral, if it has a discriminatory effect, that is something that we should care about, right? As a society, that is something that where there seemed to be, we were trying to close the gap between text and expectations. Now I'm not so sure, right? I would have to consider the lineup of the Supreme Court, the age of the justices, where the law professoriate is. You have to think about whether or not the DOJ will even enforce the Voting Rights Act. I would query whether other portions of the Voting Rights Act are even constitutional at this point, right? Given that the court struck down a portion of the act in 2013. And I would think about a host of other factors before I even attempt to answer this question. And I think our current crisis of legitimacy only reinforces this point, right? Our politics are such where political elites are questioning the presidential election because Black and brown people voted in a way that they didn't like, right? 50 years ago, we would have condemned this in clear terms. Now, senators and representatives claim that they are being responsive to their constituents by questioning the election. It is this fact that is causing me to second guess my assumption that we don't have to update our text to make permanent the expectation that democracy is not a mostly white and mostly affluent affair. The truth is that some states have been successful in passing restrictive voting measures in an attempt to keep the electorate mostly white and mostly affluent. And they have been able to do so because while we have constitutionalized a prohibition on racial discrimination in voting, we have not explicitly constitutionalized our expectation that the right to vote will be available to all those legally entitled to vote without artificial barriers, right? That make exercising the vote illusory. We don't have an explicit constitutional right to vote in the text, which would close much of this gap. Instead, what you have is scholars like me who play with the language of the Constitution in an attempt to make our expectations permanent, right? I do it all the time in my writing, arguing that the implicit right to vote in the document should be read broadly. I'm trying to flesh out the assumptions that I talked about in my talk today about voting that underlie the text. The court has done it as well, right? So I'm in good company. See the aforementioned Harper versus Virginia Board of Elections, right? This implicit right to vote in the Equal Protection Clause. But the reality is when we don't make our expectations and our assumptions explicit, then we lose ground. And we've lost ground. We have lost so much ground in the 7 years since the Supreme Court invalidated a portion of the Voting Rights Act in Shelby County versus Holder. We have lost so much ground as the court has interpreted the right to vote more narrowly and state sovereignty more broadly in this area. As it stands, the Constitution is a framework, and I think our current situation reflects that, right? The details are in the politics and the social movement and the wars and the bloodshed and the sacrifices, all the things that we, the people, have given in order to create the democratic norms that are currently under threat. But as long as this is so, where the details are contingent based on expectations and norms, then we will always be at risk because the only standard of legitimacy that is permanent is the one that is constitutionalized in the text. Right. Thank you so much.
Thank you, Vice Dean Tolson, for that. We have about 18 minutes or so for a Q&A. So if you have any questions, please raise your hand using the Zoom function and I'll go ahead and call you. The first hand I saw was Sarah Levine.
Hi, thank you so much for being here today. It's so interesting to hear what you have to say, and I really appreciated it. So I wondered if you could kind of speak more to your work with the Durbin-Warren Right to Vote Amendment, and just how this could help remedy measures that you were saying are race neutral on their face, but they do have this discriminatory effect.
Yes. So I think part of the problem that we currently face is that the coalition of the 1960s basically doesn't exist anymore, right? So we don't live in a world where the language of race really captures everything that's occurring in the area of democracy and voting rights. It's an important part of it. But the right to vote amendment would, I think, number one, it would give the right to vote constitutional standing on its own, right? Independent of race, independent of wealth, and independent of any of the categories that in the past have been really important for judicial intervention, right? So Harper was about the poll tax, and the court treated the poll tax as a wealth restriction. A right to vote amendment would require that courts look closely at any voting restrictions, right? And determine whether or not they are abridgments or denials of the right to vote. So in essence, what it does is it constitutionalizes a standard of review, because right now the court is very deferential to the states. And it also gets us beyond race. And so in that way, it's a complement to the 15th Amendment. So 15th Amendment, you have a prohibition on race discrimination in voting. And then this new amendment would extend voting rights independent of race, and also cause courts to allow courts to more strenuously police restrictions on voting outside of race. So that's why I think it's important. And probably one of the biggest changes and one of the most important parts of it is that it will get rid of that language in Section 2 that's the exemption for felony or other crime. So essentially, it's a constitutional amendment that overturns Richardson versus Ramirez, which is a good thing.
Thank you. Evan Martin.
Vice Dean Tolson, thank you so much for coming and speaking with us. We really appreciate your words. My question kind of goes back to when you were talking initially about the Capitol riots and how a certain section of our political electorate are questioning results as the result of misinformation. And I think what I wanted to ask you to speak on is how you feel the role of disinformation is affecting people's attitudes, especially towards race, where a lot of it is stoking kind of age-old fears on the white electorate, and also how you feel combating disinformation would affect change.
So one of the things that actually, Evan, let me start with this thing I think about often. Before the election, there was this potential controversy, and I say potential because it ended up kind of petering out and not turning into a big thing. Do you guys remember the story with the naked ballots in Pennsylvania? So in Pennsylvania, to vote absentee, you have to stick your ballot in the secrecy envelope and then in the second envelope before you mail it. And there was a concern that people wouldn't know to stick the ballot in the secrecy envelope first prior to mailing it. And everyone was like, oh my God. So first of all, everybody was worried about Pennsylvania anyway, because Pennsylvania, no offense to anyone from Pennsylvania, has very poor election infrastructure. And they had a state legislature that refused to make needed changes ahead of the election in order to alleviate some of the potential problems that we knew would come up. So this thing with the secrecy envelopes was also concerning for those who care about voting rights, right? Because you could see a significant number of people being disenfranchised for something that's, easily misunderstood. Because most people would assume on error that, the state sent 2 envelopes. But they engaged in this huge sort of voter education thing about the secrecy envelope, right? You had celebrities on Twitter and Facebooks telling people, make sure you put your ballot in the secrecy envelope. And it made a huge difference, right? This actually turned out to be a non-issue in the election. But it highlighted for me the importance of civic education to countering a lot of potential misinformation, right? Because part of the problem is that when people don't know, then they'll take in whatever information is put in front of them. I think it's incumbent upon the states and the federal government to provide voters with that information proactively so that they're not reactive and just taking whatever information is put in front of them. I think that's a huge problem that we have, that we don't really have a lot of resources going to civic education, right? You could, in some places, you can graduate from high school never having taken a civics class. And I think that's a big problem. We saw some of that manifest in the recent election cycle.
Thank you. Alejandro?
Dean Tolson, thank you so much for being here. There's so much that you touched on that is so interesting that I'm actually wondering if we could drop the name of the podcast that Dean Prager mentioned, because I'd love to hear some of your thoughts on other issues as well.
Of course. It's Free and Fair with Fernita and Foley.
Got it. My question is about something that you touched on earlier about the disparity between the powers that state have in the Senate. I've actually done a little bit of research on this. So in the county of Los Angeles, there are more people than in Wyoming, North Dakota, South Dakota, Montana, Idaho, Nebraska, and Kansas combined. How do we address this disparity without having to take those big steps of make amendments to the Constitution, which seem really difficult to get through, this Congress and the Senate? I mean, the ERA is still, waiting to be ratified by, I think, 2 or 3 more states since 1970. How do we address these issues without, waiting 30 or more years?
I don't know. Let me be clear. To the extent that your question is, how do we fix the Senate? So each state is guaranteed equal suffrage in the Senate. So that just seems like the one thing that we can't really fix. But there are other things that we can do to make the system better despite the Senate, right? So having independent commissions for congressional redistricting is important. I think that would go a long way towards responding to Rucho, towards responding to some of the gridlock we see in Congress right now. That's on the table. That's an HR1, which is piece of legislation that's currently pending in Congress. Not only would it create independent redistricting commissions, it would also enfranchise individuals with felony convictions for purposes of voting in federal elections. One of the things that we saw in the most recent presidential election was this huge fallout over Amendment 4 in Florida, where the voters in Florida by ballot initiative re-enfranchised 1.2 million people, and then the state legislature came in behind them and required payment of all fines and fees. The end result was that something like, I think 30,000 people were able to vote in November. And so I do think federal intervention is really important here, especially if we're going to hold ourselves out as a democracy. If that is truly who we think we are, then we should not be disenfranchising people in significant numbers like that, especially when the voters of a state have spoken and said otherwise. So I do think that there are things that we can do even if we can't fix the Senate. And don't even get me started on the Senate rules, which we act like they're constitutionally mandated, but they're really not, right? Like the filibuster is not in the constitutional text, right? So we can have very real conversations about not only changing the, we can have conversations about how to fix other aspects of our system, even if we can't touch on the Senate, but we can also have a conversation about institutional design. Right, the Senate does not have to operate in the way that it currently does. And I think that's an important part of this as well.
Thank you. Kimberly?
Hi, Vice Dean Tolson. Thank you so much for speaking with us today. So you kind of touched a little bit on my question when you were answering Evan's question. So obviously this past election introduced a whole host of issues with long in-person voter lines, more people voting by mail. Can you speak a little bit more about how the COVID-19 pandemic maybe exacerbated these existing racial disparities in our voter system?
Yeah, absolutely. So it came out pretty early in the pandemic that Black and brown people were being hit more heavily with COVID than other demographics. And I think that it's sort of that dynamic combined with the fact that there have been efforts in states to make voting harder for those populations since the Supreme Court's decision in Shelby County. And the core problem with the COVID pandemic, though, and this is this gap between expectations and text, the Constitution didn't necessarily require states to make it easier for people to vote in a pandemic. Some states did, but it was on their own initiative, right? But if you have a state that's not willing to make things easier, there wasn't really a cause of action that could have captured that would really force them to make it easier. Now, I can tell you a story about how to design a lawsuit where it makes it more likely for a court to say that they're obligated to do something, right? If you think about it in terms of voting rights and the states having obligations to their citizens with respect to the right to vote, then you could say that the state is obligated to make things easier because of COVID. But that is not how the Supreme Court looked at it during the pandemic, right? They sort of took it as a given that we're still living in a time in which the court needed to defer to the states, even if a state had decided not to make things easier to vote in a time of COVID, right? So because our orientation is one in which we prioritize state sovereignty over voting rights, and state sovereignty tends to be the baseline from which we start this conversation, it became really difficult to fix things during COVID in those states that weren't willing to take the initiative and make things easier for voters, right? And in some ways it, one of my everlasting frustration with this election cycle was how the Secretary of State of Georgia came out looking like a good guy after 7 years of trying to suppress the Black vote, right? Because he was, he was basically doing his job, right? So in sort of certifying the election result and counting the election results and saying Joe Biden won, he did his job and came out looking like a winner, even though for 7 years he had worked to make it harder for Black and brown people to cast ballots in that state. And the Supreme Court facilitates that process. They have lessened the obligations on states to make it easier for people to vote. The court, unlike the court of the 1960s, which really prioritized democracy and voting rights, that is not this court.
Thank you. Laura?
Okay, thank you. So my question is, up until now, as far as I'm aware, the Supreme Court has not ruled on a vote denial case under Section 2 of the Voting Rights Act, which is, as you know, that prohibits discrimination on the right to vote based on race. I'm saying it for the benefit of others, not for you. I know you know.
Oh, no, of course. No, yeah.
So this past fall, they actually granted certiorari in a case out of Arizona about how to prove a disparate impact on racial groups that were denied the right to vote. So I guess my concern is based on the current makeup of the Supreme Court, and in particular with Chief Justice John Roberts being pretty hostile towards voting rights. I guess I'm concerned about what an unfavorable ruling could mean for the jurisprudence of voting rights going forward, and if that is something that you think could be dealt with by legislation, including the bill that you were discussing.
I do think this is something that could be dealt with legislatively. It would obviously be bad, right? But to be honest, we've been in a pretty bad situation since Section 4B was invalidated, because Section 2 litigation, the court hasn't weighed in, but let's be realistic about Section 2 litigation. It's very burdensome. It's very expensive. The pre-clearance regime was doing a lot of the work in this space. So when the court struck down Section 4B in Shelby County, it had such a huge impact on the efficacy of the Voting Rights Act, even though we still did have Section 2, right? So if the court strikes down Section 2, that would be terrible. But let me just offer that things are already terrible, right? Such that Congress has to do something, even if the court doesn't reach the constitutional question in the Arizona litigation, which is also a possibility. So right now there's a bill pending, HR 4, which would reauthorize the pre-clearance regime by coming up with a new coverage formula. I think that would go a long way towards strengthening the Voting Rights Act in ways that we really need. Even though it's more narrow than the prior Voting Rights Act, it will cover far fewer states, but it really is Congress's attempt to be responsive to the constitutional concerns that the court raised in Shelby County, while still, arming the DOJ with the tools necessary to protect voting rights. So yes, Section 2 is important, but my fear is that if the court, let's say Section 2 survives, then we think that we don't necessarily need a new coverage. The reality is that Section 2 and Section 4B and 5 worked well together, right? It was a strong regime, and we need all of them again. So I just don't want to lose sight of that. Yes, Section 2 is important, but pre-clearance was important too.
Alrighty, well, Vice Dean Tolson, I cannot thank you enough on behalf of the Southwestern Law Review and the Southwestern community for keynoting our event today. We all definitely learned a lot from your insight, and we just appreciate you taking the time to come today. And thank you, Dean Prager, of course, for the introduction. If there are no more questions, then I will release everyone to a break, stretch, use the restroom, and we will return for the criminal justice panel at 1:40 p.m. I am excited to pass over the torch to Professor Rachel Van Landingham.
Thank you so much, Abe. I really would like to start this off by saying thank you to Abe, to Erica, the entire Law Review board and staff for putting together this incredible event today. It has been so powerful. I've teared up, and I think so many of you have as well, listening to some of our other speakers eloquently diagnose some serious societal ills, but also try some hope with some remedial measures as well. So I have the honor today to moderate our criminal justice panel. It's hard for me to say criminal justice because it seems like it's really criminal injustice, as we'll see from our esteemed panelists. But I love the positive spin we're putting on the title here, because we can't give up hope. But to quote or to paraphrase Vice Dean Tolson in her fabulous presentation a few moments ago, in the criminal justice arena in particular, our expectations for a fair, balanced, just, and equitable system, our expectations fall far short of reality. So without further ado, I'll be giving a long bio and introduction to each one of our esteemed panelists as I introduce them, because they each deserve it. But I will start off with, and I would like to say thank you so much to our panelists. Not only are these incredible scholars and thinkers and practitioners and folks deeply invested and passionate about change, positive change, they're also dear friends. So thank you so much for being here today. Professor Kenneth Williams is going to start us off today speaking about race and the death penalty. He is a graduate of the University of Virginia School of Law, and he is currently a professor at South Texas College of Law in Houston after that wonderful school stole him from us because he was here first at Southwestern Law School. He teaches criminal law and procedure, evidence, capital punishment, international human rights, and international criminal law. In addition to Professor Williams' teaching responsibilities, he is a national expert on capital punishment. He is the author of a recently published book on the death penalty titled Most Deserving of Death. And he's also authored numerous law review articles on issues related to criminal law. And he's also a co-editor with me and writing some chapters for a criminal law book. So coming out. Professor Williams was selected as a Fulbright specialist, and during the summer of 2013, he taught a course on the American legal system at the Federal University of Bahia in Brazil. In 2019, Professor Williams was named as a visiting professor at the Federal University of Bahia. He has also taught in numerous summers abroad programs in Argentina, Chile, and Canada, and has been invited to participate in hundreds of lectures abroad. He has represented several death row inmates during their federal habeas proceedings. In 2017, the U.S. Supreme Court granted a writ of certiorari that Professor Williams prepared on behalf of his client, Raymond Martinez. He's also been successful both before the United States Court of Appeals for the Fifth Circuit and the United States District Court for the Southern District of Texas in obtaining relief for inmates who were sentenced to death in violation of their constitutional rights. Professor Williams has also made numerous media appearances discussing issues related to criminal law and capital punishment. He's been quoted all over the press from the New York Times, Washington Post, Houston Chronicle, NPR, Texas Tribune, been on TV as well as on NPR. So without further ado, Professor Williams, thank you so much for joining us today. Please go ahead.
Professor Van Lanningham, it seems like he is having some technical issues. And
I think I'm back.
Oh.
I think I'm back.
Okay.
Okay.
Oh.
Sorry about that. Yeah, you know, this is the new world we live in. So yeah, I think I'm back, at least for a while.
So good. We're flexible. Go ahead, Professor Williams.
Okay, great. Yeah. So I was saying it's always nice to return to Southwestern, even though it's virtually at this point. So I really enjoyed my time there, and I decided I wanted to return to Texas. Being a death penalty person, of course, you know, I'm right in the middle of everything down here. So that was one of the big motivations for me leaving. But I very much have very fond memories of my time at Southwestern. So what I wanted to do was, I'm going to talk about the death penalty and race. And I guess I was going to start off with showing you some statistics on the death penalty and race. How race has really always been, the race and the death penalty have always been really intertwined with each other. Big motivation for the death penalty, I think, in the United States has been the issue of race and the desire to control the African-American population. So I was going to go through just to give you some examples how historically the death penalty has worked in terms of disadvantaging, has been imposed disproportionately on African-American citizens. And then I was going to talk about the current situation. And really not a whole lot has really changed currently. It is still the case that African-Americans are more likely to be sentenced to death, and especially based on the victim, their victim. So historically, while the United States had the death penalty for rape in 1930 and 1972, in 1972, the Supreme Court, United States Supreme Court outlawed the death penalty for the crime of rape in Coker versus Georgia, and then they reaffirmed that in Kennedy versus Louisiana. Supreme Court said that you could not have the death penalty for the rape of a child. But prior to that, while the death penalty was actually on the books for the rape of a woman, 455 executions for rape in the United States. 405, 89% were African-American defendants. And the vast majority of those defendants were actually executed because they had been accused of raping white women. And 97.3% of those executions occurred in the former Confederate states. No white man has ever been executed in the United States for the non-homicide rape of a Black woman or a Black child. Okay, so that shows you historically, it's an example historically, how disproportionately the death penalty has been used against African Americans. Okay, so what's the current situation? This is really much better. I think we still have a situation where Black life is really being devalued if you look at the current situation. So in terms of executions, in 1976 is the year that we point to, because that is the year in which the Supreme Court reinstated the modern death penalty. So 1976 was really the beginning of the modern death penalty period. And since that time, we've had 1,532 executions. 55% have been white, and 34% have been African American. And African Americans, of course, make up 13% of the US population. So the number of executions far exceed the number of African Americans in the total population. What's really very startling also is those who have been executed because of the person they killed. And overwhelmingly, those who are executed are those who kill a white person, okay? 75% of those who have been executed were executed because they killed someone white. Only 13% were executions because they killed someone Black, and 6% were Latino. Okay, and let me point out with this statistic, about 52% of all homicide victims in the United States are African American. So what that basically means is that African Americans are being killed, but their killers are not being executed. Okay, so that raises some real questions there, and I think points to the devaluation of Black life. And we're going to get more into that in a few minutes. Okay, and the current death penalty population, the death row population in the United States, 42% are white, 42% are African American, 13% are Latino. Again, way above the African American share of the population. These statistics were actually presented to the US Supreme Court. You've had this history, and you also had the previous, you have the history and you have the current situation. Let me talk about the Supreme Court historically, how they dealt with the issue of capital punishment and race. Basically, the way they dealt with it historically was just not to address it. The Supreme Court was on a number of occasions asked by Justice Thurgood Marshall, then attorney and NAACP Legal Defense Fund attorney Thurgood Marshall, in a number of cases involving a Black defendant who had been accused of raping a white woman. And the Supreme Court was asked to address that issue, whether or not the death penalty was constitutional for the rape of a white woman. The Supreme Court refused to address the issue during those, at the many times that Justice Marshall, he filed numerous cert petitions asking the court to consider that issue. The Supreme Court never did. So what was the case in which they decided finally to address the issue of whether or not the death penalty was constitutional for rape? Well, the case when they decided to address the issue was a case involving a Black defendant, a white defendant and a white victim, okay? They refused to address the issue whenever the defendant was actually Black. And in Coker, the defendant was white, the victim was white, and that was the case in which they decided that the death penalty was unconstitutional. Obviously, there was a political decision made. By the way, in the opinion, there was not one word mentioned about the racial aspect of the death penalty with respect to rape, okay? So that's how the Supreme Court addressed the issue historically. So let's talk about more modern times, how the Supreme Court addressed the issue of race and the death penalty, okay? There was a case, McCleskey versus Kemp, that was decided in the 1980s. And McCleskey was a Black man who had been convicted of killing a white police officer. He argued that his death sentence was unconstitutional because of his race, that his race made him more likely to receive the death penalty. In support of his argument, he presented what's called the Baldus study. Okay, the Baldus study was a study done by a professor at the University of Iowa Law School. And what this study showed was that a person who, the Baldus study took into account 230 variables that could have explained why someone would receive the death penalty. And might, for instance, maybe there's certain crimes that the person's always going to get the death penalty for. For instance, if somebody were to kill a police officer, almost always somebody gets the death penalty for that. Okay, so the Baldus study took that into account, those variables. And what the Baldus study found was that after taking into account those variables, that could explain the death penalty on non-racial grounds. The Baldus study found that a defendant who killed a white person was 4.3 times more likely to be sentenced to death than a defendant who killed someone who was non-white. 4.3 times more likely to be sentenced to death. And the person who was most likely to be sentenced to death was a Black defendant who killed a white victim, according to the Baldus study. That was the most likely combination in terms of the race of the defendant and the race of the victim. The Supreme Court accepted the Baldus study as valid. They didn't quibble with the study. They didn't find the study was invalid. They didn't critique the study. They accepted it as valid. But what the Supreme Court held was that the study was not sufficient to prove an equal protection violation, that the death penalty was actually being meted out on a basis of race. So McCleskey was arguing that because he was a Black man, and because he killed a white person, he was more likely to receive the death penalty. And the Supreme Court said, no, you've got to do more than produce statistics. You've got to prove that the actors in your case discriminated against you. Okay, you've got to prove more than just statistics. Okay, you've got to have more than that. You've got to prove that the prosecutor or the judge or the jury or even your defense attorney discriminated against you based on race. Well, that's such an onerous standard. I mean, how likely is it that a defendant could actually come across that kind of evidence? For one thing, the jury doesn't have to justify its decision. Okay, the jury deliberates in secret. They don't have to, when they render a verdict, they're not required to justify that verdict. Okay, so very difficult to prove. You know, what judge is going to admit that basically you'd have to have an admission from a judge or from a prosecutor that they took race into account? Well, what judge or what prosecutor in their right mind is going to admit on the record that they actually discriminated based on race? Not likely to happen, okay? So basically they came up with a standard that was pretty onerous, that was almost impossible to meet. I did some research on this issue for the book that I wrote, and I couldn't find a single defendant who was able to claim successfully that he had been discriminated against based on race in terms of his death sentence. Now, you know, we know intuitively that could not be the case. We know intuitively that simply could not have occurred, okay? But because the Supreme Court came up with such an onerous standard for proving racial discrimination in capital cases, no defendant can actually meet that standard, okay? So there was a dissenting opinion in the case. Justice Brennan indicated that he thought this was really an example of how Black life was being devalued, okay? One of the motivations, by the way, for having Black Lives Matter is statistics like this, in cases like this, the Baldus study, okay? Because it definitely proves that Black life is definitely being demeaned and devalued in our society. The court was really concerned with what would happen if we rule in favor of McCleskey, okay? Not only would we have to, you know, it'd be hard to figure out a death penalty that would not be infected by race, but it would have ramifications beyond the death penalty, okay? what would happen if a Black robber would say, you know, statistically, I've got a study that shows that if you're Black and you rob someone, you're more likely, and I would imagine this is the case, if you're Black and you rob somebody, you're more likely to actually receive a harsher sentence. And we know with rape, we already know with rape what the situation is. Okay, so I think that was some concern. The court was concerned with that. Okay, so let me talk about some of the factors that why we have such a disproportionate number of people on death row. And I'm going to share with you some of the findings of the capital jury study that was done. The capital jury project did a study of actual jurors in capital cases. And there were some pretty astonishing things that they came across. One thing they found was that whites are much more likely to vote for death than someone who is on the jury and if they're African American. A white person is much more likely to support capital punishment. Okay, a couple of other things that were very interesting. Number two here, no statistical models, Black jurors are significantly more likely to oppose the death penalty than are white jurors. Okay, let's see. Let me go down. Black jurors were far more likely than their white counterparts to have lingering doubts about the defendant's guilt when making their punishment decisions. Black juror, one of the things that happens in capital cases, the jury has to consider mitigating circumstances and aggravating circumstances. Okay, so is there something in this defendant's background that would warrant really a life sentence that would actually wouldn't be a defense, but might actually explain why this defendant committed the crime? So one of the things you might want to point to is, for instance, remorse. The defendant is remorseful for the crime that he committed. Okay, what the study found was that number 6 here, that Black jurors were much more likely than their white counterparts in Black-white cases see the defendant as remorseful. Okay, one of the other issues with respect to the death penalty and whether or not somebody should be sentenced to death is, does the jury see this person as potentially a danger to society? Is this person reformable, or would they continue to present a danger to society, even in prison? In Texas, for instance, that question is posed specifically to the jury. Would this person, the defendant, be a future danger to society? Well, what the capital jury project found was that white jurors were much more likely than their Black counterparts to see the defendant in Black and white cases as dangerous, and to regard his dangerousness as a reason for the death penalty. Okay, so white jurors much more likely to see the defendant as being dangerous. Okay, which would lead to a vote for death. Okay, another thing that comes up in capital cases is whether or not the defendant's family situation. Okay, many defendants I've represented for the past 30 years. I've been representing death row inmates, and most of them come from pretty dysfunctional families. Okay, and that's one of the things as a defense attorney you look for in terms of mitigating circumstances. But what the capital jury project found was that Black males were most likely, and white males the least likely, to see the defendant as remorseful and identify with the defendant's family situation. Okay, so it makes a huge difference in terms of who sits on the jury. A couple of other things I want to point out from the study number 10. Black jurors are significantly more receptive to mitigation than their white counterparts, are more receptive overall. So Black jurors much more likely to consider and give impact to mitigating circumstances. Okay, number 11 I thought was very interesting. All jurors were significantly more receptive in Black victim cases. So white jurors are not that sympathetic to mitigating circumstances, except where the victim is Black. Well, what does that suggest? That they don't value the Black life that's been lost as much. Okay, but if the victim is white, they're much more likely to consider and give, much less likely to give impact to mitigating circumstances. But if the victim is Black, they're willing to consider mitigating circumstances. So it's also evidence that jurors oftentimes will devalue Black life. So that's a big reason why we end up with the disparities that we have that I just showed you. Who sits on the jury makes a huge difference. It's really outcome dispositive who actually sits on the jury. It's very important. Okay, let me talk about a couple of other, in the time I have remaining, talk about a few other reasons why we have such a disproportionate number of African Americans on the jury. Then I'll talk about some of the reforms that I'd like to see implemented.
Ken, I'm sorry, or Professor Williams, I'm gonna have to be pulled
Okay, I'm out of time. Okay, I'm sorry. Okay, yeah, you can go ahead. Yeah, okay.
The last sentence to wrap it up, please.
Okay, sure. Okay, so my most important suggestion in terms of reform, of course, is abolition. And that is starting to happen in the capital of the old Confederacy, Virginia. They're on the precipice of abolishing capital punishment. And I think that's the only real solution. We're never going to have, in my opinion, a fair death penalty. So I'd like to see it abolished. But there are other things that could be done in the interim before we actually abolish it. But I'll be happy to answer questions later on. Thank you.
Thank you, Professor Williams.
Thank you.
And I'm really glad you left on that note. And I would like to hear definitely more about the abolition movement and how close perhaps it could be to fruition in some places. Now we'll be turning to, we have another professor joining us from Houston, and that is the terrific Professor Najri Mathis Rutledge, who is joining us from South Texas College of Law as well. She joined the faculty there in 2005, where she teaches criminal procedure, forensic evidence, and legal research and writing. She graduated summa cum laude with a BA in English from Spelman College and earned her law degree from Harvard Law School, where she served as technical editor of the Harvard Civil Rights, Civil Liberties Law Review. After graduating from Harvard, she clerked for the Honorable John T. Nixon, the Chief District Judge for the Middle District of Tennessee. She also served as an associate for Baker Botts, where she represented clients in the areas of labor and employment, toxic tort, and complex civil litigation for 4 years. Following Baker Botts, Professor Rutledge entered the public sector as a prosecutor for the Harris County District Attorney's Office. During her 3 years as a prosecutor, Professor Rutledge served in the Family Criminal Law Division, the Juvenile Division, and the Misdemeanor and Felony Divisions. After leaving the District Attorney's Office, Professor Rutledge spent the 2004-2005 academic year as a visiting professor at South Texas College of Law there in Houston. She's also served her community as an associate municipal judge, Judge Rutledge, for over 10 years. Professor Rutledge frequently speaks and writes in the areas of domestic violence, criminal justice reform, crime victim compensation, race and policing, based on her personal experience, scholarly research, and work experience. Her interests include criminal justice, criminal law, procedure, critical race theory, domestic violence, law and religion, and constitutional law. She has submitted a formal written statement before a judicial proceedings panel on sexual assault in the military. Her law review articles have been published from everywhere, from the Maryland Law Review, the Duke Journal of Gender Law and Policy, Loyola LA Law Review, and the New Mexico Law Review. Her opinion essays have been published in The Hill, The Medium, and USA Today, where she's a member of the USA Today Board of Contributors. A warm welcome to Professor Rutledge, who will be speaking on search warrant executions and the disappearing distinction between knock and announce and the no knock warrants. Thank you so much for being here.
Thank you so much for having me. I'm going to take a moment just to share my screen and make sure everything, and everyone should be able to see my screen. Yes? Okay, very good. So as you know, I have a bit of a unique background because I've been an associate judge for the past 10 years. So I've had the opportunity to review and ultimately sign off on countless search warrants. It's my position that the distinction between the traditional knock and announce search warrants and the no knock warrants is disappearing. So consequently, the call that we're hearing for reform and to eliminate no knock warrants is not really going to solve the problems that we've been seeing over the last several decades as it relates to botched search warrants. I want to start by looking at the Fourth Amendment. And of course, this is the basis for the right to search. As you all already know, we have a tremendous right of privacy in our homes. Our homes are considered sacred. And so we rely on the Fourth Amendment to get the search warrant. A search warrant is obviously just a court order signed by a judge giving the police the authority to search in a particular place. Most search warrants are based on the traditional knock and announce concept, and that is a concept that predates our Constitution. The Supreme Court found that knock and announce was even supported in the Fourth Amendment reasonableness clause. So knock and announce basically refers to the requirement that before police can enter our homes, they have to not only knock and announce their presence, but they have to wait for a reasonable period. Now, sadly, police officers have testified in lawsuits that they're not waiting. A no-knock warrant refers to not having to announce at all, but basically breaking and entering in someone's house, as long as there's reasonable suspicion to believe that knocking would be dangerous or would be futile or evidence destruction. So sadly, many of the reasons that we've had so many problems and very few repercussions for botched warrant executions is because of the state of our laws and Fourth Amendment jurisprudence. In fact, the Supreme Court has pretty much made the distinction between knock and announce and no knock meaningless. I'm not going to spend time going through all of the cases where the Supreme Court has dealt with the search warrant, but I do want to highlight two in particular. One is United States v. Banks. Banks was the decision where the Supreme Court said 15 to 20 seconds counts as a reasonable time for officers to wait before breaching someone's home. And Hudson v. Michigan was the case where the Supreme Court decided that the exclusionary rule would not apply if knock and announce was violated. So when the Supreme Court started deciding these decisions in the late 90s and the early 2000s, we were in the middle of the still ongoing war on drugs and the implicit racist undertones. As you all know, the war on drugs has systematically targeted communities of color and is responsible for devastating incarceration rates, the difference in punishment rates that we've had between crack cocaine and powder cocaine, and just the viewpoint of people who use crack cocaine being seen as criminals, but people who use other drugs like Oxycontin are considered victims of a public health crisis. The war on drugs has helped the police see ordinary citizens as enemy combatants. Now, knock and announce has some very important policy reasons for having knock and announce. To protect people's privacy would be one of the first things that comes to mind. The safety of officers, of the occupants, and a very important thing is to make sure there are no mistakes in the warrant. I'm sure all of you have heard the horror stories of the police executing a search warrant at the wrong address. So with knock and announce, the police are supposed to knock, announce, and wait. And that's the part that we keep leaving out, the wait. And it's supposed to be a reasonable time. And as I said, Banks said 15 to 20 seconds is reasonable. If you can imagine being in a deep sleep about 2 a.m. in the morning in the back of your house and hearing a loud knock or noise on your door. I know personally, I can't possibly get to my door in about 20 seconds. And so it just makes it really difficult questions. Now, the perception has been from the Supreme Court that when knock and announce is violated or when we fill out a no-knock warrant, it's a minimal intrusion on people's rights. In fact, minimal intrusion were the words that Justice Scalia used. And they say that because the issue comes down to notice. Because once a judge signs a search warrant, the police have a lawful authority to come in your house. So we're not talking about whether or not the police can enter. They can enter. We're really talking about how they're going to enter. It's important to keep in mind the stakeholders. Oftentimes when we talk about stakeholders in warrant executions, we focus on the police. And maybe we give a little bit of thought to the target of the warrant. Now, officer safety is a very important and legitimate interest, and we want officers to come back home safely after a day's work. But civilian safety is important as well. And civilian safety includes not only the target of the warrant or investigation, but innocent family and friends and neighbors. There's a concern that knocking and announcing would somehow endanger officer safety. But we also have to remember that we still have the exigent circumstances doctrine. So even without a no-knock warrant, the police can always argue exigency if they fear that there's a concern about safety or evidence destruction. Now, there are problems with knock and announce warrants, as I've already alluded to. First would be the Supreme Court case of Hudson v. Michigan, where they decided the exclusionary rule does not apply if the police decide not to knock and announce. Now, knock and announce isn't like it was back in the 90s and the early 2000s. This is no longer just a matter of a police officer kicking in your door after 15 seconds if they wait that long, which is already terrifying. Now we're dealing with the over-militarization of police, SWAT teams, officers who are not wearing their uniforms but plain clothes, flashbang grenades. These militarized missions are not saved for the most violent cases like hostage situations or human trafficking. They're sending SWAT teams following low-level buy busts without any other investigation to support that there are any substantial drugs in the home. The over-policing in minority communities and the undeniable tensions between the Black community and law enforcement has been a concern long before George Floyd. Now, the other issue is when we're dealing with drug cases, even though the Supreme Court had said that we can't have blanket no-knock warrants in particular cases, there's still a tendency to assume that if a case involves narcotics, that it automatically is going to be violent and drugs can be easily destroyed, so anything goes. Now, there are also problems with no-knock warrants. No-knock warrants are actually worse, though. With a no-knock warrant, in many jurisdictions, it allows the police to go to the judge based on reasonable suspicion, which is a lower standard than the probable cause that you would need to get a search warrant in the first place. And it's basically an opportunity to get a pre-approval on exigency. This is something that happened in the Breonna Taylor case, which I contend should have never had a search warrant issued for her home in the first place, but we'll get to that later. So essentially, the distinction between a knock and announce, and which, especially if it's a quick knock and announce, and a no knock, is really disappearing because the special dangers that are inherent with a no knock warrant are the same compared to a poorly executed knock and announce. There are proponents in law enforcement that say that that element of surprise is a really important tactic that they need to fight crime. I would argue that the risk involved is just not worth that element of surprise. Now, there are three cases I wanted to highlight, and these all predate Breonna Taylor's situation, but they illustrate the longstanding problem of these warrant executions. One was out of Utah involving Todd Blair, who was shot and killed while holding a golf club. This was a knock and announce. It's a very quick knock and announce. And they only found a small amount of marijuana. Baby Boo Boo in 2014 had to endure dozens of surgeries after the Georgia SWAT team executed a no-knock warrant in the middle of the night through a flashbang grenade in the toddler's crib. And after all that, no drugs were found. And finally, Ayanna Stanley Jones, she was just 7 years old in 2010 when the Michigan, I believe it was Detroit police, came in during a raid with a flashbang grenade, threw it through the window. The officer said it obstructed his view, and she was shot and killed. So I'd like to take a few moments just to remember these cases so we can have proper context.
You are about to see is graphic and it is disturbing, but it is vital. So America sees what can happen to innocent people when the drug war goes terribly wrong. Take a look.
Police search warrant! Police search warrant! Search warrant! Search warrant! Get on the ground! Get on the ground! Who's in this house? No, what's going on? Keep going through. Stay with me.
I got it. So
my baby, you know, what's wrong with my baby?
A family's horror as a toddler is injured with a grenade during a SWAT team raid. WSB-TV Atlanta reporting the 19-month-old now hospitalized and in an induced coma. Check out these severe burns all over his face. Alicia Fonsavant's family was staying in her sister-in-law's home when a SWAT team bursts in at 2 a.m. Wednesday. They were looking for this man, suspected of selling methamphetamine from the same house. The cops getting a no-knock warrant to arrest him, unaware the family or any children were there. The toddler's mom now heartbroken over the incident, telling the station,
"Them cops busted in the door and threw that grenade in there without even looking first."
The police team was reportedly very upset with what happened as well.
Yes, ma'am, it is. It's going to make us double question.
The man was taken into custody and the child still in critical condition. Make sure to check
This testimony that was really tough to listen to. This grandmother says Officer Weekly fired instantly the moment he entered that house.
I'm laying there screaming, asking somebody to help my granddaughter because he just shot her in the head. And he wouldn't even help her. They turned on the light and seen that she had been shot and carried out the house. Oh, man. Oh, my God. Oh, Jesus.
A highly emotional Myrtilla Jones wails on the witness stand this afternoon during the retrial of Detroit police officer Joseph Weekly. He's accused of involuntary manslaughter in the death of Jones's 7-year-old granddaughter, Ayanna. It happened in May of 2010 during a raid on a Detroit home as police were searching for a murder suspect. Jones says she was on one end of the couch and Ayanna was sleeping on the other end of the couch closest to the front door when Weekly entered first and instantly fired his gun, hitting Ayanna in the head, killing her.
Why you do it? Please tell me why you come in my house like that.
Weekly's defense has been that Jones lunged at him and hit his gun, causing him to accidentally pull the trigger. Listen as she defended herself and lashed out at Officer Weekly.
You killed my grandbaby. You killed her and you try to blame me. You know I never touched you, Mr. Weekly. You know I never touched you. You know you're wrong. She was only 7 years old. She was only a baby, man. She was sleeping.
Weekly sat stone-faced, and within moments of that outburst, Jones was escorted off the witness stand. On her way out of the courtroom, she continued to shout at Weekly.
I get no sleep. The flashbacks, I wouldn't wish them on nobody in the...
So these are obviously just horrible cases. And we've got to start asking ourselves as a society, is it really worth it? When we discuss balancing of harms and cost-benefit analysis, oftentimes these very dangerous and tragic cases aren't even yielding any drugs or whatever the police were after in the first place. Now, of course, every search warrant execution doesn't end badly, but too many are ending badly without consequences. And there have also been incidents of police officers killed while trying to execute a no-knock warrant, which leads us very quickly to Breonna Taylor. I think I have another minute. Okay. So Breonna Taylor, as you know, was a no-knock warrant that was used. Well, I'm sorry, a no-knock warrant was issued. The police claimed that they knocked and announced. Taylor fired a shot in self-defense, injuring a police officer, and Breonna Taylor ended up being killed. So this is a great example of it not really mattering whether it was a knock or announce. Notice the language I posted here from that search warrant. It says a fine is requesting a no-knock entry to the premises due to the nature of how these drug traffickers operate. Keep in mind, Breonna Taylor was not a drug trafficker. She had no criminal record. These drug traffickers have a history of attempting to destroy evidence, have cameras on the location that compromise detectives once an approach to the dwelling is made, and have a history of fleeing from law enforcement. Breonna Taylor didn't have any cameras. And so this type of overgeneralization kind of brings us to some of our concerns. I see there's in the chat, which is probably telling me I'm out of time. So I'm going to go ahead and say that besides officer training, extending the time limit for these knock and announce cases, 30 seconds is probably good if you're talking about a motel, not someone's home. and to end the SWAT team types of raids. But I look forward to your questions. Thank you for the opportunity.
Thank you, Professor Rutledge, for that very powerful and deeply impactful presentation. I am going to be moving now to Professor Michael Morris from Southwestern Law School. And Professor Morris will be speaking on the road from law enforcement target to official on his personal journey, personal and professional journey. Thank you, Professor Morris. So Professor Morris is a 2013 graduate of Southwestern Law School and has remained an integral part of this terrific institution as an adjunct professor by not only teaching courses such as California evidence and sentencing law and criminal litigation and practice. He has also long served as an assistant coach for the Trial Advocacy Honors Program. His training abilities have resulted in several, his teaching and training abilities have resulted in several mock trial championships, national championships for Southwestern. Additionally, Professor Morris is primarily responsible for conducting and facilitating the academic component of criminal law-related student externships for Southwestern's extensive externship program. Prior to joining the faculty, while he was a student here at Southwestern, Professor Morris served as a teaching assistant in numerous courses, as well as a researcher focusing on the constitutionality of sex offender registration laws throughout the United States. He also clerked while here at Southwestern for the ACLU, Los Angeles County Public Defender's Office, and the LA County DA's Office. While a student, he cultivated the idea and assisted his constitutional criminal procedure professors Jay-Z's 99 Problems, verse 2, a close reading with Fourth Amendment guidance for cops and perps. This viral article garnered much extensive media coverage both on television and on the internet. After law school, Professor Morris worked for 6 years as a deputy district attorney for Los Angeles County, where he prosecuted juvenile and adult felony cases involving a wide variety of issues, ranging from low-level drug sales to special circumstances murder. Currently, Professor Morris is an assistant United States attorney for the Central District of California, where he prosecutes violations of federal criminal law, and we're very fortunate to have him here with us today. Please take it away, Professor Morris.
Thank you very much, Professor Van Lanningham. Thank you for that very gracious introduction, and thank you broadly to the Southwestern community for hosting this important and very timely discussion. To that point, I should mention that the views I will express will be my own and not that of any of my employers. I'll be speaking in my personal capacity. And, you know, for me, the road to being a prosecutor and indeed being a part of law enforcement was anything but a straight path. In fact, it was an incredibly winding road. The first memory I have of a meaningful interaction with a police officer was when I was about 6 years old. In those days, my family and I, which consisted of 4 small children, myself being the youngest, and a single mom. We didn't know it at that time, but we were essentially homeless, living from motel to motel in Los Angeles County for several years. And I remember at about, it must have been well past midnight, maybe 2 a.m., when a knock came at our door, really a banging. If you've ever heard the police knock at your door, there is a distinctive reverberation associated with it. It was the first time that I had heard it, but I remember my mom waking up and going to the door, having a short conversation with a shadowy figure who was clearly a police officer. After that conversation, she shut the door and we gathered our belongings and as quickly as we could and went down to the main lobby of that motel. When we got there, it became clear that all the residents who had been sleeping that night were also awakened and rushed in, basically huddled into the motel lobby by law enforcement. And it was a proverbial cross-section of the community, Black, white, Latino, Asian, mothers, fathers, small children like ourselves, all of them. You could tell by the way that they were dressed that they left in a hurry from their rooms. And before long, law enforcement, a police officer announced to the group of us that they had evacuated us from our rooms because of some large-scale threat. Maybe it was a bomb threat. I can't remember what it was. But they told us that eventually we'd be allowed to go back into our rooms and go to sleep. And I remember some of the conversations from the adults in that room. And I particularly remember an African-American man who made a comment that when he heard the knock at his door and realized that it was the police, he initially thought that they were there to arrest him. That comment was met with a rather uproarious laughter from most people in the room, as if to acknowledge this sense that was kind of like an elephant in the room, where a lot of people felt like when they heard the police knock that they were coming for them. And I remember wondering as a small child why these adults would assume that the police knocking at their door meant that they were there to arrest them. Weren't the police there to protect us from the bad guys? Years would pass after that event. My family and I eventually settled into my grandfather's home, which was in a low-income community with a fairly high crime rate and a very vigilant police force. And it was there, growing up as a young Black male, that I would learn exactly what those people in that motel lobby were referring to all those years ago, and why they assumed that the police, when they knocked on their door, were not there to protect them, but there to apprehend them. And my experience growing up in that community was not unique, in the sense that it's an experience that many Black males have had and are having across this country. And that is, it wasn't uncommon in those days for me to be walking down the street with a friend, for example, and have a police officer pull up alongside us. Two police officers get out of the car, ask us if they could chat with us, which was a question that we really understood to be more of a command than anything. And of course, before they could talk to us, for their safety and somehow for ours, they needed to make sure we didn't have any weapons on us, which usually entailed us putting our hands on a wall or on a police vehicle and being frisked, having the contents of our pockets emptied onto a hood. And eventually the police would discover, or we would produce some form of identification. One police officer would run us, presumably for wants or warrants, while another officer would stand with us and make fairly innocuous conversation about where we were from and where we were going, where we lived and what school we went to, et cetera. Eventually, they would figure out that we weren't doing anything wrong, and in fact, we weren't. And they would cut us loose and let us go. And it was this kind of law enforcement interaction, really an intrusion into our lives, that came to be just a normal part of our lives. It was sort of like living in a place where there's a lot of traffic, like Los Angeles. There's a fair degree of unpredictability to it, but there's an inevitability to it. And when it happens, you sit tight and hope that it ends sooner than later, and that it ends without incident. And so that's what we did when the police would make contact with us. Later on in life, a couple of years later, when I got my driver's license and began to drive, my interactions with the police did not improve. In fact, they got a little bit worse. I can tell you that between probably the ages of 16 and 25, I must have been stopped by a police officer while driving at least 30 times. And that's a very conservative estimate. And I will tell you that I was stopped for a myriad of issues, some mechanical. I was missing a front plate. I had tint on my window. I had dice hanging from my rear view mirror. Sometimes it was for a moving violation. I was making a right turn too wide or too narrow. Maybe I changed lanes without signaling. In fact, at least a couple of times, I was actually stopped while sitting in my car, completely stationary. For example, waiting for a friend to come out of their apartment. Police officer would happen at least a couple of times. They would look at me, make eye contact, hit a U-turn, put on their lights and perform a traffic stop, which wasn't a stop at all because I was already stopped. The conversations that I would have with them when they interacted with me were fairly cordial. I would speak to them just as I'm speaking to all of you. I did notice that as I got a little bit older, some of the questions changed. For example, are you on probation or parole? Didn't really know the significance of that, but I said no. And I mostly left those interactions unscathed, if you will, save for maybe some fix-it tickets and maybe a moving violation or a warning and what have you. Unfortunately, though, for some of my friends and acquaintances, their interactions with law enforcement went a little, ended up in them being arrested, mostly for petty crimes. But over the years, I visited them in juvenile detention facilities. As a young man, I visited them in LA County jails as well for the small stints that they would spend there. And what I noticed was, as for the law enforcement staff who was staffing this custodial facilities, I noticed that they tended to treat the visitors as if they too were inmates. There was a level of disregard and disrespect that I felt. And of course, most of the visitors were people of color. You know, so that sort of aggregate of experience with law enforcement, by the time I reached around my mid-20s, as you can probably imagine, I didn't have the highest, most positive opinion of law enforcement. In fact, I think it was pretty negative under the circumstances. So, you know, what changed for me? Why do I stand here with some of the experience that Professor Van Lanningham explained? For me, it was a guy named Detective Sammy Morello. At the time, he was a Los Angeles Police Department homicide detective out of the 77th Division of LAPD. And he was, he's one of the people that I'm most glad to have met, but I wish I hadn't have had the opportunity to meet him. And that's of course because he, being a homicide detective, he and I met because one of my best friends and a really close family friend was murdered by his roommate, a victim of gun violence. And when I first met Detective Sammy Morello, he came to my mother's home and met with me and my family. And I have to tell you, I was quite skeptical as to the type of justice that my friend may receive. Detective Morello was a white man with a badge. And what I knew of that interaction was not a positive one. My friend, the victim, was a Black man under 25 years old who was murdered in South Central Los Angeles. So despite, though, my sort of, skepticism, I found Detective Morello to be an incredibly diligent, caring, compassionate, and empathetic public servant. He called me, he went above and beyond the call of duty I felt. He would call me on the weeknights, sometimes on weekends when it was clear that he was doing some errands for his family, for example, dropping his kids off for soccer practice, and he would give me updates on the case that was as yet unsolved at that time. And I remember thinking, against the backdrop of my experience with law enforcement, like, what gives? Why is this guy, I know he's not getting paid extra to contact me and tell me what's going on and keep me in the loop. I'm not even technically my friend's next of kin, although he was like an extended family member to us because he was in foster care and he stayed with us at periods in his life. So I remember being taken aback by that experience, and eventually the person who was responsible for my friend's death was arrested and taken to trial, and I got a call a couple of days before Thanksgiving from Detective Morello saying that he'd been convicted. I saw the closure that brought to myself and my family, and I decided I wanted to go back to school and become a prosecutor. And Southwestern was gracious enough to accept me, and the rest is history, as they say. But even as I was getting sworn in as a local prosecutor, my first job out of law school, essentially, I resolved to not forget the experiences that I had with law enforcement as a young man. And so for me, the issue of community and law enforcement rebuilding, or maybe the word is building, a functional relationship between each other is a deeply personal one. In my capacity as a local prosecutor, I reached out to police officers. Obviously, I worked with them on multiple cases. We did fly-alongs together, ride-alongs together, et cetera. And I can remember one particular ride-along I did with an officer who told me, and I was kind of picking his brain saying, hey, do you guys like to write tickets for kind of minor vehicle violations? Is there some kind of quota? Like, what's the deal? He said, you know what? I don't like writing traffic tickets. He said, my goal is to be a gang officer one day. I'm looking for the guns and the drugs. And I use the vehicle code as a tool. A tool. What do you mean by that? He said, well, there's so many laws associated with the vehicle code that are basically encompass traffic infractions, that if you observe a car for long enough, you can find a justifiable reason to pull them over. And when he told me that, it confirmed something that I already knew, but I didn't know with such clarity. And that is, all those years that I was being stopped and contacted as a pedestrian or a motorist, they were really pretextual profiling stops wherein they looked at me, the type of car I was driving, my race and age and style of dress and friends in the car, and decided they were more likely to find guns and drugs on me than someone else. And they stopped me with that expectation. And then I also had to, as a prosecutor though, obviously admit that that's just patently unfair, right? But I also, with my experience, I had to say to myself, well, I had friends growing up who, most of us, as I was just trying to get through our day and be law-abiding people, as most people are in those types of communities. but we did have some friends and acquaintances, you know, who responded to that disenfranchisement of living in that area, that lack of opportunity, lack of education and healthcare and so on, by engaging in criminal activities themselves, right? So they actually were riding with guns and drugs at various times, or riding dirty as we called it back then. And I did know them personally to be stopped and arrested for those crimes. So I had to admit, at some level, the way in which law enforcement was policing my community, which I consider myself the victim of, was yielding some result. But I had to also ask myself a question that I think law enforcement needs to ask for themselves, and as a community we need to consider. And that is this: for every short-term gain that we accomplish policing in this way, for every gun or every bad guy with a warrant that we happen to take off the street, how many innocent people are we disenchanting? Are we eroding our goodwill with? And how are those people then going back to the community, as I did, discussing with the community that no matter what we're doing out here, be it good, bad, or indifferent, we all have one thing in common, and that is that the police are targeting us. And how does that impact our goal then, shared goals, prosecutors and police, to affect public safety? I know personally affected mine, talking to witnesses who didn't want to talk to me, who didn't want to testify because they saw me as an extension of the police. It's against this backdrop that we see camera phone footage and body cam footage of motorists being stopped and being immediately non-compliant, not because they hate police, but because they have been stopped, not the second time this year, but the 5th time, the 10th time this month. And you have police officers who are engaging in this sort of erroneous presumption, already expecting that they're going to encounter someone with the guns and the drugs. It's a recipe for disaster, and we see it played out every couple of months, correct? So what can we do to solve this sort of stalemate where the police believe that they're doing the best they can to get the people off the street that they need to, and the community feels under siege? The first thing I think we need to do from a law enforcement perspective is to have a full-throated acknowledgement, without question or caveat, that Black lives matter. And we must do this critically without the dubious retort that blue lives matter as well. And I call it dubious because there's no such thing as a blue life. That would be a Smurf. You can take off a uniform, you cannot take off your blackness or brownness, etc. The second thing we need to do, I think, because words are not enough, is take a look, a forceful critical analysis at the way that we're policing, the way that we are shortcutting pretext and profiling as a way to accomplish a menial amount of crime suppression, and how that impacts and cascades across the entire community and erodes our goodwill. Finally, because I'm out of time, I think as a community, and because of law enforcement as well, we have to dedicate ourselves to not be at war with one another. But I think the onus is on law enforcement here. I think we chose this job, the community didn't choose us. And I think we cannot be in a feud with the public that we're sworn to protect. And although there is good reason for us, as those of us in law enforcement trying to do the right thing, to be proud of what we're doing, we've also got a complicated past that we have to wrestle with as well. And we have to confront that forcefully and endeavor to do better. Thanks so much for your time and attention, and for listening to my story and thoughts, and I'm honored to share it with you.
Thank you, Professor Morse. The threads that connect all of your presentations, I'm really hoping to I know our students will be pulling on them and to elicit even more, because we could hear from all of you all day. We are going to hear from another amazing individual, and that is my beloved and esteemed colleague, Professor Gunning. Professor Isabel Gunning was motivated to study law during the civil rights movement of the 1970s, when she saw that, quote, some very positive things could be accomplished through the courts. Following a clerkship with Chief Judge William Bryant of the U.S. District Court for the District of Columbia, she served as a staff attorney with the Public Defender Service in Washington, D.C., and later with the Southern Africa Project of the Lawyers Committee for Civil Rights under Law. Professor Gunning taught for 6 years as a member of the faculty at the University of California, Los Angeles School of Law before her appointment to Southwestern in 1992. Incredibly active in the larger realm of legal education, Professor Gunning has served on the board of the Clinical Legal Educators Association and was one of the 3 editor-in-chiefs of the Clinical Law Review. She also served on the executive committee of the Association of American Law Schools section on gay and lesbian issues, as co-chair of the AALS section on clinical legal education scholarship committee, and as a member of the American Bar Association's skills training committee. Under the auspices of the American Bar Association's African Law Initiative and other entities, she has traveled to Ethiopia, South Africa, and Tanzania to speak on clinical legal education and trial advocacy. Professor Gunning was appointed as a commissioner in 2015 and elected president in 2016 of the Los Angeles County Human Relations Commission, which works to develop programs that proactively address racism, homophobia, religious prejudice, linguistic bias, anti-immigrant sentiment, and other divisive attitudes that can lead to intercultural tension, hate crimes, and related violence. She serves as a pro bono mediator throughout the Los Angeles County Bar Association's Dispute Resolution Services Project and Gay and Lesbian Mediation Project, as well as through the Southern Christian Leadership Conference's Martin Luther King Jr. Dispute Resolution Center. She has also co-chaired the Asian Pacific American Dispute Resolution Center. She was president, Professor Gunning was president of the American Civil Liberties Union of Southern California from 2005 to 2009, and is currently a member of the National ACLU Board as the Southern California affiliate representative. She is our very own evidence law guru, scholar, professor, as well as teaching negotiation and counseling skills and interviewing skills. She is a perfect dovetail to perfect complement to Professor Morse's presentation. Please take it away, Professor Gunning. Thank you.
Oh, thank you, Abe. Thank you so much, Professor Van Landingham. That kind of had your life flashing right before you as she talked about all this stuff. I was like, wait, I did that? That was so long ago. Anyway, good afternoon. I'm really pleased to be here. And as Professor Van Landingham said, I teach here at Southwestern Law, so I was really happy to be a part of this terrific symposium that our students have put together. I've been asked to talk about my work on the Los Angeles County Human Relations Commission. I was going to give you that nice long piece about all of the proactively addressing racism, et cetera, but Professor Van Landingham beat me to it. But in short, our mission absolutely is to transform prejudice into acceptance, inequity into justice, and hostility into peace. The commission grew out of a committee that was established by the Los Angeles County Board of Supervisors back in 1944 in the aftermath of what's called the Zoot Suit riots. The riots involved gangs of white servicemen who attacked largely Mexican-American young men who were wearing what were in fashion at the time called Zoot Suits, while Los Angeles police officers looked on and intervened only to arrest the Mexican-American victims. I was appointed by Los Angeles County Board of Supervisors Sheila Kuehl, and as Professor Van Landingham told you, I've served as the commission's president, although now what I currently chair is our ad hoc committee on policing and human relations. So Ed, could you move to, not just to the next slide, but the slide after that? Yeah. The year 2015 was the 50th anniversary of the 1965 Watts Rebellion. The triggering event for that uprising was a violent encounter between the police and a local resident of the Watts neighborhood here in Los Angeles. And the result was 6 days during which the community protested really decades of police abuse and brutality. And our commission wanted to commemorate that rebellion with action, not just words. And so we launched a series of hearings that would provide safe spaces for community members to document their stories of police interaction and to record their visions for public safety. By gathering community members throughout the county, including policing experts and law enforcement agencies, the academy, and community organizations, we intended to support and catalyze positive change in policing policy and practice. And we plan for the hearings to become the basis of both a video as well as a report that would document community voices on policing. And we also hope that by gathering a broad range of community stakeholders in and around policing here in our own county, we could help to create and strengthen the relationships of trust that Professor Morris was talking about being so lacking, that would support the collaboration we would and still need as a community to transform both policing and public safety. Next slide, please. Over the next 5 years, we partnered with some 20 anchor community organizations in every district in Los Angeles County. These were our partners in reaching out to even more community groups and members to both publicize and attend our hearings. We had about 169 speakers testify during over 17 hours of testimony during 6 community public hearings. 6 because we held hearings in each of the 5 supervisorial districts, and then added an additional one to specifically address the needs of women of color and the LGBTQ+ communities. Our 7th and final public hearing was specifically for law enforcement experts. So we had high-ranking representatives from our local police forces, from what we call the big dogs, the Los Angeles Sheriff's Department, as well as the Los Angeles PD, as well as smaller forces like the Long Beach Police Department. In addition, we invited 13 subject matter experts. We had representatives from the Office of the Inspector General and the Sheriff's Civilian Oversight Commission. We invited lawyers like Sam Paz, whose practice of many decades involves suing the police over abuse endured by his clients, and Peter Biebring, who is an expert on policing issues and works at the ACLU of Southern California. We also heard from academics, including the great Professor Kelly Little Hernandez, who is at UCLA and who received the MacArthur Genius Fellowship back in 2019, and has written extensively on the history of immigration, prisons, and policing, and how all of them intersect with race here in Los Angeles. After the formal hearings, we did follow-up feedback sessions, 38 of them with some 42 groups and organizations, and the resulting report, which we released in June of last year, was supported by 2 academic partners. Next slide. 2 main themes emerge from our hearings on how policing needs to be redefined. The first is the focus on redefining public safety and understanding that policing, law enforcement, is only one and not the main component of public safety. Moreover, when we talk about public safety, that needs to be defined not by law enforcement experts by themselves, but primarily by the community, community defined and community led. Communities that are understood to be safe are not the ones where the police are around, stopping young men like Professor Morris was every time they walk out the door. Safe communities are the ones where schools are safe, where parks are maintained and are safe for community members to use, where community members have jobs that pay well and adequate health care. Those are the communities that we call safe. The other is, of course, to demilitarize police culture. And we heard that already from Judge Rutledge, right? The idea that civilians who are in fact, if not in perception, the neighbors, friends, families of police officers would be treated, as she said, like enemy combatants just doesn't make any sense. This isn't a new idea, but it's still something that needs continuous work in order to transform policing entities from militaristic guardians of public order to ones of officers of peace. The next slide, please. So our report came out with 34 recommendations, which were sent on to the Board of Supervisors, but here are some of the examples. Refund the community, right? In eras of austerity, we have lost so much money for schools, for health, for mental health, for drug programs, refund the community. So we're talking about reallocating, increasing funding to and expanding and fully resourcing non-law enforcement community-based initiatives that proactively address the core issues of poverty, education, health, safety, and youth development. Related to that is to use alternatives other than arrest when responding to quality of life violations and misdemeanors that relate to crimes of survival, such as sleeping in public spaces or in cars. The elimination of qualified immunity so that when police officers do engage in unwarranted uses of force, they can in fact be prosecuted. And the provision of public access to information about police officers who engage in misconduct and are being investigated. Requiring the use of independent prosecutors for use of force investigations of police officers, right? These investigations need not to be housed with the very DAs who they have to partner with in order to do police enforcement. They need to be separate from and housed outside of law enforcement agencies or the district attorney's office. Using racial and identity profiling data. We've got laws on collecting how that's occurring. Not only do we need to have that data be accurate and continue to be collected, but we need to use it to actually end anti-Black racism. And then, of course, ending the cooperation of law enforcement with ICE, immigration and custom enforcement, and rather have our local police forces complying with our own state sanctuary laws. The next slide, please. So our next steps are the long haul, right? So we've got a great report, we've got a video. So it's choosing our strategic priorities, supporting current and emerging initiatives, and developing collaboratives for change that require new and sustained effort. And so far, as you know, as I mentioned, the report came out last June. So you know, we were hit with COVID by that time and the uprisings. So it's still fairly new for us. But what it's looked like so far has been to support community groups that don't get the kind of attention the Black Lives Matters groups do, but who are also doing the important work of bringing together community members and advocating for community needs and public safety. So I'll give you a couple of examples. One group, Care First South Pasadena. It's a local group in what I've come to call the Dinas. That's Pasadena, South Pasadena, and Altadena. And they're pushing an agenda which is redefining public safety away from law enforcement. And last fall, they discovered that their police chief was promoting a prayer rally on City Hall Plaza that was to be hosted by the American Society for the Defense of Tradition, Family, and Property. Now, this is a group that's been cited by the Southern Poverty Law Center for its virulent anti-LGBTQ views, and one which publicly condemns the Black Lives Matter movement. So Care First South Pass felt that their police chief should not align himself with a group that denounced significant portions of the South Pasadena community, nor should public spaces be used to promote such divisive views. We agreed with them. When asked to write a letter to support their efforts to get the chief to change his mind, we did, and the chief did. And we continue to support their efforts to continue to redefine safety in their community. Another group is called My Tribe Rise. It's in Altadena, and it's actually made up of young people who are former gang members. And they're doing mutual aid events like doing food handouts and ways to gather up gang members, former gang members, people who might be thinking about it, to unite, to recognize that they and we are all actually one tribe. And in doing that, to get the gang members to come up with a truce and reduce the gang shootings, which have been increasing in the Altadena area. One of our commissioners is a distinguished former educator, and she's been working with the group regularly, providing the long overdue wisdom and recognition and support that these young people who are turning their lives around and having a positive impact on their communities so need and deserve. So she introduced the rest of us to on the ad hoc committee to them, and we're developing a relationship in order to support their work. And one of the first things that several of our committee members did was to attend a virtual community meeting that My Tribe Rise organized. It was well attended by a host of DINA organizations. We recognized right away that the My Tribe Rise young people are well respected in their community for the good work that they're doing. And the whole meeting was on public safety and police accountability. They were a little frustrated over an earlier community meeting about public safety and police accountability, which had largely excluded community voices. And they wanted to have the community speak. And one of the most compelling aspects of the meeting was the presence of an African-American police officer who both works in the community and lives in the community. I see that. It was clear he was a familiar participant. And it was clear that he rejected pretty much any and all criticisms of the police. No matter how well documented, he would say, nah, they just hate us. But it was also clear that the My Tribe Rise and the other community members were clear that he and they were neighbors, that they were going to need to keep talking and working together. And despite all of his griping about, is this an attack on the police, when he was finally asked, what does this community need? He didn't say more police. He said more jobs, more healthcare. The last thing I guess I'll try to sneak in real quick is some work that we're doing with the Long Beach Police Department's Community Advisory Committee. One of our staff is facilitating their work with the police department there in reviewing their trainings and use of force policies. And one of the things that I like the most about what he was able to do is have an impact right away on expanding the committee's membership to include young people from the Youth Justice Coalition, thereby ensuring the young people of color, the young Michael Morse, who probably would have been overlooked when he was younger, before he decided to actually go to law school and do all that stuff, those folks who've been negatively impacted, those folks who have the experiences that he had, those folks who were like his friends who got arrested, that they'd be on the advisory committee so that all of the voices of the Long Beach community would be represented in this important endeavor. All of the community be a part of that. I know I'm running out of time, so I will just end by saying there's more stuff that we've done, there's more stuff that we're going to continue to do, and I'm happy to take any questions that you have in how we're trying in our own backyard to improve policing and community relations right here in Los Angeles County. Thank you.
Thank you so much, Professor Gunning. I would really love to see some hands up there because I know there are quite a few, and we definitely need one for Professor Williams in particular, since I rudely cut him off in the beginning. Vache, please go ahead.
Hi, thank you all. My question is about the war on drugs. I know Judge Rutledge, you mentioned that. So I guess my question is for you, and maybe Professor Morse can jump in as well. What impact the war of drugs has had on warrants and no-knock warrants and on pretextual stops, and what kind of reforms would you like to see on the war on drugs, and if that would have any sort of impact on the ills that both of you were talking about.
I would love for Professor Morse to jump in as well, but I'll get started. I think it has made us enemies. First of all, we're losing the war on drugs, right? We've been doing this, I think, since the 70s or 80s. I mean, there have been, and then when Reagan became president, it just got ratcheted up even more. And so we haven't yielded the results that we wanted to. Plus, with this new relationship of looking at people addicted to drugs as having a public health issue, I think is a better way to go. You know, there have been arguments about legalizing drugs, and I don't know if that will help or not, but certainly the war on drugs has been a losing battle. You had a second part of the question. I already forgot it. What was the second part?
Just what reforms you would like to see if it would have an impact.
Besides ending the war on drugs, you know, I really think we need to stop having militarized searches, flashbang grenades, SWAT teams, missing uniforms on drug cases with low amounts. And what we've been seeing in my practice is that they'll do an undercover buy bust, maybe, to actually support a confidential informant saying, hey, someone's selling drugs out their house. And then they'll just go all military on them 100%, and bad things happen. And it's just not worth it. It just isn't worth it. So I want to end to that. This kind of militarized thing needs to be reserved for hostage situations, human trafficking, terrorists. Not someone who's selling a bag of 1 gram, which is like a sugar packet of crack, out of his house.
And I'll just jump in. I agree with Professor Rutledge, and I agree with her assessment that we are losing the war on drugs. What I would add to that is, you know, we're not, in fact, fighting a war on drugs. Drugs are an inanimate object, right? The war is on people. Who we believe may be possessing, trafficking, otherwise using drugs. And the people are definitely losing that war. And so with respect to the Fourth Amendment and search and seizure laws that have emerged in light of this quote unquote war on drugs, as you can see, if you've taken constitutional criminal procedure, if you haven't, you soon will, the so-called war on drugs has caused the Fourth Amendment case law to essentially the rules to break under the weight of the exceptions. And so that's an issue. But I think with respect to what reforms we can implement, I think we need to take a creative look at how police and their involvement is in terms of traffic stops and traffic violations and the like. Most of our interactions with the police as a community, no matter what community you're in, is with that traffic officer. And to what extent do we need a police officer that we're also asking to run into a burning building after an active shooter to also give you a ticket when you make a U-turn that's against the light? They're completely diametrically opposed sort of roles, and we're asking the person to be at once a warrior and a customer service provider and an implementer of very specific laws. And what we found is that in those interactions, those traffic stops around traffic violations, to the extent that we have police filling those roles, have taken the opportunity to execute the war on drugs and to sort of, use those legitimate interactions with the community as a way to discover bigger fish, if you will. So, not with respect to the knock and announce stuff, that's Professor Rutledge's expertise. But I would say in the area of traffic stops and things of that nature, if we can reimagine, if that's the word that people are using nowadays, how we police traffic stops. In other countries, they use technology. They use, for example, parking enforcement, who have the duty or the ability to pull you over. If you run, then they call the real police, if you will, right? But we need to think about to what extent are we stretching the police too thin to their credit and asking for a sort of a disparate and unreasonable sort of rules or roles that they play. And to the extent that we can negate the abuse of that role by having maybe another body in charge of, if you will, the day-to-day interactions with the community on very minor things such as traffic violations. I think that would take away a lot of the abuse that occurs around the war on drugs.
Yeah, can I jump in on that too?
Oh, absolutely.
Because I just want to expand on what Professor Moore says, because I do think that behind the popular, sometimes polarizing chant of defund the police, right, is really this reimagining, which would really shrink, right, those aspects of law enforcement that require something that I still don't want them militarized. I just can't go with that. But nonetheless, could require of them a more violent or aggressive response to what they meet. And to just not have what we think of as that kind of traditional law enforcement, not just not doing traffic stops, but they're not going out to intervene with people having mental health problems. They're not going to talk with homeless people, right? Because that's not really what they do. They'll tell you that they don't do that. Our big issue is find houses for people without housing, and then send social workers who know how to talk to people who are in trouble and mental crisis or having a mental crisis because of drugs to get them the services they deserve. So there are just a lot of things that even cops will tell you, this is not what I trained for. You know, I don't want to be chatting with people who are having custody disputes. That's not the thing that I signed up for. So we really, a lot of what's behind that is not so much that, you know, we hate cops or anything like that. I mean, there are a lot of different definitions for defund, but I think one of the things that we want to think about in this reimagining is how many things are we asking cops to do that really we don't need somebody with a gun and a taser to be doing at all.
Thank you. That reminds me, I think it's Wittgenstein or one of those old dead philosophers said, if all you have is a hammer, everything looks like a nail.
Mm-hmm. Mm-hmm.
That's the thread. So Heather Nicholson had raised her hand on the chat. Heather, please go ahead.
Okay, can you guys hear me? Oh, thank you. Okay, so Mr. Williams had discussed in the beginning how difficult it had been as far as challenging the death penalty despite all the evidence of racial bias, unequal prosecution, and all these government-sanctioned killings. When Professor Rutledge, you were talking about this whole notion of officer safety. So I'm a public defender in Compton. I've done so many motions to suppress, and it's always officer safety is always the exception, always the get around. We've seen it even with the sheriff gangs, with the executioners and things like that. And I guess my question to you guys is, how do we gather this data? How do we challenge these things? And I mean, if it doesn't work for the death penalty, how is it going to work to even start saving some of the last little bits of constitutional rights that these people in these communities start to have when officer safety is this politically accepted way of just saying racist or biased or whatnot?
I don't know if you want to start, Ken, but I'll jump in. It's a really hard issue because officer safety is legitimate, but it's overused, right? And it is the perfect get around. The same thing about when officers shoot unjustifiably and they say they were fearful. So the law needs to change. And I think one of the biggest problems is that we got rid of the exclusionary rule for things like the no-knock warrants, because if we could at least have some kind of oversight after officers make the decisions that they make with body cameras, that may be able to curve the tide a little bit. But I am all about balance. I value the police, and officer safety is a real thing. And there are police that get injured, but we have to find balance where it's not being overused. And you're absolutely right. It's the get out of jail card every single time.
And I would add that it's important, even though in court it's going to be difficult, the courts are totally unreceptive to statistical evidence. I still think it's important to gather that information. In Virginia, for instance, they're in the process of repealing the death penalty. Well, one of the things the legislature and the governor has cited to is the racial imbalance in the application of the death penalty. So it does have an impact in moving legislatively, if not judicially. So I think it's very important to still gather the information on the disparities, and that will ultimately, hopefully, lead to change.
Thank you. We have 3 minutes before Abe kills me. Erica, and then Mara Paola, please. Erica.
Hi, Professor Williams. You just started to touch on this, but I wanted to follow back with you about the abolition movement. And I'm curious what your thoughts are on the most viable path towards abolition, whether that is through state legislation, which will be gradual and it could take decades, or whether it is a constitutional vehicle, which realistically would be much more effective and sweeping. And if it is a constitutional vehicle, whether it's equal protection through a reimagining of the intent doctrine, or whether it's an Eighth Amendment challenge building on recent death penalty jurisprudence like Roper versus Simmons and its progeny.
Well, I think this Supreme Court is not going to overturn the death penalty. I'm pretty safe in concluding that. So I think the best path now to repealing the death penalty would be to do it on a state-by-state basis, be that legislatively or judicially within the state court system. Now, we live in a state, Texas, that's probably going to be one of the last states, if ever, to actually repeal the death penalty. So, but in other states like California, you had an initiative that almost passed. So, the more we get the information out, that people understand that this is really not necessary and it's completely unfair, I think that has an impact on public opinion. Death sentences are way down, executions are way down. It is having an impact, even though the Supreme Court is not prepared to overturn the death penalty.
Maria Paola, did you want to add on to that?
Erica really asked my question. I guess the only thing that I would add on to that, Professor Williams, is you mentioned that there's some alternatives or some steps along the way to abolition, and I'm wondering if you can just touch on those a little bit.
Yeah, well, some states have passed what's called a Racial Justice Act, in which a litigant can go into court and say, well, here are the statistics that I presented to you. And the state has to justify, well, why is there this imbalance? So some states have done that, North Carolina, Kentucky. So there are a few things that can be done legislatively, and also in terms of jury selection. As I mentioned before, it's very important who sits on the jury. So if we get more people, African Americans on the jury, that will have a big impact in reducing the number of sentences. So that's another thing that we can work and strive for. That and maybe even judicially that might happen, because even the Supreme Court, this current Supreme Court, has written some pretty strong Batson decisions. So there are ways of attacking the death penalty without an actual abolition of it, which, again, I don't think it's in the cards, certainly not in the near future. I do think one day the Supreme Court will be composed and will overturn the death penalty. I think that will happen eventually, but not, as currently composed. But remember also, Supreme Courts can change at a snap of a finger.
And on that positive note, Professor Williams, thank you. And would you please all join me in thanking our incredible panelists? Back over to you, Abe. Thank you so much, everyone.
You're welcome.
Thank you, Professor Van Lanningham. And yes, thank you to all of our wonderful panelists. I did just want to squeeze in a quick break for everyone. So before our voting rights panel, so please take a 5-minute break, and we'll be back at 3:20 for our voting rights panel.
And good to see all my old colleagues, Mark Hammock and Isabel. And Dave.
Good to see you, Ken.
Okay.
Good to see you all.
Thanks for coming.
Rachel.
And thanks for bringing Angera with you. She was terrific.
Okay.
Oh, thank you. It's been a great panel. Thank you, everyone.
I'm very excited to pass it over to Professor Gauri Ramachandran.
Hi, everyone. It's really great to see everybody. I want to make sure, because I haven't spoken yet today, is everything working? You can hear me? Audio? Okay, great. I'm getting some thumbs up, so that's fantastic. And I apologize, the lighting is very odd. I'm in my kid's school classroom and isn't really set up for Zoom meetings very well. But it's really great to see everyone, and I'm so happy to see all of you for our last panel today on voting rights, which is, of course, as many people say, the right that secures so many other rights, and is, of course, as we've all seen over the last 4 years, but especially over the last couple months, it's a right that is in some danger and needs some preserving, and the rights of Black and Brown voters in particular, not only to vote, but to have their votes counted and respected, is under some threat right now. So I'm really excited for our panel today. We have amazing speakers, and I'm going to start with Chris Holland, who I'm super honored to introduce. Chris is an attorney. He's a 4th generation Houstonian, and he is the former county clerk and chief elections officer of Harris County, Texas. He's in private practice currently at Holland's Law Group, but he served as the clerk of Harris County in this past election, extremely contentious election, and of course, extremely difficult election to provide safe and secure voting given the pandemic. So he developed his commitment to public service through the example of his parents and their devotion for improving the lives of others. His father served for 34 years in the Houston Police Department, and his mother, Christy, was an administrative assistant and raised Chris and his two sisters and more than 20 foster children, which is amazing. Before he went into private practice, he worked in some of the world's most distinguished professional service firms as a management consultant. He used analytics and organizational best practices to transform public safety, and he also served in the White House Office of Presidential Personnel. He has a BA in poli-sci with Phi Beta Kappa honors from Morehouse College. He also completed JD from Yale Law School and an MBA from Harvard Business School at the same time. And today he is admitted in the state of Texas. When he was county clerk very recently, Chris made it really a priority to protect the right to vote for 2.5 million registered voters in Harris County. So he implemented the Safe Elections Plan, which was 24 initiatives that were designed to ensure that the 2020 elections would be safe, secure, accessible, fair, and efficient. And so he implemented many things for the first time in Texas, like 24-hour voting, drive-through voting, expansion of vote by mail for those who were eligible in Texas to use that option, and over 800 locations where voters could cast their ballots in person safely. Since he finished his term as county clerk, he's continued to serve as an advocate for voting rights, democracy, and good government. And he says that he believes our state and our nation must, in addition to addressing countless issues to improve the human condition, protect the basic elements of democracy for all citizens, so that government of the people, by the people, and for the people shall not perish from the earth. He lives in Houston's 3rd Ward with his wife Morgan and their daughter Vivian and their son George, and they attend the Wheeler Avenue Baptist Church. And with that, I'm going to turn it over to Chris. I do want to add one thing to his bio, which is that not only did he implement all of those things during this recent election, he did it without the encouragement and support of state level officials. He did it really with people trying to undermine him at every turn, and he didn't back down, and he stood up for voters the entire time. So I'm really, really honored to introduce him. Take it away, Chris.
All right, well, thank you so much. It's my honor and my pleasure to be here with you all this afternoon. I want to first start by just making a very obvious statement. Well, something that you may find obvious, which is that every vote counts. And the reason I think it's worth stating is because, in my former role as the election administrator, while most election administrators want their constituents to have the ability to cast their ballots and to do so fairly, safely, and conveniently, the majority, I would say, are more focused on making sure that nothing that they did would sway an election. There's something called the election administrator's prayer, which essentially says, Lord, don't let this election be close. Because if it's close, then what I do gets scrutinized. And if it's not close, then we're good. And regardless of what happened with, any individual voter, we know that the result is, the fair result. But if you take that mindset, that, hey, look, candidate A won by 100,000 votes, it's clear that's the victor. And so even if you had an issue getting to the polls, not a big deal, then that starts to chip away little by little, at a basic tenet of democracy, at a fundamental right that we have as citizens of this country. And so when I became the county clerk of Harris County, Texas, I made sure that, our North Star was to protect the right to vote for every single eligible voter that we had. And so, I want to talk to you just a little bit this afternoon, specifically focused on issues that voters of color can typically face. And you don't necessarily need to say voters of color, but you can say, voters who are disadvantaged in any way, voters who live in a certain part of town, voters who speak a certain language. But every part of society has its haves and its have-nots, and that is no different when it comes to placing your ballots, when it comes to having your voices heard at the polls. So I want to talk about some of the challenges that these communities can face. What was specific to some of those challenges in Harris County and in 2020, and how some of those were exacerbated by COVID-19. I also then want to talk about what my office did, and perhaps there were some examples from other administrators as well, to try and address some of these issues, to ensure equal access. And then finally, because this is a law symposium, I want to talk about some of the legal challenges that we faced and some of those outcomes. So let's jump in here. Let's talk about issues that disadvantaged communities can face during elections. And it may not come as any surprise to you that these issues are vast and widespread. Some of them are intentional. Some of them happen perhaps not intentionally, but certainly due to a lack of focus on ensuring that they don't affect these communities. And so I'll just start to walk through some of these. I'll start off at a very basic level. If you're going to cast your vote, you have to be registered to vote. You have to know how to vote. You have to know where to vote and be able to access that place. And then you ultimately have to make that decision. Being registered to vote for certain communities can be the hardest step in the process. And in states like Texas, it's even harder on nearly every scale of voter centric laws. Texas comes in dead last or close to dead last nationwide, and voting registration is no different. We're one of the few states that doesn't have automatic voter registration or some type of online voter registration. And so every voter registration in the entire state of Texas, a state that has 29 million people, has to be done on a sheet of paper with ink. In addition to that, while there are many, many, many groups and individuals who are passionate about voting, who, if they could, would spend limitless amounts of time going door to door to register voters, doing that is extremely difficult in the state of Texas. For someone, if Chris Hollins wanted to go to my neighbor's house with a voter registration form and say, hey, Mr. Lewis, are you registered to vote? If not, I brought this form for you. I brought a stamp and an envelope. Why don't we get this signed and send it in for you? That's a felony in Texas. The way to get around that is to become a volunteer deputy voter registrar, which means that to do so, you need to take a course to be qualified to get someone to fill out this most basic form and submit it. You also have to do that in every specific county in which you want to be active as a voter registrar. And in Texas, we have 254 counties. And so if you wanted to do this as a job, if you wanted to do this as a volunteer, there are numerous hurdles that keep you from doing it and ultimately make it harder for those who don't take it upon themselves to proactively register to ultimately do so. Of course, COVID-19 makes that even more challenging. Going door to door during this time is not safe. And I know you all are there on the West Coast. Here in Texas, although it's, I'd say, significantly more open than certain other parts of the country, going door to door is something that in many cases is forbidden, by government agencies, by nonprofits who would normally do this kind of work. And so it's become that much more difficult to register to vote. But let's say you're registered, then you have to know how to vote. If you voted before, you know how to vote. If your parents took you when you were younger, like mine did, you see it's a pretty straightforward process. You may have even got to go through some sort of simulation. But for so many folks in these disadvantaged communities, whether they're newer citizens or have recently come of age or have simply never been engaged previously, not knowing how to vote is a real hurdle. And, there are feelings of embarrassment or shame associated with just not knowing. And that's a true deterrent for people. They think they might go in, not know what's going on, be embarrassed and just say, hey, it's not worth it. Knowing where to vote. In communities of color in particular, what you tend to have is fewer voting locations. And where there are voting locations, they often are not accessible by public transit. The locations might move around from election to election. And so there may not be a traditional place to vote. Or, in times like COVID-19, there can be a consolidation. There are numerous jurisdictions across the country and many in Texas who during this spring and summer, when there were runoff elections, proactively closed many locations. I think the prime case that you saw was, I want to say, in Louisville, Kentucky, where the entire city had one voting location for safety reasons, or at least it was said that this was for safety reasons. That can be a real challenge for folks. You have to make that easy. And certainly, once you know how to vote, you know where to vote, you have to be able to access these sites, have a level of service at those sites, not be deterred by a long line. And these are very practical things that can be impacted by decisions by election administrators. What else? I guess this might be the most obvious. Active efforts to suppress votes. Here in Harris County in 2016, there were white nationalist biker gangs who showed up during election season, who targeted areas that were known to be African-American parts of town, and who showed up in front of voting centers with the sole purpose of intimidating voters, deterring voters, ultimately making it less likely that they would cast their ballots. And then we've seen other examples like that across the country. In 2020, I think the most prominent one was in Virginia when early voting started. I want to say in late September, where there were crowds of voters who were blocking entrances to voting centers. That type of open intimidation, has not stopped in this country. I was just on the phone with a gentleman from East Texas yesterday who had Democratic, and I don't want to make this a partisan speech, but who had Democratic signs in his yard and began to receive calls from anonymous people giving him warnings about those signs. And ultimately, this gentleman's had cows who were shot. These efforts at intimidation are not rare, unfortunately, in Texas in particular, and certainly across the southern United States. And then finally, you have legal challenges. Again, these are slightly more veiled than murdering a man's cows, but not much more veiled. These are active efforts to try and take the franchise away from certain groups of people. Where you saw this the most, obviously here in 2020, were the efforts by Trump supporters to invalidate the votes of millions of people, particularly in Black cities across the country that were in states that Biden ultimately won. Here in Harris County, and I'm going to go into this in more detail a little bit later, but we were the center of numerous litigation attempts challenging us on concepts like drive-through voting, like mail ballots and mail ballot applications, and even on emergency ballots that were intended to allow sick people to vote during the time of COVID-19. And so there are no shortage of reasons why folks in communities of color and other disadvantaged communities across this country vote less than their peers in other parts of their counties and their states. But we took it upon ourselves to do our best to empower voters, to try when we can to snuff out and to reverse some of these causes of injustice and voter suppression, and frankly just voter inconvenience that might lead to decisions not to vote. And during the time of COVID-19, to make sure that votes were cast safely, and also were cast with the peace of mind that their votes were going to be counted. And so I'm going to talk about just a few of those examples. I mentioned locations. People need to know where to vote and have access. What we found when I became county clerk, and let me share the very quick anecdote about how I became county clerk. The county clerk is an elected position in Harris County. I was not elected. We had an elected county clerk who, in May of this year, abruptly resigned because of health reasons. She is a 70-year-old woman. And as you may know, being an election administrator is your front line. You're out in public on a regular basis. She had some underlying health issues that she thought might be exacerbated by COVID-19. And she made a decision for herself and her family to no longer serve in the position of clerk. And so I was appointed just 4 weeks before our July primary runoff, which was to be the first election held in Harris County during the time of COVID-19, and handed the keys. And you heard a little while ago about our SAFE plan, but over the course of the first week and a half of my administration, we developed a set of 24 initiatives to ensure that our elections could be safe, but could also be secure, could be accessible, could be fair, and could take place in an efficient manner to better serve the 2.5 million registered voters of Harris County. And so many of the things that we did were as part of that plan, were to solve these issues that I just spoke through. The first one was just the number of locations. We found that there were numerous areas, suburban areas, and there are also even rural areas in Harris County. It's a massive county, but also densely populated urban areas, particularly areas where people of color resided, that did not have access to vote in a convenient manner. And during the time of COVID-19, we also knew that the more spread out we could have voters, the safer it would be. And so we tripled the number of early voting centers across Harris County. Back in 2016, there had been roughly 40, and we had over 120 locations. We made sure that historically important locations like churches and schools and community centers were able to stay open whenever possible. There were a couple of locations that, because of the size of them, they were quite small. You just could not, in a safe manner, administer an election inside the room that was allocated to us there. And so in those situations, we staffed a person to remain at those locations, to be able to talk to any voter who would come up and direct them, hopefully just across the street or down the block to a nearby voting center. Improving service at locations. As was mentioned previously, we extended the hours of voting. We made sure that there were late night opportunities and even 24-hour opportunities to vote. These weren't gimmicks. There are folks who do shift work here in Harris County at the Port of Houston. There are electricians and welders who get off of work at midnight or 2 a.m. In our medical center, which is the largest medical center in the country, there are doctors and nurses who have been working around the clock since February and March of 2020 to save lives. And we allowed those folks to vote at a time that was convenient for them. We introduced drive-through voting, a much safer and much more convenient way to cast ballots. We decreased wait times to to the point where during early voting in November and on election day of November 3rd, there were nearly zero waits across the entire county. And where there were waits, we were transparent about that. You could look online and see the wait time at various locations and choose the location where you cast your ballot. We also engage voters in ways that we never had before. We drastically improved our social media presence. We had celebrities and sports teams like the Houston Rockets, Houston Texans, the Houston Dynamo, our soccer team, to help with messages, increasing awareness around voting and sharing the information like how to vote, how to fill out your ballot, how to use a sample ballot, how to apply to vote by mail, that people had not been exposed to before. And we made sure that seniors had access to vote by mail applications. We made sure that jail populations who were entitled to vote had access to vote by mail applications. And we took our battles to court when we needed to. And so with the few minutes I have left, I'll talk about that, and I'm happy to take any questions. The two most significant efforts that we faced in court, one was around our efforts to share vote by mail applications with everyone across the county. Texas was only one of 5 states that didn't allow any voter who wanted to, because of the safety issues involved with COVID-19, to cast their ballots by mail. In Texas, you have to fall into some very specific categories. But information about those categories and who qualifies is not readily available anywhere. And so we made the effort to share this information with everybody in the county. But we were sued by our Attorney General and our Secretary of State, who did not want us to share that information. And ultimately, we were able to share that information with seniors. We were able to proactively send those applications to folks in jail. But we did lose at the Supreme Court level in being able to send vote by mail applications to younger voters. But we were much more successful in protecting drive-through voting. We were sued by the Republican Party of Texas, as well as numerous Republican elected officials around allowing people to vote from the safety and convenience of their vehicles. We were ultimately mandamused at the Supreme Court level. And in Texas, we have elected judges. That Texas Supreme Court is made up of 9 Republicans who have certainly been against many of our efforts to expand the right to vote in Harris County and ensure access. But that Texas Supreme Court outright dismissed these claims, and that was actually a very positive time in our democracy to see, regardless of partisan sentiment, this court meet its oath and dismiss these frivolous actions. But then we were sued again, and this time in federal court. And there was fear that because of Justice Barrett's recent appointment, that this would be marched up to the Supreme Court, and that ultimately more than 100,000 voters who cast their ballots through drive-through voting would be disenfranchised. That came to a head at a hearing in federal court the day before the election on November 2nd. And I'm out of time here, but ultimately what happened there was that a judge who was a conservative judge who had been appointed by George W. Bush marched through our issues, particularly around how drive-through voting related to Texas election code, and ultimately dismissed this case as well. That was affirmed in the Fifth Circuit. And so those 127,000 votes that have been cast through drive-through voting in Harris County were upheld. And we were proud to be able to protect the right to vote in Harris County. I've run out of time here, but again, it's my pleasure to be here with you this afternoon, and I'm happy to take any questions later on in the program.
Thank you so much, Chris. That was amazing, and it's a lot to pack into the time that you had, because you did a lot, right? Like there's so much to go over, and I'm sure people are going to have questions during the Q&A about that litigation and just the impact of it, even when you do win, right? And even when you do get those voters' rights upheld. So we're going to move on to Patrick Berry next. So Patrick Berry is a fellow and counsel in the Brennan Center's democracy program. The Brennan Center is a nonprofit think tank public advocacy organization affiliated with NYU Law. And Patrick, so I know Patrick in my current work, and he's fantastic. We're really lucky to have him. He focuses on voting rights restoration and on promoting fair, diverse, and impartial courts. When he was in law school, he was a law clerk at Citizens for Responsibility and Ethics in Washington in open primaries. He got his undergrad degree at the University of Central Florida and his JD from University of Pennsylvania Law School. When he was there, he participated in a legislative clinic, and he was executive editor of the Journal of Law and Public Affairs. And he's just really a wonderful person to work with and really brilliant. So I'm really excited to hear what he has to say.
Well, thanks again for the invite, and it's very nice to see you, gallery. I have a PowerPoint, so let me just try to get set up. Can everyone see it? Okay, great. So hi, everyone. I'm here to talk to you today about a different barrier that kept millions of Americans from voting in November. So as many as 5.2 million Americans are barred from voting because of a felony conviction, nearly 1 million fewer than in 2016. Most citizens are incarcerated, they're home, working, paying taxes, going to school, and raising families, yet they're not allowed to vote. In fact, only 25% of people disenfranchised are in prison or jail, while only 22% are on felony probation and 10% are on parole. The remaining 43% have completed their sentences but still can't vote. These voting bans disproportionately affect Black Americans. Nationwide, 1 in 16 Black adults are disenfranchised because of a felony conviction. And in some states, the rate is much higher. In Wyoming, for example, more than 36% of Black voters are disenfranchised because of a felony conviction. And in Mississippi, the state with the highest disenfranchisement rate overall, it's about 16%. Latino Americans are also disproportionately impacted. Over 560,000 Latino Americans, or over 2% of the voting eligible population, are disenfranchised because of a felony conviction. There is a deep and troubling history of racism driving felony disenfranchisement laws. After the Civil War, states passed disenfranchisement policies to bar people with criminal convictions from voting. These laws were passed in addition to other voting restrictions like poll taxes and literacy tests. And as these laws spread, states began creating lists of crimes they believed were most likely to impact Black voters. Additionally, states with higher proportions of Black residents were more likely to pass harsher restrictions. And these laws weren't limited to the South. At the very time the 14th and 15th Amendments were enacted, they forced New York to remove its property requirement for Black voters, which led to the state changing its law from allowing to requiring criminal disenfranchisement. California's 1879 Constitution provided no native of China, no idiot, insane person, or person convicted of an infamous crime could vote. And just 9 years before that Constitution was adopted, the state refused to ratify the 15th Amendment. As you can see from this map, felony disenfranchisement laws vary widely across the country. 18 states bar people from voting only while they're in prison. Those states are noted as light blue on our map, whereas Vermont, Maine, and Washington, D.C. never take the right to vote away, meaning people in prison can vote. Those are in dark blue. The remaining 30 states fall somewhere in between. Some states prohibit people from voting while they're on probation and or parole, while others impose additional waiting periods or even require payment of court debt. Some also permanently disenfranchise those convicted of certain offenses unless they receive a pardon from the governor. Even within a single state, the rules can be complicated, contingent on things like the date and type of crime a person was convicted of. In Alabama, for example, people convicted of crimes of moral turpitude are prohibited from voting since the turn of the 20th century. But until 2017, the state actually never explicitly said which crimes convicted to ones of moral turpitude. giving local election officials wide discretion to block people from voting because of different crimes. Few people also know the difference between parole and probation, yet in 3 states, Connecticut, Louisiana, and New York, people on probation may vote, but those on parole may not. Connecticut's law is made even more confusing by the fact that only people convicted of felonies in another state or in a federal court are required to pay outstanding court debt before they can register, but those convicted of a felony in a Connecticut state court do not have to pay court debt before they can register. Election officials also receive little or no training on these laws, and there is little or no coordination or communication between election offices and the criminal legal system. These factors, coupled with complex laws and complicated registration procedures, result in the mass dissemination of inaccurate and misleading information. And this confusion has real consequences. In rare cases, it can lead to people being prosecuted for mistakenly voting despite being ineligible to vote. Perhaps the most notable example of this happening is Crystal Mason, a Black woman in Texas who was sentenced to 5 years in prison for illegally voting, even though she didn't know she was ineligible, and ultimately her vote wasn't even counted. More commonly, this confusion results in the de facto disenfranchisement of untold numbers of people who are in fact eligible to vote, but don't know they are, or refrain from voting out of fear of breaking the law. Even worse, the disenfranchisement of one person can also have spillover effects throughout their entire family and communities. In other words, eligible voters who live in neighborhoods where felony disenfranchisement runs rampant turn out to vote at lower rates. Despite the damaging impact of these laws, efforts to challenge them in court have largely been unsuccessful. Richardson versus Ramirez is the leading precedent that courts rely on to reject constitutional challenges to felony disenfranchisement laws. And in that case, the United Supreme Court held that states are granted an affirmative sanction to disenfranchise those convicted of crimes. Since that decision, advocates have attempted to challenge felony disenfranchisement laws under the 8th and 24th Amendments, but those efforts have largely been unsuccessful because courts, following Ramirez, have evaluated these state laws under a more deferential rational basis review as opposed to strict scrutiny. Several circuit courts have also held that Section 2 of the Voting Rights Act, which prohibits states from denying anyone the right to vote based on their race, does not apply to felony disenfranchisement law, while others have held that proof of intentional discrimination is necessary to challenge these laws under Section 2, which is just an incredibly difficult burden to prove. Challenges under state constitutions have fared similarly. Last year, for example, a Minnesota court dismissed a lawsuit challenging the state's policy of disenfranchising those on probation, holding that the plaintiffs hadn't shown that people convicted of crimes have a fundamental right to vote, nor that the state lacked a rational basis to deny that right until probation periods have been exhausted. A North Carolina court, on the other hand, struck down a portion of the state's law that blocked people from voting only because they still owed court debt, holding that such a requirement violates the state's constitution because it conditions the ability to vote on one's financial means. Fortunately, there's been a growing movement among state legislators and other leaders to restore voting rights to people with felony convictions. And as a general matter, it bears noting that this is an issue where there has been a history of bipartisan interest and success. And even more importantly, this is a movement where these efforts around the country are actually led by individuals who are, directly impacted by the criminal legal system in that, they have a family member or them themselves, and also people that are prohibited from voting. So in the last 20 years, over a dozen states have taken some action to extend the vote to those with felony convictions. In 2018, Louisiana's Republican-controlled legislature passed a law restoring voting rights to tens and thousands of people on probation and parole, and that law was signed into law by the state's Democratic governor. In 2019, Arizona's Republican governor signed into law a bill that removed the requirement that people convicted of a first-time felony offense pay off their restitution before having their rights restored. 4 states, California, Colorado, Nevada, and New Jersey, all enacted policies restoring voting rights upon release from prison, and Washington, D.C. changed its policy, joining Maine and Vermont in never taking the right to vote away. Some states also changed their policies through executive orders. In 2018, New York's governor, Andrew Cuomo, began using his pardon power to restore voting rights to people on parole. The next year, Kentucky's governor signed an executive order restoring voting rights to more than 100,000 people convicted of non-violent offenses who had completed probation or parole. And last year, Iowa's Republican governor issued an executive order restoring voting rights to tens and thousands of Iowans previously barred from voting for life, bringing an end to the state's policy of blanket disenfranchisement. And rights restoration also became a part of the national dialogue, with all major 2020 Democratic candidates for president taking a position on the issue. California is the most recent state to change its policy, where voters approved an initiative I'm sure a lot of you have heard of and hopefully voted in favor of, but Proposition 17 in November, amending the state's constitution so that anyone who's not currently in prison for a felony conviction can vote. Prior to Proposition 17, California's constitution barred people with felony convictions from voting while they were in prison or on parole. As a result, as many as 50,000 people living in the community, a disproportionate number of whom were Black and brown, could not vote. And California was also one of a very small number of states that I mentioned previously that excluded some people on community supervision from voting, but allowed others to vote. And California's law was arguably even more confusing than those states, because California actually has 4 different forms of community supervision. And those are probation, parole, mandatory supervision, and post-release community supervision. And prior to Prop 17, only those on parole couldn't vote, but everyone else on those 3 other forms could vote. So nearly 60% of Californians voted in favor of Prop 17, which also got more yes votes than the 11 other initiatives on the ballot. And in all, over 400 prominent individuals and organizations endorsed the measure, including state and national elected officials, businesses, civil rights groups, conservative groups, faith groups, labor unions, law enforcement associations, student groups, as well as celebrities and activists like John Legend. The Brennan Center had the privilege of serving on the executive committee for Prop 17. Supernaturally, all of this progress is not without pushback, the most obvious example being Florida. In 2018, a supermajority of Florida voters approved Amendment 4, a constitutional amendment that automatically restored voting rights to as many as 1.4 million Floridians, except those convicted of murder or a felony sexual offense who had completed the terms of their sentence, including probation or parole. Prior to Amendment 4, Florida's constitution permanently barred all citizens with a felony conviction from voting unless their voting rights were restored by the Clemency Board. And in 2016, more than 1 in 5 of Florida's Black voting age population was disenfranchised. Shortly after Amendment 4 went into effect, Florida's Republican-controlled legislature passed a law requiring all formerly incarcerated people to pay off all of their court debt, including restitution, fines, fees, and court costs before they could actually vote. At least 900,000 Floridians are disenfranchised by this new law simply because they cannot afford to pay what they owe, the majority of whom are Black. And since Florida has no centralized system for tracking whether all of this money has been paid, it is next to impossible to make eligibility determinations. And our client, Pastor Clifford Tyson, provides a perfect example of the problem with Florida's law. Despite a team of lawyers, including myself, and hours of research by local county officials, no one has been able to give him a definitive answer about how much he owes for his convictions dating back to the 80s. Along with the ACLU and the NAACP, LDF, we filed a federal lawsuit challenging Florida's pay-to-vote law on a number of legal grounds, claiming it violated the federal constitution. But as I'm sure you've heard, the results have unfortunately been a mixed bag. After an 8-day trial, which was conducted entirely by video because of the pandemic, a federal judge held that the law was unconstitutional. And in making that determination, he found that the overwhelming majority of returning Floridians would be too poor to pay the amounts they owed. And that's if they could actually find out what they owed. The judge also said that Florida's pay to vote law created an administrative nightmare and that it also accounted to an unconstitutional poll tax on voting. But the state appealed and the 11th Circuit held that the law didn't amount to an unconstitutional poll tax, ultimately barring those 900,000 people who can't afford to pay their court debt from voting in November. Despite this setback in Florida, there's still reason for optimism. So far in 2021, state lawmakers from 15 states are considering bills that will restore voting rights or ease current restrictions for people with convictions. Of those states, lawmakers in Connecticut and Oregon are considering bills that would enable people in prison to vote. In New Mexico, New York, and Washington state, lawmakers are considering bills that would allow everyone who is not in prison to vote. And in Iowa and Kentucky, lawmakers are also considering proposals that would place constitutional amendments on the ballot to automatically restore voting rights after completion of prison, parole, and probation. And in Virginia, just this week, a Senate committee voted to advance a constitutional amendment that would abolish felony disenfranchisement in the state. At the federal level, there's also an opportunity for even more comprehensive reform. Congress is considering the Democracy Restoration Act, which would allow all Americans who aren't in prison to vote in federal elections, regardless of whether they have a criminal record that makes them ineligible to vote in state elections. And the Democracy Restoration Act is included in H.R. 1, the Omnibus Democracy Reform Bill, which passed the House by a substantial margin in 2019. And while it stalled in the Senate, it was co-sponsored by all 47 Senate Democrats. But now the new Congress is poised to advance this historic legislation. In closing, we have a lot of work to do, but if the past couple of years have been any indication of where the country is going with regards to felony disenfranchisement, I'm feeling pretty optimistic. So thank you again, and happy to answer questions.
Thank you so much, Patrick. Super informative as always, super jam-packed with information. And I'm sure there are going to be questions. There's like interesting contrast, I think, between some of the backlash against the sort of pro-voter actions that clerks like Chris took in this last election, and the kind of continued momentum on restoring rights for persons with felony convictions. So I'm going to be really interested in hearing about that from both of you in the Q&A. But before that, we're going to hear from Professor Birchall Ross. So Birchall, I actually met him for the first time at the last in-person conference I went to before the pandemic. It was at UC Irvine Law School. I don't know if you remember Birchall back at, I think it was like February 28th or so last year. And I was so impressed with his talk there, and he's also just really great to chat with. So he is the Chancellor's Professor of Law at UC Berkeley School of Law. And his research is driven by a concern about democratic responsiveness and accountability, as well as the inclusion of marginalized communities in the political process. His past scholarship is in election law, constitutional law, and statutory interpretation, and it has been published in a variety of wonderful publications. The Columbia Law Review, the NYU Law Review, and the University of Chicago Law Review are just a few of them. He earned his JD from Yale Law School and his master's degree from the London School of Economics and Princeton University's Woodrow Wilson School of Public and International Affairs. Before he joined Berkeley Law, he was a Callis Parker Academic Fellow at Columbia Law School, and I'm really thrilled to hear what he has to say today. Take it away, Birchall.
Thank you, Gary. It's great to see you. Yeah, the last conference, it feels like the last time I was out of the house, frankly. I hope everyone's doing well. Thank you, Abraham and the other organizers of this symposium for inviting me to be with you today. I know I think I'm the last speaker, so I'll try to keep this lively and brief because I imagine you all are tired and ready to head out to dinner or go outside or whatever. So I hope everyone that's participating is safe and healthy and that your loved ones are the same. So I'm going to share a PowerPoint slide myself and see if I can pull this up. I should have good experience with this, although I'm quite resistant to Zoom, but here I am zooming away. All right, so let me get a slideshow going. I gotta pull that off. There we go. All right, everyone see it okay? All right, excellent. So I'll try to navigate this. I'm in my basement. I'm on the childcare shift right now, so trying to avoid my child. All right, so we're getting close to a new round of redistricting in 2022. And although the 2020 election gave Democrats control of the White House and the two houses of Congress, they did not do so well in the state legislatures. Despite the efforts of the National Democratic Redistricting Committee, chaired by the former Attorney General Eric Holder, and its backing of 100 state legislative candidates, Democrats were unable to make much of a dent into Republican domination of state legislatures. As Politico reported, on the day after the election, Democrats did not flip a single state house chamber in its favor. And Democrats remain completely blocked from the map-making process in Texas, North Carolina, and Florida, which could have a combined 82 congressional seats by 2022. And nationwide, Republicans will have full control over the redistricting process for 181 congressional districts, while Democrats will have full control over the redistricting process for only 76 districts. 124 congressional districts in 10 states will be drawn by commissions, and 47 congressional districts will be drawn by legislatures in states controlled by both parties. Now, this is important because state legislatures are responsible for drawing districts not only for state legislative seats, but also for Congress. And in the first redistricting round after the Supreme Court's decision in Rutro v. Common Cause, declaring challenges to gerrymandering to be non-justiciable political questions, we can expect perhaps the most gerrymandered districts in the history of this country. Now, what I want to argue today is that partisan gerrymandering is not just a threat to partisan representation in the political process. It is also, with the current orientation of the Republican Party, also a threat to the multiracial democratic project. Now, to understand the threat to the multiracial democratic project, we need to return to the early 1990s racial gerrymandering case of Shaw v. Reno. In that case, the Supreme Court properly diagnosed a potential districting threat to America's multiracial democratic project, but it ultimately identified the wrong source. And only now can we start to attribute the districting threat to the multiracial democratic project to the right source. Now, let me try to explain to you what I mean. In Shaw v. Reno, decided in 1993, the court addressed a challenge by white voters to the state legislature's use of race to draw districts that provided racial minorities with opportunity to secure representation in Congress. Now, the state of North Carolina, whose redistricting practices were challenged, did not draw majority-minority districts on its own. It did so in response to the United States Department of Justice's enforcement of Section 5 of the Voting Rights Act. That act, as enforced in the early 1990s, required that covered states, mostly states in the South, draw the number of majority-minority districts proportionate to the minority population in the state. At that time, African Americans comprised nearly 30% of the population in North Carolina, and the Department of Justice mandated that 3 of the 11 congressional districts be majority-minority. However, due to demographic spread of the African Americans in the state and some partisan considerations as well, the state legislative districts that the state drew were unusually shaped. The white challengers pointed to the unusual shape of the districts and the Department of Justice's demands as support for their challenge to the districting line drawing under the Equal Protection Clause. The challengers argued that the state legislature's drawing of district lines gave rise to an equal protection claim because the state relied on a suspect racial classification. And the court ultimately agreed. The court, focusing on the shape of the district, explained, in some exceptional cases, a reapportionment plan may be so highly irregular that on its face, it rationally cannot be understood as anything other than an effort to segregate voters on the basis of race. As support for its conclusion, the court diagnosed 4 race-based democratic harms that it said arose from the consideration of race in drawing district lines. First, the court asserted a racial reapportionment plan that includes in one district individuals who belong to the same race, but who are otherwise widely separated by geographical and political boundaries, and who have little in common with one another but the color of their skin, bears an uncomfortable resemblance to political apartheid. Second, racial gerrymandering reinforces the perception that members of the same racial group think alike, share the same political interests, and will prefer the same candidates at the polls. Third, the court asserted by perpetuating such notions, a racial gerrymandering may exacerbate the very patterns of racial bloc voting that majority and minority districts are sometimes said to counteract. And finally, the court announced, when a district obviously is created to effectuate the perceived common interests of one racial group, elected officials are more likely to believe that their primary obligation is to represent only the members of that group rather than their constituency as a whole. This, the court concluded, is altogether antithetical to our system of representative democracy. Now, it is this latter democratic harm that the court diagnosed in Shaw v. Reno that I want to focus on today. Now, there are three potential problems associated with this account of the harms from state consideration of race to draw majority-minority districts. First, it just lacks empirical support. Although there is evidence suggesting that minority representatives in majority-minority districts do better represent racial minority interests than their white counterparts representing majority white districts, there is no evidence suggesting that minority representatives neglect their white constituents. In fact, and this goes to the second point, it would be entirely irrational for minority representatives to neglect their white constituents. Legislators are not presidents who get to make policies on their own. Rather, legislators are part of multi-member bodies that make decisions according to the majority or supermajority voting rule for that body. As a result, in order for a minority representative to advance his or her policy goals, she necessarily has to build coalitions with members of the white legislative majority. Recognizing this, it would be entirely irrational for minority legislators to neglect the interests of their white constituents, as this might impede their ability to build cross-racial coalitions in legislatures and Congress, even with members of their own party. There's a second source of irrationality associated with minority legislators' neglect of white constituents. We all know about the racial wealth gap. And in the political process, that racial wealth gap translates into a racial campaign contribution and expenditure gap. The fact is that minority candidates and representatives for office are reliant on white contributors and spenders of campaign money. They therefore literally cannot afford a reputation of neglecting white constituents. As a result, the multiracial democratic harm from the consideration of race to draw majority-minority districts are imaginary at best. And the benefits from such consideration of race, which includes increasing minority representation and voice in the political process, seem to far outweigh these imaginary harms. The court did, however, diagnose a real potential threat from the consideration of race in the drawing of district lines. It just identified the wrong source. The right source for this democratic harm threat, which I consider Republican partisan gerrymandering, is now coming into view. To understand the source of the threat, it is necessary that I provide you with some background. For a while now, the Republican Party has been a mostly white party. In 2018, the Pew Research Center found that 83% of Republican voters were white, as compared to 60% of the US population. In Congress, 91.4% of Republicans in the House of Representatives are white, and 94% of senators are white. In districts where at least 3/4 of residents are non-Hispanic white, 82% elected a Republican representative in 2018. In contrast, 83% of the nation's most diverse districts elected a Democrat into the House of Representatives. These results were the product of a districting strategy in 2010 known as the Redistricting Majority Project, or REDMAP. The goal of this project was to keep or win Republican control of state legislatures with the largest impact on congressional districting. In the 2010 midterm election, REDMAP spent $30 million in typically low-money state legislative races, and the strategy proved effective in securing control for the Republican Party of state legislatures responsible for drawing state and federal legislative district lines. According to data collected by REDMAP, Republicans increased their control over districting from 98 jurisdictions in the 2000 round of redistricting and only 5 in the 1990 round of redistricting to 193 in the 2010 round of redistricting. At the same time, Democratic control declined from 135 jurisdictions in the 2000 round of redistricting and 172 in the 1990 round of redistricting to only 44 in the 2010 round of redistricting. And the result was extensive partisan gerrymandering, mostly by Republicans, due to their advantage in controlling the drawing of district lines. As a result of the mostly white racial composition of the Republican Party, the product of racial partisan gerrymandering was a drawing of the maximum number of majority white districts for partisan advantage. The success of the red map strategy and the Republican state legislatures it produced is seen in this graph that shows the seat bonus, which is the difference between the percentage of seats won by a party in House elections and the percentage of votes cast for that party in House elections nationwide. And what we see here is that between 2012 and 2016, Republican partisan gerrymandering secured a seat bonus of 6 to 7%, meaning that Republicans won 6% more seats in the House than votes cast for Republicans nationwide. Now, this is not a partisan issue. Democrats have done the same thing when they've had control of state legislatures as well. Now, the seat bonus almost entirely disappeared in the 2018 midterm election as a result of the combination of broad popular antipathy towards President Trump and demographic shifts that made some Republican districts less Republican than they were at the beginning of the decade. The successful Republican gerrymander not only had partisan effects, but also racial effects on representation. But before examining the racial impacts, it is important to understand the rise of white identity politics. Ashley Jardina, in an important book that was recently published titled White Identity Politics, finds an increasing embrace of racial and political identity amongst white Americans. Whereas the race of white people has been treated as invisible in the past, it has become much more visible and salient in the present, in part due to the demographic shifts of the United States that is predicted to lead to a majority-minority country by the middle of this century. This white racial solidarity is not principally grounded in white supremacy and outgroup prejudice, although that is part of the story for some parts of the white population. Instead, the primary motivation behind white racial solidarity is a concern with their in-group status and a desire to protect its status from a changing country. Now let me start to draw a more explicit connection between Republican partisan gerrymandering and the multiracial Democratic project. In 2014, 95% of House Republicans were elected from majority white congressional districts. This election, which came in the midst of the second term of the first Black president, was in the middle of a shift in orientation of the Republican Party from using dog whistles to attract white racist voters to using foghorns about racial status threat to attract white voters embracing their white racial identity in the face of racial demographic change. Now, what is concerning about this from the perspective of the American multiracial Democratic project is that the rational calculus of representation for these Republicans, for these Republican white elected representatives from white majority districts is different than it is for minority elected representatives from majority minority districts. For the same reason that it would be irrational for Black elected representatives of a majority minority district to neglect their white constituents, it is rational for Republican white elected representatives of a majority white district to neglect their minority constituents, in the short term at least. Whites are a numerical majority in the population, and as I described before, make up 83% of Republican voters. White Republicans make up over 90% of Congress, and as recently as the 115th Congress that ran from January 2017 to January 2019, Republicans controlled the White House and all in the two houses of Congress. Finally, it remains the case that the color of campaign finance dollars continues to be white. Now, what this all means is that in the short term, there are rational electoral incentives in partisan gerrymandered districts for Republican representatives to stoke racial divisions through foghorn accounts of threats to white racial status and to govern as a white man's party, all while neglecting their minority constituents. So to conclude what I describe as a compound threat to multiracial democracy includes, first, the recent activation and encouragement of white racial identity and solidarity by Republicans who stand to benefit politically as a result of racial partisan gerrymandering. Second, this activation and encouragement of white racial identity that creates and reinforces perceptions that minority democratic gains are a threat to white racial status. And as a result, white identity voters will be inclined to support white representatives who seek to advance white interests at the expense of minorities. Putting this all together, the threat to the multiracial democratic project of growing white racial solidarity and white racial gerrymandering through partisan gerrymandering starts to become clear. So the court in Shaw v. Reno was quite prescient in diagnosing the harm from racial gerrymandering, but they targeted the wrong source. Now that we have a sense of the right source of the threat to the multiracial democratic project, the question is whether the court or anybody else will do anything about it. Thank you very much.
Thank you so much, Bertrell. That was super fascinating and so crystal clear, I felt, in my view, in sort of replacing the term partisan gerrymandering with white racial gerrymandering, and all your data really made it so crystal clear why that sort of replacement of term is really, really appropriate. So I think we're ready for the question and answer period. And so I'm going to use this hand raising function, and everyone, please feel free to raise your hand. The first question I see is from Natasha Comedina. So please go ahead and unmute, Natasha.
Hi, I just want to say thank you to all the panelists. I really appreciated everything that you guys had to say and to explain to us. I think my question is more directed towards Mr. Hollins, but I welcome the other two panelists to chime in if you guys have an opinion about this. Given the given the large amount of voter fraud accusations that were coming out, in the most recent election, and even though those, accusations have been debunked over and over and over again, we keep seeing that there's a large majority of the population that still thinks that it's a very valid thing. And their argument or their justification is, they want to preserve the validity of our election process, and that voter fraud is something that we really need to fight against. So how do you how do you suggest that we sway this, public misopinion? I don't know what else to call it, but is there a way that we can ease those fears or calm those fears to that population without just shouting at them, voter fraud is not a thing, stop worrying about it?
It's a really good question, and thank you for asking it, Natasha. This is tough because, going back to just this piece around, reframing this as sort of, white racial gerrymandering, these calls around voter integrity and voter fraud are truly just dog whistles around minorities and poor people are voting. And the propaganda machine around that just continues. When our governor gave his State of the State remarks just recently, and amongst his emergency items for our upcoming legislative session, COVID-19 was not one of them, but elections integrity was one of them. And we have to just see this and treat this for what it is, which are, efforts by a small group of folks to try and limit a broader group of folks from exercising their right to vote in our system. When it comes to, I just saw a recent poll that it was certainly very aligned with partisan view, but even amongst independents, I think there were something around 20 to 25% of folks who agreed with a statement that there was widespread voter fraud. And I think this calls into the conversation, just sort of a broader challenge around how do we communicate facts in America in 2021, when there are so many folks who are not interested in facts anymore and just want to spew things that they know to be untrue. And unfortunately, I don't have the solution at this moment, but I certainly agree that it needs to be top priority for, particularly for progressives who are kind of grounded in reality.
Did anyone else want to chime in on that one on the panel?
I guess the only thing I'll say is that so long as we're into a team of R's and D's in our country, it's going to be hard to break through in terms of informing people and providing facts that people will buy into and believe about the degree and the threat of voter fraud. So I don't have tremendous hope on that regard. I think in terms of, moving forward, I don't think that those who seek to expand access to the vote should be deterred by these concerns about voter fraud. I think there's one way you can approach it. You could, try to accommodate those people that have concerns about voter fraud that are imaginary, but I think that that's the wrong way to go, because you're going to feed into the notion that there is actually really fraud out there. I think the better response is to push forward through with a access agenda and to maximize access as much as possible, and to defend efforts that are designed to deny the vote with real information that are presented to courts and legislatures about the degree of fraud and the problems and the non-problems that are out there. And so I think that that's the best path to going forward in this extremely polarized environment that we're in. If we get beyond the teams, if we get to a point where we're acting as a political unit again, then we can have a real conversation about how to best sort of promote our democracy and how we can sort of think about and how we should consider the problem of fraud. And I think if we have that real conversation, I think that the concerns about fraud would be greatly ameliorated.
Yeah, and I'll just chime in as moderator as well and note that, it can feel, I think, efforts that people make to ensure that elections are free and fair and transparent and all of those things can feel like they're for naught when you have something like the attempted insurrection that took place on January 6th. But it is important to note that there were a lot of efforts to kind of undermine people of color voting that didn't work, right? Because the country really effectively, and the media and people who were telling the truth over and over again really effectively undermined that. So for instance, there were some attempts to claim that if the sort of vote lean changed between election night and the week later as a result of, the counting of absentee ballots as they got processed, that somehow indicated something wrong or unfair or fraudulent about the election. And those attempts really fell flat on their face, largely because the public was really educated beforehand about how absentee ballots work, and they take time to open and they take time to count and that sort of thing. So I do think there are some efforts that can be made, but I think Bertal's right that when you've got such a partisan lean to just even whether or not to propagate the truth rather than falsehoods on this question, it poses a really big challenge. I want to move on to the next question. I think we have Camila is next.
Yes, thank you. First of all, I want to thank the panel for a very informative presentation. I have a question for Mr. Patrick Berry. So from your presentation, it seems that the states have a lot of discretion in felony disenfranchisement laws. And it's kind of inconsistent where states like Vermont, their criminals or felons are not disenfranchised, and then versus in Alabama or Florida, where they're permanently barred from voting unless they're pardoned. And before you ended your presentation, I was actually wondering if it was possible to have a more national or uniform standard. And you did bring up I think it was called the Restoration Act, or Democratic Restoration Act. And so I wanted to ask if you could elaborate more on that, or if you have any thoughts on having a more like a national standard rather than giving discretion to each of the 50 states.
Sure, so that's a really great question. So with regards to Maine and Vermont, I mean, part of my presentation talked about the history of felony disenfranchisement laws. And it should come as no surprise that, Maine and Vermont are two of the whitest states in the country. And it really just is incredibly clear that felony disenfranchisement laws have one purpose, and that purpose is to suppress the vote of people of color. People of color are more likely to live in communities that are over-policed, and they're more likely to, go to prison or be on community supervision for crimes that white people commit as well. I think, that's certainly a difference between Maine and Vermont and Alabama and Florida. With regards to your question about having a national standard, so the Democracy Restoration Act would allow everyone who's not in prison to vote in federal elections. And the reason for that distinction is, for the most part, states have control over how they run their elections. And so it's very complicated, but I'm sure there's an argument where you could have, a federal standard, but I'm not sure what the strongest argument there is. But for the most part, states control their elections, and that also comes down to, who's qualified to vote.
Okay, the next question, next person I think on our list to ask question is Alejandro.
Hello. First of all, I want to take an opportunity to say thank you to Professor Ramachandran for helping us put this panel together. She was in the trenches this last fall, fighting to protect the right to vote, and fighting in jurisdictions all over the country, and at the same time helping us put this panel together. So thank you, Professor.
And you were in the trenches this summer with me, so don't don't knock your own contribution.
My question is about independent commissions to draw candidate maps. We have that here in California, and I think Professor Ross, you mentioned that there's a number of states around the country that have already set up these independent commissions, but it seems like there's been an effort to get more states to do that, but it's kind of slow rolling. I would just love to get your thoughts on where that fight is and how that is progressing in different states, because it seems like, if we could, get to the heart of gerrymandering, it would solve, or at least it would alleviate a lot of the issues that we are facing in terms of polarization and things like that.
Yeah, I think you're right. Absolutely right, Alejandro. Independent commissions are definitely an important part of the solution. And I think there's been some progress. It is slow, but we did have Virginia pass an initiative that established a redistricting commission in that state. Michigan did so recently as well. So you're starting to build up some momentum. The major roadblock in place of commissions is the fact that not every state has a referendum or initiative process. And if you're in a state that doesn't have a referendum or initiative process, then you're relying on your legislature to exercise, say, self-restraint and establish a redistricting commission that will take away its powers over districting. And as you imagine, many state legislatures don't want to do that, because not just simply the partisan advantage that they stand to gain from drawing district lines, they're thinking about their incumbency advantage. They see district lines and drawing their own districts that will, allow them to pick their voters rather than the voters picking them, preserves their time in office and removes or lessens the electoral threat that they might face if an independent body was responsible for district lines. So this can be addressed, though, through federal legislation. And like Patrick was saying, the Congress does have considerable power over federal elections, including the drawing of district lines for congressional districts. And so you have an HR 1, the For All America Act. I forgot what the name of the bill was. It has a provision that establishes independent redistricting commissions to draw congressional districts. And that would be an important move in the right direction. And I think if you can set that example, then it puts pressure on state legislatures with respect to drawing their own district lines, because there's people are saying like, well, we do this for congressional districts. Why are we allowing you? It just seems like an anomaly to allow you to draw your own district lines. The obstacle, of course, to the federal legislation is, given the status of the filibuster, which is still in place, you would need to secure 60 votes in the Senate to pass the act to establish redistricting commissions. And it seems unlikely right now that 10 Republicans will join in an effort to pass that act to take away the powers. And I'm not altogether certain that all the Democrats will join either. right? Because of the incumbency advantage that's associated with the drawing of district lines. And I'm talking about the House of Representatives. I still think that the margins are big enough in the House to secure passage of this act again in this new Congress. But it's a question of whether you can overcome that very large obstacle, which is the filibuster in the Senate, to get it passed. But I think that that could be an important push in the right direction.
And I'll add to that also that, you know, there is one option in some states, I mean, really all states, but particularly states that have certain clauses in their constitution that go a little bit further than the US Constitution in terms of voting rights. There is the option of potentially challenging partisan gerrymandering as unconstitutional under the state constitution. And that effort was actually successful in Pennsylvania a few years ago. The Pennsylvania Supreme Court found that partisan gerrymandering violates the Pennsylvania Constitution. Interestingly, I don't want to leave people on a depressing note, but I think an interesting thing to know on that front is that there is now an attempt in Pennsylvania to, I would say, essentially gerrymander the Supreme Court in Pennsylvania. So turn it into a Supreme Court in which the justices on the court actually represent regions of the state, opening it up to potential, you know, shenanigans in terms of how you draw the lines, delineating those regions. And I think it's not surprising that that's the reaction to that, as an attempt to try to politicize even the court. But for the time being, at least, there is the option of state court litigation in those states where you don't have the referendum process to try to get an independent commission. I see Professor Howman has his hand up.
Hi, Gowrie. Thank you for organizing this, and thank you to the speakers. I'm always concerned about this idea of an independent commission to draw the lines, because it seems like that is something that the Republicans are certainly willing to support in those states where they can't gain a majority in the legislature. So they want it taken out of the legislature's hands, so they can't, a Democratic controlled legislature cannot gerrymander in the way that a Republican controlled legislature can do it in other states. So I appreciate that if this were nationwide, then there would be an even playing field. But I worry about us all thinking that this is going to be a solution when it's going to be done in Virginia now that the Democrats control the legislature. They're going to do it in Michigan now that there's sort of a growing Democratic trend in that state. So I worry about that. And I wonder if any of the speakers would want to comment on that.
Yeah, there is that concern about, for lack of a better phrase, unilateral disarmament, in the sense that, you know, you take one of the tools out of your pocket for purposes of advancing fairness, and ultimately you get hit hard by the fact that in all those states in which Republicans control, they can district, and in the states that Democrats control, they cannot. It's been left to redistricting commission. So you only have partial fairness, and partial fairness may be worse than the status quo in a weird sort of way, because you can at least perhaps achieve some semblance of partisan balance if state legislatures draw district lines in all the states, whereas if state legislators only draw district lines in Republican states and not in Democratic states, then you're going to have perhaps the worst form of partisan imbalance that you can imagine. And so, yeah, that is a worry. And there's actually that pushback against the Virginia Redistricting Commission from, you know, even progressives, because they saw a few decades in which Republicans controlled the state legislature and drew district lines in a very gerrymandered way. And this was their chance, in a sense, to pay that back. But the Redistricting Commission is ultimately going to have more power over district lines. And so I do think that the national option, for the reasons that you state, Professor Heilman, with respect to drawing district lines, is the best solution going forward.
I don't see any other hands up, but I really wanted to ask a question of our panelists, which is, I wanted to hear from Chris a little bit more about what did you think the impact on voters was of the lawsuit that the state brought against you, the Attorney General and the Secretary of State, to try to prevent curbside voting. I remember in the days running up to the election, it seems like it was the top headline everywhere that, oh my God, they might throw out hundreds of thousands of curbside votes that have already been cast in Harris County. Do you feel that even though that litigation was ultimately unsuccessful, and your interpretation of the law that permitted for curbside voting was upheld, do you feel that the impact on voters in terms of intimidation or just fear was significant?
I think that it cut both ways, but in all honesty, I believe that the massive amount of media attention that was being paid to this, sort of falsely created controversy ultimately increased the number of people who cast their ballots. Now, whether or not they voted through a drive-through, that's a different question. But what we saw was so many folks who, may have been on the margins, the folks who might have stayed home in 2016, who were just infuriated by numerous attempts by their governor, by their attorney general, by other folks who they thought they had entrusted to protect their interests, who were actively trying to take away their right to vote. And so we had many who were coming out in anger, and these weren't just Democrats. These were Republicans who I would talk to in person or who would send me an email, who were just infuriated at the fact that, in a county that's larger than the size of Rhode Island in terms of like actual footprint, that they might have to drive upwards of an hour both ways to drop off a mail ballot in person because the governor had shut down, the sites that we had around the county. That, they had, people who had voted already through drive-through, and they had done so because, we had examples of folks who, had their kids in the car and wouldn't want to take 3 young children into a voting center. Folks who had their animals in the car. Folks who, we had a veteran who was suffering from PTSD, and other folks who had, anxiety issues, who voted in this way because it was sort of, private, didn't expose them to a bunch of other people. And then, of course, plenty of people who, because of COVID-19, thought it was a safer way to vote, who were just so, again, infuriated, upset that this type of challenge, could even take place. And so the only place where I could say with certainty that it may have kept some people from voting in a certain way was on election day itself. That was the day after we got the verdict that supported us, but the judge had, in giving us that verdict, also talked about some of the distinctions between early voting law and election day law in Texas, which is absurd that there's a difference to begin with, but there is. And so because of that, we decided to limit the number of drive-through voting sites that were available on election day. And so that was, accessible by fewer people on election day, unfortunately. But we did that because we wanted to give every voter who voted the certainty that their vote would count, and not subject them to any further confusion.
That's interesting. Let's hope that these sort of attempts to restrict voting access that are popping up in some of the state legislatures, let's hope it pisses people off in the same way again, and people continue to do what it takes to exercise their rights. I think we have another question from Alejandro.
Yeah, sorry, I have another one. Kind of following in that, but in that light, we saw a lot of states across the country, even states that are, traditionally conservative, expand the way that people could vote. States that, states that already had mail-in voting allowed people to vote with no excuse, and expanded the days of early voting and things like that. Are we expecting any sort of backlash or swing the other way in future elections, especially now that there's been so many accusations of voter fraud and particularly in places like Georgia and Pennsylvania and Michigan? Is that on the horizon and something that we should be on the lookout and watching for?
So go ahead, Chris.
Go for it.
So I was just going to say, and I'm more than happy to drop a link in the chat, but there definitely is evidence that there is a blowback. The Brennan Center puts together a compository of state laws to expand access and restrict access. And a significant amount of bills have been introduced. In Georgia, for example, there are a slew of bills that would make it harder to, I believe, to vote by mail. Also to get rid of automatic voter registration. And so while that, is upsetting, there also have just been a significant amount of bills that have been introduced that would expand access to voting. And so, there's just gonna need to be a ton of work at the state level to try to fight back against those restrictive laws. But, lawmakers have recognized that people generally do prefer making voting easier and an expansive democracy. So I'll turn it over to Chris and I'll find that link.
Yeah, I would say that this cuts both ways. You're already seeing efforts, certainly here in Texas at the legislative level, to potentially try and make voting more difficult. The new committee chairs in our state legislature were just named yesterday or the day before, and the committee chair of the elections committee in the state house in Texas is a lawyer who was on the Trump legal team looking to throw out millions of votes after November 3rd. So that there sort of tells you the signal that they're sending. In Georgia, I know that there is a law that they're attempting to pass. I don't think it has a high chance of success. That would require you, if you were to try to vote by mail, to send in a photocopy of your driver's license multiple times to the election administrator for that to be verified. And again, just trying to put hurdle after hurdle in the way of voters who simply want to have their voices heard. And so we have to be vigilant. We have to be on guard. But, I think what we're seeing overall is a slight, not a huge, but a slight awakening to some of these issues, even to folks who consider themselves to be perhaps like moderate conservatives, who find this stuff to be ridiculous and ultimately want people to be able to cast their ballots. And so I'm hoping that sentiment carries a lot further.
Thank you. And I would know, actually, because I did a lot of my advocacy in the run up to this election in Georgia. I do think Chris is right that, there are a number of, moderate conservatives who still believe in rule of law and still believe in upholding the right to vote. They may not be party leaders, but they do hold some sway. In the weeks before the runoff elections in Georgia, there was actually a Republican-appointed County Board of Elections member in Gwinnett County, which is one of the suburban counties in Metro Atlanta. It's the kind of county that used to be pretty solidly Republican and has been changing in the past decade, and voted pretty overwhelmingly for Democratic candidates in these last elections. That Republican-appointed member was calling for reducing Dropbox access after the November election, presumably because she was under pressure from her party members because all the Dropbox access that they provided obviously helped people vote and helped people of color vote in Gwinnett County. A few kind of grouchy comments from me and other local partners in the state at that meeting. And by the next week, she was saying, never mind, I withdraw my motion. I'm not going to do it because even some of the, I think, moderate members of her community were kind of appalled that she would try to just make it harder for people to vote using a system that they had just used and really liked, right? So I don't see any more hands up, and I think we're done with time also, right? There's gonna be a break before our closing keynote. So thank you everyone so much. Is there anything else, Alejandro or Abe, that you need to say before we go to the break?
No, Professor, I just wanted to say thank you to you and thank you to our amazing panelists again. I loved listening to this panel, and I know that you all have been working very hard over the last several months, so we appreciate you taking the time to speak with us today. As Professor Ramachandran said, we will be taking a short break. We will be returning for the closing address at 5 p.m. Pacific time.
Bye, everyone, and good to see everyone.
Thank you, Abe, and thank you everyone for being here, and what a great day and what an important topic. So I'm glad you've stayed till the very end here to hear our closing speaker. It's really my pleasure to introduce our final speaker today, our newest county supervisor, Supervisor Holly Mitchell. Supervisor Mitchell grew up here in Los Angeles in Leimert Park. She went to the University of California at Riverside. She then worked with Crystal Stairs. That's an organization dedicated to child and family development. She also was a lobbyist for the Western Center on Law and Poverty. That experience helped her get elected to the State Assembly, where she served for 3 years. She then went on to the State Senate, served for 7 years in the State Senate. While in the legislature, she had an incredible record. She worked to pass 90 bills in the legislature, including the California Crown Act, which banned discrimination based on natural hairstyle. In my experience in local government, and I've had a lot, you get to meet a lot of local elected officials, state officials, and national officials, and you really begin to discover who's the real deal. And Supervisor Holly Mitchell is the real deal. She's there to do the people's business, to make the community better, and to make the state better. She represents parts of Los Angeles, parts that include downtown, include where we're at here at Southwestern, Koreatown, Venice. She also represents Carson, Compton, Culver City, Hawthorne, Inglewood. In all, she represents more than 2 million people in the county of Los Angeles, which actually makes her represent more than 28 US senators. She is incredibly busy. We have so many challenges happening right now in the county. And I'm so pleased that she has been able to carve out a little bit of time today to be our final and closing speaker. It's my pleasure and my honor to introduce our final speaker. Please join me in welcoming our supervisor, Supervisor Holly Mitchell.
So good afternoon. I think my ear pods have probably have had a day as long as yours have, and they're like, we're dead. Don't even try it, lady. Thank you very much, Professor Heilman, for such a generous introduction. I appreciate you. You all have had a very full day. I see you got started at 8:30 a.m. with Congressman Schiff. I'm sure that was very exciting. How timely, given the role he's playing on the national platform. And you've had a full meaty day. So I realize that I am the only thing keeping you perhaps from your Friday happy hour cocktail and beginning your weekend. I appreciate the invitation, and you're going to appreciate me even more because unlike many of my colleagues in elected office, I know when to hold them and when to fold them, and I will keep my remarks relatively brief. Although what you've been discussing all day today is, I believe, you know, the cumulatively kind of the civil rights issue of our generation. And so I'm really proud that you've asked me to join you and give you your final remarks for a very full day. So again, I want to thank Southwestern Law School for inviting me. I wish you all a grand journey on your future in the legal profession. So as we close today's symposium entitled Widening the Lens of Justice, Unmasking the Many Layers of Racial and Social Inequity, I want to shed a little light on the impact local government and the community wins we've had here in LA in advancing the larger movement for justice and against injustice. You know, right now here in Los Angeles County and throughout the nation, we're continuing to experience what I have begun to acknowledge is a dual pandemic, a public health pandemic, an economic pandemic that has elevated for many what structural racism looks like and feels like, in that this virus has disproportionately impacted the lives of the underrepresented, poor people and people of color. For example, as we talk about structural racism here in LA County's justice system, African Americans and Latinos comprise 74% of arrests. And despite the fact that Black folks are only 9% of LA County's residents, our population, we comprise 29% of the county's jail population. Racial disparity on Front Street. Currently, communities of color are experiencing higher incidence of the virus, higher incidence of hospitalization, and dominate the deaths we're experiencing here in LA County. You know, our case rate disparities are double for poor people and people of color. And so while today's LA Times says LA's infection rate plummets, please don't be confused by that. That isn't equally shared across all of LA County and every community and every racial group or socioeconomic group. And these numbers are tragically similar all across this country. So it's clear to me that we're facing a tipping point, quite frankly, particularly with regard to restorative justice. And we didn't just get here. The calls for action that we're hearing today echo from throughout the course of history, back to the abolitionist movement, the civil rights era, the uprisings that I've experienced here as a Native Angelino, from the Watts uprising in '65 to the '92 unrest, to some of the more recent examples of protest, thanks to the organizing, the international organizing around Black Lives Matter. And, you know, the collective scream or sigh based on our all witnessing Mr. George Floyd's murder. And of course, there are countless others of men and women of color here in LA County and across the country who have died unfairly, inappropriately, and unjustly. So what are we going to do at this moment in history to meet this moment for justice? Well, I believe we've got to start with leading by example and committing to ending our own policies that continue to perpetrate systemic racism. And LA County, as local government, is not exempt. This past summer, before I joined the Board of Supervisors, I was very proud that they passed for the first time ever an anti-racist policy agenda to guide and increase the county's ongoing commitment to fighting systemic racism. Why is that important? You know, the county of LA, 10 million people. If we were a state, LA County would be the 10th largest state. And so for an entity this size, 112,000 employees, $36 billion budget, 33 county departments, an entity of this size to pause and do our own internal work to figure out what we must do as an employer, as government, to address and fight systemic racism is really a big deal. And I'm proud to be a part of that ongoing dialogue and solution. This historic and unanimously approved initiative by the board makes a bold statement about the type of LA County we want to be, what the kind of LA County we all want to live in, and forces the largest county in the nation to confront structural racism and its consequences head on. This moment also demands accountability. We cannot have public safety without public trust. The power of community organizing is crucial in advancing justice. That was evident in the work that was done by a coalition of activists to seek subpoena power for the LA County Civilian Oversight Commission. It was CHAR who's been charged with holding our Sheriff's Department accountable. Their advocacy work and demands for oversight and accountability inspired a state law that I was proud to co-author and present on the Senate floor before I left the state legislature. That was AB 1185, which ensures that all oversight bodies in the state of California have subpoena power. We wanted to give these civilian oversight committees the tools they needed to do an effective job to really hold law enforcement accountable, which is really what the general public expects of them. And lastly, I'll say that once we are willing to address the source of systemic racism and be accountable to our communities, we've got to go further and be brave enough to create new solutions that break away from old, unjust systems. LA County is making remarkable efforts to transform the county's justice system into a rehabilitative model based on what we're calling Care First, Jails Last, really as a vision and action statement. This model prioritizes investments in alternatives to incarceration, prevention, and community-based solutions. These are just a few examples of how local government is partnering with the community to take necessary proactive action. This work requires an investment from all of us and a sustained commitment to being part of the solution, not just complain about it or contribute to the problem. I know you're all here because you fundamentally believe in your own power to create change, or you wouldn't have spent your entire Friday having these important policy conversations. And I know that and fully expect and hope that many of you will go on to advance policy in the political arena yourselves, or in the judicial arena in terms of setting policy through the court system. Regardless of what sector you're applying your talent, know that you can take action and make a difference from whatever platform you have access to, and that our collective wins are how we ultimately create a more just and equitable society. Because if you don't take the leadership reins to make that happen, who will? I appreciate your time and commitment and the effort you put into having these really tough human public policy conversations today. I appreciate you inviting me to spend a little time with you to close out your session. I ask that you all stay safe during this public health pandemic, and I thank you.
Thank you so much for those inspiring remarks. And we certainly hope that when the pandemic is over, that we can host you on campus and that you can tour our facilities and that you can share your experience and wisdom with all of us. I know we have some time for some questions, and I'd like to kick it off. You mentioned law enforcement, and certainly before you joined the supervisors were having their battles with the LA County Sheriff. And that's going to be, appears an ongoing challenge that the supervisors are going to have, because it appears that the board and the sheriff are not necessarily on the same page in terms of the reforms that need to occur. Do you want to share your thoughts on how we can move forward with reforms with law enforcement in the county?
I appreciate that question. And that's been a very interesting kind of climate in which to join the Board of Supervisors. As I said, I was very active, co-authored the bill to really try to give teeth to the Civilian Oversight Commission. And I've met with the sheriff, quite frankly, as I'm supposed to. I've met with maybe a little over half now of the county department heads, but I had an early meeting with the sheriff because we needed to look eye to eye via Zoom and have a conversation about, you know, from his perspective, what I needed to know about the work he does in my community, and he needed to hear from my perspective, my feelings of what I'm hearing from constituents about their experience with his department. You know, it doesn't help him when the Attorney General of the state opens a case reviewing the behavior of an entire department. It does not help him. And so before I got here, the Board of Supervisors voted to ask County Council to provide them with information about what we could do, quite frankly, to unseat the sheriff. This gets very dicey. He is a duly elected county-wide official. There are some counties that have statute that allow them under certain circumstances to remove, if you will, a sitting elected. LA County doesn't have that. And so we got a report back from County Council that listed all of our options. And it's going to be interesting as we go forward to really see what the political will be of my colleagues on the board. I am continuing to hear daily, Professor, from constituents who are clear that they are over-policed, who have lost confidence in the sheriff's department, who are reading every day about gangs and illicit and inappropriate behavior within a law enforcement entity. And so I'm going to continue to hear from constituents. I'm going to continue to raise those issues. I am going to continue to work very closely with the State Attorney General's office to monitor their investigation. And, you know, as a representative of the 2 million people who elected me, I'm going to have to step in and step up to talk about the demands of the community of this individual who's leading this department. There are movements afoot, and I'm meeting with groups next week who are talking about a recall effort. He is up for re-election in 2 years. And I think it's a problem when any policymaker, any elected official turns a deaf ear to the throngs of people who are expressing viable, valid concern about your leadership or lack thereof. The fact that he refuses to follow the letter of the law in terms of empowering the Inspector General to have access to investigations in real time. It's just he's thumbing his nose, it feels, at all of us who are concerned about the direction he is leading his department in. I know that there are good men and women of the force. We encounter them on the regular basis. We're talking about leadership from the top and the impact that has on influencing an organization as a whole.
Well, that's great to hear. And I know that it is a dicey situation because he is duly elected. And it's even some of his supporters, people who supported him and endorsed him, who are concerned about the direction he's leading the department in. I wanted to just go back to today's topic, widening the lens. And certainly your Crown Act was part of widening the lens and how we think about racial equality and justice. There are a lot of people who never thought about that as an issue that needed attention. And once you led the effort to get that bill passed, we've seen other states replicate it and copy it. So that's really been a cutting edge issue. Tell us a little bit, because I'm sure there are people here who are not familiar with it. Tell us a little bit about the experience of drafting that and adopting it. And then are there other issues like that that you might be championing, things that we may not think about as a racial justice issue?
I appreciate that. You might not be able to tell by my top notch and Zoom cutting me off because I'm so tall, but I wear my hair natural. I've been locked. I wear my hair locked. I've been locked the entire time that I've been in public office. I've been locked now, I think 17 or 18 years. And I began to get letters from young girls in school who were either being sent home because their hair was a violation of school dress code because they wore it in braids or twists, or their hair was locked like mine. And I just kind of began this kind of my little personal private process where I would send them my official Senate picture where I'm in a suit, the American flag, the California flag behind me, and I'm in locks and with my locks to say that, you know, I am a Black woman, the only Black woman serving in the California State Senate. And people elected me and continue to re-elect me for what's inside my head, not how I choose to wear my hair. And, you know, I thought back to my time in high school. I'm a product of the 80s. It was hip. We were wearing elaborate braids and beadwork in the 80s. And I began to think that if I hadn't been allowed to experiment and experience my own cultural pride and sense of self-identification in those years, how would that have impacted me as an adult, as a grown woman, in terms of my own confidence? Fast forward, I was at a conference. Dove did a survey of Black women about your hair, and the results were astonishing. The number of women who said no based on workplace dress code, what was deemed professional and acceptable. We heard again from parents about these school-based policies. They didn't feel they could wear their hair in its natural state. I want to emphasize that. And then that November, we all saw the young man, the wrestler from New Jersey, who it went viral, who had his hair viciously cut off on the wrestling mat in the middle of a wrestling match. And we began to really look deeply at this and recognize that Black women or men were the only group of people who were told that your natural hair was unacceptable in school or the workplace. Parents sent me these letters, these suspension letters, and they literally said, your hair is a distraction to others. It wasn't about, it was, you know, dangerous, none of that. It was a distraction to others. So we began to look deeply in the law. I remember back in the 80s when women, Black women in two of the more conservative industries, the airline industry and banking, were not allowed to wear braids. And we decided to really impact the letter of the law by acknowledging the fact that natural hair, the way my hair grows as a Black woman, is a race-based trait. And there are other traits protected under how the Fair Housing and Employment Act, gender, age, sexual orientation, race. So we added natural hair to that list, that protected class. So no longer can I not be hired, not be promoted. No longer can employers write dress codes that limit my ability to wear my hair in its natural state. And because of the natural way, the way my hair grows naturally, the texture, I can wear these protected styles, twists, locks, or braids. I think it was important for me as a woman, a policymaker who wears her hair natural, to be able to educate my fellow policymakers about this issue. Was very proud that Governor Newsom signed it, and we were the first state of now 7 or 8. It's been introduced in Congress, and we fully expect now that the Senate will address it as well. It is an issue of race, and that people are being locked out of employment opportunity because of the natural way their hair grows. It's fundamental.
Great, thank you for sharing your experience and the experience of what motivated you to take this action. We do have time for some questions. I see Angel has her hand up. Angel?
And Angel, somebody has been ringing my doorbell. Angel asked her a question as I grab my door. This is what happens when you're doing a speech at home at Zoom. So go ahead and ask your question.
No, don't even worry about it. You got it. Hey, Professor Hellman, how are you?
Hi, how are you?
Good, nice to see you.
Nice to see you as well.
I love the picture she has in the background. So nice.
Okay, let me put this right here.
Did you send it?
Angel, I'll be right there with your question.
Okay, thank you. I appreciate it. What'd you say, Professor?
I said, go ahead, ask your question. I think she can hear.
Oh, okay. So my question is basically, well, first I wanted to thank her for taking the time and for sharing. And secondly, I just wanted to agree with a lot of her contentions about the importance, about the connection of hair and hair typing and the connection of it to race. As you can see, I'm a natural girl too. And I feel like it's really important. I came from an African household. And so a lot of our values when we're coming here to this country and trying to assimilate to achieving the American dream is to sort of fit into the confirmation of whiteness. And so a lot of it is reclaiming and unlearning and finding a way that you can fit in these professional spaces while still owning your individuality and owning your culture and owning your woman, as I like to call it. So I appreciate you so much for sharing and think it's really important work that you're doing.
I appreciate you. Thank you. I have to tell you, I was proud to be in a position to elevate an issue that, some said, oh, and the haters out there in social media, ooh-wee, LA, California, you need to be worried about homeless. What do you care about hair? So I had to, fire back. Excuse me, I'm not a one bill pony. I, check my record. I have done work on homelessness. I did carry the bill in California, the first in the nation to create parity in sentencing between crack and powder cocaine. The 90 bills that are not Mitchell bills that are now law are not, chopped liver. This too is a critical issue as we talk about discrimination. That there was one group of people who could be told that their hair was unprofessional. As I stood on the Senate floor and in committee and said repeatedly, not one of my colleagues ever didn't vote on a Mitchell bill or didn't vote on a Mitchell budget. I chaired the Senate Budget Committee for 4 years because of how I choose to wear my hair. It had no bearing on the number of Mitchell bills that were introduced that were signed into law, or it had no bearing on my capacity to be an effective legislator. Why would we send girls, Black girls, home from school or not promote or hire people because of the way we choose to wear our hair? And we're the only group of people that appear to be impacted by, and it was unacceptable. So I was proud to be in a position to use my own life experience, to use it as an opportunity to educate my colleagues who may not have understood. I had a colleague that asked me about, well, what's a conch? I mean, sometimes when you're in the room, it creates opportunity for conversation. People who may not have ever understood the difference in hair texture. And I use it as an educational opportunity and an opportunity to change the law. And I'm very proud to have been in a position to do so. So thank you for your comment, Angel.
Thank you for your time and your presence. I appreciate you, and I hope you have a great weekend.
Thank you. You too.
I think we have time for one last question, and I see Professor Hart has her hand up. Danny.
Thank you, John. Really appreciate it. And thank you, Supervisor Mitchell, for joining us and taking the time out of your day to do our closing remarks, because they were really, really wonderful. I have a question for you, just based on your background, because you're saying you're a native Angelino. I am not, but you've been here. You said you went through the Watts riots, the early 90s unrest, and I guess I'm just wondering, in your own opinion, your own personal experiences and everything, is this moment really different? As a result of the Black Lives Matter movement, all of the marches, and we now have Black Lives Plaza. Is this moment really different? Does it feel different to you? If so, how can it be capitalized on? What are you feeling about this?
I so appreciate the question. In the 92 uprising, I went back and read the McCone Commission report that was written after the 65 uprising, and realized if we had done everything they recommended we do, we wouldn't have been in the position to have the 92 uprising. I also had to acknowledge the structural changes that happened as a result of Watts. As a result of Watts, we have Martin Luther King Community Hospital. We have Cal State Dominguez Hills. What the community came together and said, we have no resources. We have no health care infrastructure. We have no college. And so these major institutions were born out of that. St. John's Community clinics, a series of community clinics that are saving us now because they are the clinics that are doing the testing and vaccine distribution throughout South LA. Kedron Community Mental Health Clinic. There were institutions that were born out of the Watts Uprising. You know, there's famous front page LA Times stories when, you know, the Times has acknowledged the fact that they had no Black reporters. LAPD, you know, Tom Bradley, you know, owes the uprising for his career, quite frankly, with LAPD. There were no Black police officers with LAPD. And so there was some structural change that happened for LA. We didn't go far enough. Here comes 1992, where we look at ongoing police brutality. And here we are now in 2021, where we're experiencing the same thing. There have been so many documentaries, and I can't remember the last one I watched, but it showed footage from 65. And this man looks directly at the camera and says, what we are sick and tired of as a people. And my 20-year-old looked at me and he said, that could be right now. If it weren't black and white footage, I would assume that was today. And so while we've had gains, we still have so far to go. I believe what will make a difference in this movement rests on us. That all of the research, all of the commissions that will opine about how we got to this place where a man could look in a camera and put his knee on the neck of another human being and feel him expire underneath him. We have to decide that that's no longer acceptable and continue to keep the pressure on until it's not. We have to decide that it's not just a matter of building a hospital and health clinics and a school for a segment of the community. We were all impacted on a cellular level based on the inhumanity we bore witness to. And until we all understand that that impacts us, whatever, regardless of the color of your skin, although it does disproportionately impact people of my hue, it won't change. So I am hoping that with the Watts Uprising experience, the 92 experience, the Black Lives Matter experience, that we will finally get it right and really continue the conversation about structural, systemic change that we all have to do. I carried a bill in the legislature a couple of years ago, attempting to address the issue, the disproportionate number of Black women who die as a result of childbirth. We've spent more time talking about Black infant mortality, but Black maternal morbidity in California, in this country, are at offensive levels across the socioeconomic spectrum. You've heard you've heard Serena Williams' story. You've heard Beyonce's story. You've heard the widow of the physician at Cedars. These Black women who've died in childbirth. And we looked at the painful to me research that shows Black OBGYNs who assume that my threshold for pain is different than my white female counterparts, that my skin is more difficult to penetrate in order to give me a saddle block. All of these amazing, inaccurate assumptions about treating Black women, how we are not listened to when we are telling them there's something wrong, I don't feel right, and assumptions are made. So the bill I carried talked about implicit bias and how everyone who's involved in the delivery process has to go through implicit bias training. We have to get in touch with our own perceptions and misperceptions about Black people and people who are different from us before we can begin to kind of self-correct as a society and in terms of government structures across the board. So do I sense a difference this go round? I do. However, it's going to depend on all of us, not just me. And it's got to live well beyond when the cameras go away and the hyper focus goes away and whether Black Lives Matter gets the Nobel Peace Prize or not, when all of that goes away, and how we change our own language, our own behaviors, and the organizations that kind of grow and evolve as a result of us.
Wow, what a great way to end today with that not only historical overview, but really an inspiration to all of us to continue in this fight, to continue widening the lens of racial justice. Thank you for the shout out to our graduate, Mayor Tom Bradley. But thank you also for the incredible work you're doing and for being with us today. We know that you have incredible challenges in the county, COVID, the economic situation, transportation, affordable housing, law enforcement, and all of these intersect, of course, with the fight
Houseless
for racial.
residents, can't leave that out. Our houseless residents, yes.
Yes, yes. And but hopefully with a new administration that has a focus on urban issues and with issues of equal opportunity and justice, we'll have some resources as well to address some of these issues. We certainly wish you a great deal of success. We know you're going to be a great supervisor here for us. We look forward to welcoming you onto our campus. Please join me, everyone, in thanking our incredible supervisor, Holly Mitchell. Thank you so much, and we appreciate you.
Thank you very much. I appreciate the invitation, and I appreciate you allowing me to close out your session today. It was indeed my honor. Thank you.
Thank you. I'm going to turn it over to Erica Jensen, who's going to give us our final marching orders and wrap up today's conference. Thank you again, Supervisor.
Thank you so much, Supervisor Mitchell. What an incredible day. Thank you all for joining us. We really hope you enjoyed the program. Please keep your eye out for the 3rd issue of the 50th volume of the Law Review, which will be published later this summer. It will contain the remarks made by Congressman Schiff, Vice Dean Fernita Tolson, and Supervisor Holly Mitchell. It will also showcase articles from some of the panelists today: Natalia Ospino, Dr. Kenya Covington, Professor Bertrand Ross, and Professor Ken Williams. We are about to close out this program, but I just want to say that the purpose of the symposium really was to confront these systemic injustices within our past and our present, but also to outline how we carve out a better future. And thank you to the speakers and the moderators who helped us achieve that goal and engage us in such a meaningful dialogue and inspire us. So also thank you to all who made today possible. And on behalf of the Law Review, please have a good night and stay safe and well. Thank you.